serial number 58. Huh? 58. 58. ಕಾಮರಾಜು
The press matter. Press matter.
Lord, the writ petition 2246, my lord. In this stay had granted, my lord. Stay was granted. Though
So
say
giving a memo,
my lord.
fresh matters, bringing a matters, you can
My
discuss.
lord, though the memo is the day-to-day basis ಅಲ್ಲಿ case ಹಾಕೋತಿದ್ದಾರೆ trial court ಅಲ್ಲಿ.
Huh?
Case ಹಾಕೋತಿದ್ದಾರೆ. So
What do you want?
impugned order is stayed, my lord. Still the case is being called in the trial court on day-to-day basis. But kindly have it tomorrow.
Only fresh matters, preliminary matters, you can please.
Lord, may I make a mention in respect of a writ filed in July? This honorable court, my lord, had remarked that after service of notice, it would hear it in preliminary hearing itself, because the matter is covered by Supreme Court judgments. And also the urgency is that it's a commercial suit matter. So my lord, my petition will become infructuous. It pertains, my lord, to the question of whether unregistered lease deeds can be marked in evidence. Now the evidence stage is over. It's for arguments. It'll become infructuous if your lordship doesn't hear it. Any date, my lord, next week or the week after.
Please give a memo.
Please.
Yes.
Lordship, fresh matter, my lords.
What do you? Please give.
Kindly have
Fresh matters, preliminary matters, you can please give. Old matters, any urgency, you'll have to file application for early hearing. Otherwise, it won't come. Yes.
Serial number 58 for withdrawal of 58.
8.
I was ready. I am appearing for petition.
Learned Counsel for petitioner has filed a memo dated 11/9/2024. Seeking leave of this court to withdraw the writ petition. Full stop. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition shall be dismissed as withdrawn. Yes.
Adjournments and other said to be present. List number 1.
Page number 3, serial number 19.
Hmm?
Page number 3, serial number 19.
Hmm.
1 week.
Adjournments only if the other side is here and says no objection. Otherwise, no adjournment. Yes.
List number 1. Pronouncement of orders. Serial number 1. KG Bhavana.
The petition.
The writ petition is allowed. The impugned order dated 7/3/2019, allowing IA number 29 of 29 in OS number so and so is quashed and set aside. IA 29 is accordingly dismissed. Impugned order dated 15/2/2019, allowing IA number 32 in OS number so and so is quashed and set aside. IA 32 is also dismissed. Ordered accordingly.
Preliminary serial number 2, Raja L.
This case appear for the petitioner. Petitioner is the dependent before the trial court Myla. The plaintiff filed the application order 6 rule 17 to before the trial court. The trial court allow the application is annexure G page number 45 impugned.
2018 suit.
Suit
Suit for?
partition and separate position.
Ah,
Subsequently, earlier, the plaintiff filed the same IA for amendment of the Order 6 Rule 17.
Hmm.
That application is withdraw. Again, once again, he filed the application,
to amend the survey number.
survey number. Survey number, earlier, ಆಕೆ ಅದನ್ನ withdraw ಮಾಡ್ಕೊಬಿಟ್ರು.
ಆಯ್ತು.
Withdraw ಮಾಡ್ಕೊಂಡ್ ತಿರ್ಗ again, posted for cross examination ಹೋದಾಗ
ಆಗ್ಲಿ.
application ಹಾಕಿದ್ದಾರೆ.
ಹಾ.
In the year 2000.
Only correcting the survey number as it's a typographical error.
In 2018 ಅಲ್ಲಿ ಆಗಿ 2023 ನಲ್ಲಿ ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು ಹಂಗ
Issue notice to the respondent.
ಸ್ಟೇ ಫರ್ದರ್.
Serial number 3,
I appear for the caveat or respondents, my lords.
Sri Prakash.
For the petition.
I seek for a short accommodation.
My lord.
I seek for a short accommodation, my lords. Some inconvenience today.
My lord.
Any urgency?
Tuesday it may be taken up.
Only thing is my interim order I sought, not to alienate the suit property during pendency of the suit. That application has been rejected. When first applied court also
Yes.
rejected.
Suit for?
Suit for partition, my lord.
Partition.
Partition.
What is the difficulty?
My lord, senior, there's some inconvenience today, my lord. It may be taken up on Tuesday, my lords.
If they undertake, my lord, they could be.
My lords, they fire, the order,
Really, at the request of learned counsel for the respondent. Caveator, release this matter on 17th of September 2024.
much
Full
honor.
stop. In the meanwhile, parties are directed to maintain
My-
status quo
my
with
lords-
respect of the suit.
My lords, if that is the case, then it may be passed over, my lord. I'll at least address my arguments.
Yes,
Serial number 4, Mohammed Tahir. Withdrawn.
learned counsel for petitioner has filed a memo dated 9/9/2024. Seeking leave to withdraw the writ petition and file a fresh petition on the same cause of action, but raising proper grounds. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn while reserving liberty to the petitioner as prayed for.
5, B. Sharat Kumar.
Please, note, in this case, I pay for the petitioner. Decree orders, judgment letters, petition, please. note. What has happened is, a suit for their injunction was filed. Suit came to be dismissed. Against it, a RA was filed. RA, it was allowed, that is, the injunction was granted in favor of the plaintiff. Against that, a RSA was filed. The RSA, please note, it was admitted and substantial question of law was framed.
Hmm.
After the filing of the admission of the RFA, they have filed now an execution petition based on the RA. We felt that the execution petition is not maintainable since the RSA is pending. And we have also produced order copy and substantial question of law framed before the trial court. But the trial court holds that there is no order.
Seek any order of stay before the.
When we
Wednesday.
argued the matter was admitted, substantial question of law was framed.
It's all right.
And,
Could have asked for stay.
we could have asked for
Then
second. Now, as the matter is pending, but the trial court holds that the matter is admitted and, but there is no stay order granted. And rejected my application.
issue notice to
Because,
the respondent. The petitioner is also permitted to serve copy of
The petition.
the petition on the learned counsel representing the respondent before the
Trial court, trial court.
Executing court. Full stop. Next para. Learned counsel for the petitioner submits that although the trial court dismissed the suit filed by the respondent seeking permanent injunction, nevertheless, the regular appellate court allowed the suit. Full stop. The petitioner has questioned the same before this court in RSA
365 of 21.
365 of 2021. Full stop. The regular second appeal has been admitted. Full stop. In the meanwhile, the respondent has filed an execution case seeking to execute the orders passed by the regular appellate court. Full stop. When a pointed question was put to the learned counsel for petitioner as to why an interim order of stay was not sought at the ends of this court in the regular second appeal, learned counsel submits that the petitioner will file necessary application.
It's already, after hearing both the sides, the matter was admitted.
So what?
Please, Mr.
You can still ask for stay of the
Please. It's already there, please. The application is there.
ಹಾಕಿದ್ದೀರಾ?
ಆಗ್ಲೇ ಅಪೀಲ್ ಅಡ್ಮಿಷನ್ ಆವಾಗಲೇ ಹಾಕಿದೆ ಬಟ್
ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ವಿ
It was not pressed.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿ ಅಡ್ಮಿಟ್ ಆಯ್ತಲ್ಲ ಅಂತ ವಿ ಕೆಪ್ಟ್ ಕ್ವೈಟ್.
Submits that such an application has already been filed, but orders were not pressed for since the matter was admitted. Full stop. Next para. There shall be an ad interim order of stay for all further proceedings in execution case number 20 of 2021 on the file of the additional civil judge Chamarajnagara till the next date, only for the purpose of enabling the petitioner to seek necessary orders at the hands of this court in the pending regular second appeal. Yes.
Lords,
Serial number 6.
my lords, apologies, my
Take
lords.
one
Serial number 3, my lords. I request for a pass over, my lords, because I may be heard at least, my lord.
Yes.
Serial number 6, Vijay Kumar K.
You heard on Tuesday.
Petitioner, my lord, filed
Yes.
recall reopen application filed by the defendant number 10, 11 and 12 came to be rejected by the court.
Huh?
On the ground that earlier matter was posted for judgment. My lord, now the presiding officer was changed and matter has been reopened and the case itself, my lord, was set down for arguments. My application, my lord,
2006 suit.
2006 suit, yes, my lord.
Suit
Not
for?
Suit for declaration and cancellation of various sale deeds. That to 20 sale deeds, they need to cancel the cancellation of sale deeds. my lord. I am the purchaser of a portion of land in one of the portion of item of property, my lord.
You don't even say, you are the defendant.
Defendant 11 and
Yes.
12, my lord. But my application for recall and reopen to cross examination of PW1 and to lead evidence, my lord. Lord, my application rejected on the court that, my lord, we filed earlier counsel on record was not properly conducted and the subsequent counsel has filed application. But court comes to the conclusion and rejected that only on ground that now the matter is reserved for judgment. We cannot reopen the case.
Yes.
But now the circumstances changed. But that judgment, my lord, has been, the earlier presiding officer was not passed the judgment, he was transferred. Now the matter has been recalled and matter posted for arguments. And opportunity has given, my lord, we are able to cross-examine within a time-bound manner and we will, because the valuable right of the bona fide purchaser is interested. It is a suit for declaration and cancellation of sale deed and other reliefs, my lord. My lord, this suit was connected with other two suits, my lord. Therefore, in another suit, my lord, I have placed the page number 47. Plaint may kindly look at, my lord. In that suit, my lord, there are 170 defendants are there. Notice was not served to them. Some of that under those, my lord, by mistakenly we are unable to cross-examine the PW1. In that suit, my lord, matter was set down for steps. That is OS 7646 of 2008.
reasoning portion or the objections raised by the other side.
My lord,
Page number 19.
yes, my lord. The grounds urged in
Evidently,
the-
defendants number 11, 12 are on record and return statement is also filed in the year 2006 itself.
yes, my lord.
Now the parties cannot contend that wakalat is filed on 5/7/2023.
No opportunity.
No
has been-
opportunity of hearing is given.
This
In
is
spite
for,
of written statement, the parties plead that the council has not filed written statement.
in the connected matter, my lord. Not in this matter. Court, my lord, there are three suits clubbed together.
Ah.
Common evidence was some of the matters recorded. All the matters clubbed together in the court heard and
Tako, you don't have to file, you can adopt the same in the other.
but
suit.
cross-examination insofar this suit is concerned, we are not done, my lord. Because the reliefs, because I am not a party in all the suits. Some two suits I am the party, one suit I am not a party. One thing. Second thing, my lord, is now the anyhow, my lord, argument stays, my lord, if the reason, my lord, is that earlier judgment matter reserved. We are the purchaser of the property in portion of land, my lord. Our valuable rights are involved. Some strict conditions may imposed and we are ready to prosecute the suit, my lord. For cross-examination for the limited purpose of the wakalat filed by no objection from the previous council that stated the reasons in the accompanying of application.
Hmm.
That application, my lord, I have also placed it before the court.
That was filed in July 2023.
Yes, my lord.
Immediately after that, you could have sought for cross-examination.
Yes, my lord.
Then,
The earlier council not done, my lord. This is a suit for declaration cancellation
that
of,
cannot be a good grounds.
my lord, 10 sale deeds they are seeking cancellation. There are 170 defendants are there in the connected suit, my lord.
Notice to respond number 1.
Only one, my lord. Other response, I am filing memo for dispensation. They are not
Petitioners
proper.
Are also permitted to serve a copy of the writ petition along with annexures on the learned counsel representing respond number 1 before the trial court.
Memo filing
Learned
for,
counsel has also filed a memo seeking dispensation of notice to response number 2 to 11 on the ground that the said respondents are co-defendants along with the petitioners in the suit. Yes. And no relief is sought against them in the writ petition. At the risk of the petitioners, notice to response number 2 to 11 is dispensed with. Release this matter, next para. On 20th of September.
Seven. Yes,
Lord, in this case, Lord, the petitioner challenged the order dated 3/6/2024, Annexure A, page 19, Lord. Lord, the concise fact of the case, this, Lord, the plaintiff before this, the petitioner is the plaintiff before the trial court. He filed a suit for specific performance of contract to enforce an agreement of sale dated 21/1/1986. So in the agreement, there is a clause that on the total sale consideration is 4,000 with respect of this property bearing survey number 54/1 measuring 30 guntas. So on the date of execution of the agreement of the physical possession has been handed over to this plaintiff, this petitioner. Thereafter, since the defendant has not come forward to execute the sale deed, he filed the suit for declaration that specific performance. That entire sale amount has been paid, that 4,000 rupees is the sale consideration paid. He filed the suit. The trial court only on the ground that
4,000 rupees.
4,086 ಅಲ್ಲಿ ಆಗಿರಂತ 30 guntas property. This original agreement is also there.
Filed when?
Pardon, Lord?
Suit was filed when?
2012. Lord.
2012.
Well, because there was a bar for fragmentation act was there, then the property was also notified as a pada land. So after that, he filed the suit. That is not the issue, Lord. Thereafter, he filed the suit. Then the suit was tried. Lord, since the possession was there with this plaintiff, this petitioner, he has not sought for the permanent injunction. But taking the undue advantage of the suit dismissal of this petitioner's suit on 9/1/2020, the defendants, that is the respondents, were tried to interfere in my possession. For that, I filed an application under Order 6, Rule 17, seeking for permanent injunction to restrain these defendants from interfering my peaceful possession, enjoyment of the possession of the property, suit schedule property.
When did you file the application?
Lord, I
Before
filed
the-
that annexure, Lord, kindly see.
Regular appellate court.
Appellate court, Lord.
Ah,
Appellate court, Lord, kindly see annexure F, page 72, Lord. 27/1/2024, Annexure F, page 72. So I filed this application, my lord, but the first appellate court, my lord, by referring the decision of the apex court, Annexure A, page 22, my lord, kindly see. In fact, that is in favor of this petitioner only. This court has, the apex court has observed that the amendment can be allowed by imposing the reasonable cost.
Amendment.
Amendment of that Article 6 Rule 17 application can be, appellate court can also
Yes.
allow that application by imposing some reasonable cost. That is page 22, my lord, in the impugned order. The impugned order starts from page 19. The observation made by the first appellate court by referring the decision of the apex court, my lord, that is there in para 10, my lord. So by imposing reasonable cost, my lord, this relief can be sought, that whatever the relief sought, that can be allowed.
Yes.
But the trial court, the first appellate court has rejected my application on 3/6/2024, my lord.
On the ground?
On the ground that so belatedly filed the application. Because for in the agreement, my lord, there is a clear class of that possession, but this agreement is also there, my lord, here, certified copy, my lord. In that on the date of execution of the agreement of sale, the physical possession of the property has been handed over. And also, my lord, recent decision of the apex court, my lord, even the appellate court can interfere and allow this application for amendment. That is the recent decision of the apex court, my lord. Kindly see, this is the reason.
The problem is the law of limitation will apply.
Law of limitation, my lord, because for as on the, it is not in dispute that as on the date of execution of the agreement of sale, the physical possession of the property has been handed over. During the pendency of the case, till the disposal of the case, there was no impediment and there was no disturbance from the defendant. Only after this appeal was dismissed, on the ground that there is no, not ready and willing, that because of that, the entire amount of sale consideration has been paid. The original certified copy of the sale deed, this agreement of sale is also there, my lord. The entire sale consideration of 4,000 has been paid. On the date of execution of the agreement of sale, the physical possession of this property has been handed over, and also there is a clause that if the defendant failed to execute the sale deed, this agreement can itself be treated as a sale deed. Antano, there is a clause. But anyhow, that I filed a suit for specific performance.
Yes.
So the apex para 70, my lord. Para 70, there are several decisions have been referred in that decision, my lord. The relevant portion is para 70, page 49, my lord. So even in appellate stage, my lord, the appellate court can also consider the application for amendment. Para 70, my lord,
Provision
page
itself
40.
is there, sir. You
But-
don't have to repeat.
But-
There is a provision itself,
But the trial court,
enabling the appellate court to amend the
But-
pleadings. Provision is there.
but the
So
trial
you don't
court,
have to
my lord, by
repeat.
referring the decision of the apex court which has held in 2009.
It is dismissed on the ground that it is barred by limitation. So what is your answer to that?
My lord, barred by limitation, my lord, this when they, because for in the respect of the injunction, my lord, the cause of action will start only.
What is that you want to refer to?
Lord, this is with regard to that even appellate court can exercise the power for,
Provision itself is there. You don't have to cite a judgment for that.
but the trial court, my lord, annexure A, page 19.
Under order 41, provision itself is there. Yes.
So, but only
Your answer to the question of law of limitation.
law of limitation, my lord, insofar as this injunction is concerned, my lord,
Yes.
the injunction, the cause of action arises only when there is an interference by this other side. Whenever they started interference, thereafter I filed an application.
It is to the respondent.
And
The
13 is the
petitioner.
date fixed for the argument, my lord, this main appeal.
Let us see.
The 13 finally on the court is also because for if their the argument has heard and posted for judgment, then it
And
becomes.
when did you file the 2020?
Was file ಮಾಡಿದ್ದು 20 ಇದರಲ್ಲಿ 23 4 ಅಲ್ಲಿ ನೋಡಿ kindly see annexure page 72 lord
Issue notice to the respondent.
page 72 lord the application is filed on 23/1/2024.
A copy of the petition along with annexures on the learned counsel representing the respondent before the appellate court. Release this matter on 23rd of September.
Lord, 13th is the date fixed for argument, lord. That is the reason, lord. Till that time, lord, not to precipitate this appeal, lord. Otherwise, my writ petition become infructuous ಆಗ್ಬಿಡುತ್ತೆ ಅದಕ್ಕೋಸ್ಕರ.
Yes.
This is the seventh defendant's writ petition. Challenging the amendment, allowing of the amendment, seeking declaration that the sale deed of dated 7/5/1992 is void. That is the declaration they wanted to amend. After 32 years of the first sale, and then second sale has taken place on 12/10/2004 after 20 years, and suit was filed in the on 7/7/2014. Amendment application is filed on 14/6/24. Even after that, for 10 years are lapsed. Now the application is filed for amending the prayer seeking declaration that the sale deed dated 7/5/1992 is not binding, void, and it has to be cancelled. One third. Secondly, second sale deed is dated 2/6/2004 has to be declared as void. This is the prayer sought. Therefore, my lord, this is a clear case, my lord, it is barred by limitation. One. Secondly, this was very well within the knowledge of the plaintiff, my lord. This was, we have disclosed the written statement itself. And apart from that, my lord, what happened was, this is a small extent of property, comes within the larger extent. We got this, my lord, clubbed along with the larger extent of the property, 22 acres. We are the owners of about 22 acres. This is a small extent because it comes in the middle of this, and we purchased it. And my lord, we got this land converted. Then we applied for joint development. There are 12 towers have been constructed. More than my lord, each tower consisting of 27 floors. We have sold the properties. Thereafter, they filed this suit because after seeing the huge building and only for extent of land is only 3.5 guntas. That's all.
Suit for?
Suit for partition and separate possession. Son, my lord, father has sold the property in our favor, in favor of my vendor, and my vendor sold the property. Conversion has taken place. Applied for the sanction. Huge building has come up. I have crossed. My lord, another aspect is the suit. After filing the suit, we filed a written statement. We have taken all these defense. The issues was framed. But issue was framed on 29/7/2016, and examination chief 2/8.
29?
But issues were framed on 29/7/2016.
Written statement was filed on?
Written statement we filed on 2015. I filed my date. I will give the date. Written statement filed by us on 9/4/2015. 9/4/2015. 15. Suit was filed on 7/7/2014. I filed written statement on 9/4/2015. And we got the and huge building has come up, that we have sold the property also.
Issue notice to response number 1 to 5.
Yes.
What about the other respondents?
The others, dear family members.
What do you want to do?
Now the matter.
Notice to be issued to them, or you are seeking dispensation?
Notice has to be issued. You may be permitted to take notice to the
all the
learned
respondents.
advocate appearing before the trial court.
Issue notice to all the respondents.
And we may be permitted to take.
The petitioner is also permitted to serve copies of the writ petition along with annexures on the learned counsels representing the respondents before the trial court. Next para. Learned senior counsel Sri G. Krishnamurthy appearing for the petitioner submits that the petitioner, having purchased
Shall I? One request. Sorry, because ಅದರಲ್ಲಿ amendment application ಹಾಕಿದ್ದಾರೆ. ಒಂದು ಪೇಜ್ ಅಲ್ಲಿ ಹಿಂದ್ಗಡೆ ಪ್ರಿಂಟ್ ಸರಿ ಬೀಳಲಿಲ್ಲ. Shall I furnish the amendment application? ಯಾಕಂದ್ರೆ amendment application ಇದೆ ಅಂತಿದೆ. ಒಂದು ಪೇಜ್ ಹಿಂದ್ಗಡೆ ಪ್ರಿಂಟ್ ಇಲ್ಲ. Tomorrow they should not say that misled this on. Please take.
The
Same copy.
Petitioner ನೀವು ಯಾವಾಗ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದು?
We purchased on the 12/10/2004. My vendor purchased on 7/5/1992. Our vendor purchased from the plaintiff's father. Lordship can see the amendment application, just now I have given it, the date what they have sought the prayer. Amendment application, your lordship may kindly come to next page, para 2 ಬಂದು ಸಾಕು. Prayer notice ಆಗುತ್ತೆ, ಬಾಕಿದೆಲ್ಲ pleadings ಅಷ್ಟೇ. Lordship may kindly see, declare that the alleged general power of attorney as executed by Jayarama Pandya, that means his father, and dependent upon wide document number so and so dated 6/8/2003, registered in the sub-registrar office, Bangalore, on the basis of the alleged GPA executed alleged sale deed, document number so and so dated 12/10/2004, registered in the office of sub-registrar, Kerpuram, Bangalore, executed so and so, null and void. Null and void, not binding.
Sale deed date ಇಲ್ಲ.
Sale deed ಇದೆಯಲ್ಲ 12/10 ಇದೆ ಕೆಳಗಡೆ ಇದೆ. ಪ್ಯಾರಾ 2 ನಲ್ಲಿ ಲಾಸ್ಟ್ ಅದು ಸ್ವಲ್ಪ 12/10 ಅಂತ ಇದೆ.
12/10/2004.
ಆಮೇಲೆ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ 6/8/2003.
The 12/10/2004 is the date on which you purchased.
We purchased. And our vendor purchased it on 12/10, 1992. Our vendor purchased in 1992. First para 8 ಏನಲ್ಲಿ ಫಸ್ಟ್ ಪೇಜ್ ನಲ್ಲಿ ಇದೆ, ಎರಡನೇ ಪೇಜ್ ನಲ್ಲಿ, ಸೆಕೆಂಡ್ ಪೇಜ್ ನಲ್ಲಿ ಅಲ್ಲಿ ನಾವು ಲಾಸ್ಟ್ kindly see. Has executed registered sale deed dated 7/5/1992. ಈಗ ಇದನ್ನ ಕೇಳಲಿಲ್ಲ ನಾವು. This sale deed unless this is anyway that is on merits. ರೀಡಿಂಗ್ ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, ಪ್ರೇಯರ್ ಇಲ್ಲ.
The lands in question. You are, this is pertaining only to 1 acre 17
No,
guntas.
this is pertaining to only 3.8 guntas. That is 3.5 guntas only. But we are fighting it. The reason is it comes under the middle of the project. Entire project has come up. 12 floor at 27 we have constructed the building, and 12
Survey
buildings-
number 95/2 and 6.
No. This is we are concerned only in respect of 48/4 only. Other portion we are not concerned, because let them fight it. We are concerned about only survey number 48/4.
3.5 guntas.
Yes, no, 3.5 only 3.5.
48/4.
Yes, madam, correct. Sandra village, Kerpuram.
You purchased only that much.
Yes, madam, because our other properties are huge properties are there. Only this much.
ಏನು ಹೇಳಿದೆ? Namely, 3.5 guntas in survey number 48/4 of Tanisandra village and registered sale deed dated 12/10/2004. And he being the owner of the larger extent of land which are adjacent to the property in question. Got the lands converted to non-agricultural purposes and obtained permission from the competent authority to form a layout.
Yeah, no, this is a, you got the plan sanctioned for the construction of the multi-storied apartment, residential apartment.
Got the permission to put up a multi-storied residential
Apartment.
complex
Yes.
and commenced work.
And 22 floors have already been constructed.
Full
And
stop.
on 3/3/2012 itself.
Nevertheless, long after the plaintiff's father, Sri Jairamappa, executed a registered sale deed
On
in
7/5.
the year 1992.
Yes, on 7/5/92.
A suit for partition and separate possession
Yes.
is filed
Filed on 7/7/2014.
in the year 2014.
And written statement was filed on 9/4/2014.
Obviously with the ill motivations. Full stop. Learned senior counsel submits that Written statement were filed at the hands of the petitioner herein on 9/4/2015.
Yes.
And the details of the sale deeds executed in the year 1992 and 2004
Yes.
were clearly stated in the written statement.
Yes.
Full stop. Issues were accordingly framed on 29/7/2016. Full stop. When the matter
Even cross-examination is also over. Examination, cross-examination, everything.
is almost at the verge of conclusion of trial, an application under Order 6 Rule 17 was filed
Year 23 of 24
in IA 23
of
of 2024,
on 14
seeking to amend the plaint
and prayer.
and prayer, more particularly raising a challenge to the power of attorney dated 6/8/2003 and subsequent sale deed dated 12/10/2004. Full stop. Learned senior counsel submits that although it was contended by the petitioner, defendant number 7
Defendant number 7.
before the trial court, that such an application cannot be allowed. Firstly, since no valid explanation can be given by the plaintiffs having regard to the mandatory requirement in the proviso to Rule 17 of Order 6 regarding due diligence. And secondly, regarding the law of limitation. Stop. Nevertheless, the trial court has proceeded to allow the application, which is going to cause enormous difficulties for the petitioner defendant. Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated 8/7/2024 in OS number 5056 of 2014 till the next date of hearing.
Please.
So number 9.
Ali,
This may kindly, I'm sorry.
the learned senior counsel has also filed a memo furnishing a better copy of the application in IA number 23
Yes.
filed by the plaintiffs. Since the copy furnished along with the writ petition is not clear. The
One
same
page,
mistake
one
on
page
record.
print ಆಗಲಿಲ್ಲ, ಅದೇ mistake ಆಗಿದೆ.
Serial number 9. Madhava, yes.
I appear for respondents 1 to 5. My lord. I pray for some small accommodation to file the statement of objection. First time it is come. I have entered into caveat.
Execution file ಮಾಡಿ ಏನೋ let him not precipitate.
ಅಲ್ಲ 23/9 ಇದೆ ಅದ್ರ ಒಳಗಡೆನೆ ಡೇಟ್ ಮಾಡಿದ್ರೆ ದಿ ರಿಟ್ ಪಿಟಿಷನ್ ಇಟ್ ಸೆಲ್ಫ್ ಕುಡ್ ಬಿ ಕನ್ಕ್ಲೂಡೆಡ್.
23/9
23/9 ಇದೆ. ಅದ್ರ ಮಧ್ಯದಲ್ಲಿ ಯಾವ್ದಾದ್ರು ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿದ್ರೆ
at the request of learned counsel for the respondent caveator, release this matter on 19th of September.
grateful.
Then we can't be.
Petition in this case.
Not, I may be permitted to appear on behalf of the respondent number 1 to 3.
Preliminary hearing. Yes.
I may be permitted to appear on behalf of the respondent number 1 to 3, my lord.
My lord, petitioner is the
Learned counsel Shri
Rudrappa P.
Rudrappa P. Please undertakes to appear for
1 to 3, my lord.
response number 1 to 3. Yes.
Start date may be given, my lord. I will file a statement of objection also, my lord.
my lord,
Any urgency?
my lord, the matter is posted for cross of PW1 on 25th of this month. In fact, I sought for the amendment of the written statement. The petitioner are the LRs of the defendant, my lord.
25th ಒಳಗಡೆ any date may be given. ಅಂದ್ರೆ after evidence amendment ಕೇಳಿದ್ದಾರೆ ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಅಲ್ಲ ಅದರಲ್ಲಿ once we brought on record, you have filed the amendment
25th ಒಳಗಡೆ ಅಷ್ಟೊಳಗೇನೆ ಒಂದು ಡೇಟ್
based on the sale deed, which is taken place in the
Next
19th.
date is 25th. 25th, huh? Yes. Same order at the request of learned counsel for the respondent. Release this matter on 23rd of September.
Obliged.
We'll stop. In the meanwhile, wakalat shall be filed.
Please, please.
Yes.
Obliged.
For preliminary, yes.
11, Nagaya.
Please. Plaintiff's writ petition. Suit for partition. IA number 1 for injunction not to alienate the suit scheduled properties. Dismissed. MA filed. Appellate court also dismissed my appeal.
Yes.
Resulted in this writ petition before your lordship.
Yes.
Kindly see annexure A, genealogical tree.
Relationship is not
Not in relationship, not in
Sorry.
evolution of the property from the Kampalappa to the defendants is also not in dispute. Opinion is kindly see annexure B at page number 23. The item number 1 of the property, annexure B, page number 23. Khata of the item number 1 of the scheduled property is standing in the name of 5 persons. There are 19 plaintiffs and 17 defendants. They are the family members. Khata standing in the name of only 5 persons. Opinion of the trial court is 5 ಜನದಲ್ಲಿ ಖಾತಾ ಇದೆ ಹೆಂಗ್ರಿ ಮಾರ್ಬಿಡ್ತಾರೆ ಆಸ್ತಿನ.
Correct.
ಸರಿ.
There is logic in that.
ಸರಿ, ತಾವು ಕೆಳಗಡೆ ಕೋರ್ಟು ಸರಿ, ತಾವು ಸರಿ. ನಂದು ಲಾಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ. ಐ ರಿಕ್ವೆಸ್ಟ್ ಅವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಟು ಸಿ ಇನ್ annexure M at page number 95. The sale deed.
95.
Sale deed dated 13/2/2023. Different number 18 and 19 are the developers entered into develop the item 1 of the scheduled property with the defendant number 1 to 17. Ivru avun development ಮಾಡಿದ ಆಸ್ತಿನ they have sold this site, started selling the sites. ಸೈಟ್ ಮೇಲೆ ಖಾತಾ ಮಾಡ್ಕೋತಾರೆ, ಕನ್ವರ್ಷನ್ ಆಗಿದೆ ಆಸ್ತಿ, ಖಾತಾ ಮಾಡ್ಕೋತಾರೆ. On the basis of which they are started selling the sites for which we are seeking the
12 persons.
ಹೌದು. ಆಮೇಲೆ ನಾವು ಪರ್ಚೇಸರ್ಸ್ ಎಲ್ಲರೂ ಪಾರ್ಟಿಷನ್ ಸೂಟರ್ ಪಾರ್ಟಿ ಮಾಡಬೇಕು. ಆಮೇಲೆ ಕೊಂಡ್ಕೊಂಡವ್ರು ಈಕ್ವಿಟಿ ಪ್ಲೀಡ್ ಮಾಡ್ತಾರೆ. In order to avoid all such complications in future, we are seeking the relief of injunction at least at the hands of the Samba court. ಈ ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದ ಮೇಲೂ ಮಾರಾಟ ಮಾಡಿದ್ದಾರೆ. And one another property, item number 2 property also subsequently in the year 2023, they have entered into joint development agreement to develop the property.
2018.
ಅದು 2018 joint development agreement in respect of item number 1 of the property. Item number 2 property ಗೆ 2022 ನಲ್ಲಿ joint
ಡೆವಲಪ್ಮೆಂಟ್ ಶುರು ಮಾಡಿ 2022 ಅಲ್ಲಿ
ಹೌದು
ಸೂಟ್ ಫೈಲ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀವಿ. ಅಲ್ಲಿ ನಾವು ಅಲ್ಲ kindly
you are now trying to ensure that they don't dispose of the property.
ಇಲ್ಲ ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ. I request your lordship to kindly see the cost rate of the place. ನಾವೆಲ್ಲ ಬೇರೆ ಊರಲ್ಲಿ ವಾಸ ಇದ್ದೀವಿ.
ಆಯ್ತು.
Once in a while ಊರ್ಗ್ ಹೋಗ್ತೀವಿ. We have noticed the development only after full-fledged layout has come up, and at that point of time you have filed the suit for partition. So during pendency of the suit ಮಾಡ್ತಾ ಇದ್ರೆ
There are 19 of you.
ಹೌದು.
ಮತ್ತೆ issue notice to the respondents.
ಅದರಲ್ಲಿ ಒಂದು
The petitioners are also permitted to serve copy of the writ petition
ಮಾಡ್ತೀನಿ.
along with annexures.
In the meantime,
Alternate counsel is representing the respondents before the trial court.
ಅಲ್ಲ in the meantime status quo ಅಂತ ಆಟೋಮೆಟಿಕ್ ಫರ್ದರ್ alienation ಅವರು ಪ್ರಿವೆಂಟ್ ಆಗುತ್ತೆ.
No.
Otherwise the very purpose of coming before your lordship,
Yes.
even after I produced the sale deed said to have been executed by the defendant themselves.
Yes, let us see, sir. Yes.
I want to date, kindly fix the date. In the meantime, you will serve the copy, kindly fix the date.
Yep. Release this matter on 30th of September.
ಮಚ್ಚು
ಸ್ವಾಮಿ ಇದ್ರಲ್ಲಿ 6 and 7 ಗೆ ವಕಾಲತ್ ಇವತ್ತು ಹಾಕಿದಿರಿ ಸ್ವಾಮಿ.
ಆಯ್ತು. ಲಾಸ್ಟ್ ಟೈಮ್ ಅಂಡರ್ಟೇಕ್ ಮಾಡ್ಕೊಂಡಿದ್ರಲ್ಲ?
ಹೌದು.
Yes.
Kindly press short week.
ಏನು?
Week time ಸ್ವಾಮಿ.
No. Yes.
This is
petitioner has filed a suit in OS 8701 of 2011. Annexure G, page 89.
OS
8701 of 2011, page 89. Suit is for various.
Suit
release
for?
For various release, including declaration of title. Written statement is filed at page 100, annexure H. At page 102,
Who is before this court?
petitioner.
Plaintiff.
Plaintiff. At page 102, defendant's written statement, paragraph 6. About fifth sentence in paragraph 6. It is submitted that said Srimati Bayamma died on 22/2/82, bequeathing her properties to the defendants herein, while her will dated 3/9/81. So last it got it.
It is pertinent to state at this stage that the original owner of the suitable property was one Srimati Bayamma,
Who under the partition deed dated 16/7/52 became an absolute owner of the scheduled property along with other properties. It is under this original owner, the present tenants and their fathers were tenants in from 1970. It is submitted that Srimati Bayamma died on 22/2/82, bequeathing her properties to the defendants herein, while her will dated 3/9/81. Now,
so the plaintiff is claiming to be a tenant.
plaintiff is the owner. Plaintiff under a different will. Defendant's brother has sold the property in favor of the plaintiff.
It is under this original owner that present tenants
That is.
and their fathers were tenants since 1970.
That is other parties, nothing to do with the plaintiff. The defendant 6 and 7 claimed the properties under a will dated 3/9/1981. Now, this will, original of this will is not forthcoming. They had filed a suit in OS number 5557 of 1993. You last turn to annexure. Annexure at page 21, annexure A, 5557 of 93. You last may see the first defendant. Syed Bashir Malik.
1993.
93.
Suit for?
Suit for declaration. First defendant is Bashir Malik, the petitioner here. So you last may turn to the prayer. At page 27.
Tail deeds dated
So and so.
1994,
Executed by the
85.
fourth defendant in favor of defendants 1, 2, and 3 are null and void and not binding. So again, that's the first defendant, that the petitioner suits are filed. Statement is filed. You'll have to pay attention to annexure C. The order sheet.
What happened to that?
Suit dismissed for default. Suit dismissed for default. A miscellaneous application was filed seeking restoration annexure D, this 680 of 1999. Miscellaneous application is dismissed on merits. A review petition was filed. It was withdrawn. Revision petition. Thereafter, a review petition in the CRP was filed. Annexure E, civil revision petition 126 of 2007. Dated 29 May 2007. The revision petition was withdrawn, page 82. Petitioner seeks leave to withdraw the said petitioner with liberty to file an appropriate proceeding in accordance with law. Thereafter, page annexure F, page 83. Review petition was filed in 3/29 of 2007. The review petition came to be dismissed. So the suit for declaration seeking that plaintiff's said deeds are void has been dismissed, attained finally. Now, there are some tenants in the property. I filed a suit, not relevant. I filed a suit for rejection. He makes an application for impleading the defendant's respondent. That application is rejected. They
Who is
filed, he claims that is the persons claiming under the will dated 3981. Relatives of YM. That interim impleading application was rejected. They filed a separate suit without impleading me, get an ex parte decree and execute it. I have filed the suit for setting aside that decree. Now, this suit is for set down for evidence. My evidence is complete. They want to lead evidence. The original will is not produced. If it is any other document, I would have had no objections. Register said it. Original will, production of the original will. They say annexure L is the application, page 115. Seeking to summon the sub-registrar and to depose.
The application is filed by defendants number 6 and 7.
6 and 7. Seeking to summon the sub-registrar. Turn to page 116, the affidavit. Paragraph 3. I submit that the original of the.
What happened to the impleading application?
Which that is separate. That is.
It's not this matter, some other matter,
Some other-
right by the.
Incidentally, in the paragraph 3 at page 116. I submit that the original of the said will was submitted before the Honorable Court in OS 5557 of 93 and placed in safe custody. This is the application. And the original of the will is required because for any other document, certified copy would certainly do. This application, we objected. Thereafter, they filed a memo with 2 documents. Annexure N, page 119, at page 120.
To produce the
Original will. To produce the.
certified copy. He can't produce the original.
Yeah, original is not available.
So to produce certified copy.
Certified copy. Annexure N is a memo filed by them. Complaint, page 120. Complaint to the Registrar, City Civil Court, Bangalore. I submit that and the plaintiff and filed a suit against Bashir Malik in OS 557 of 93 and a deposited a original will dated 3981 executed by my grandmother Srimati Bayamma for safe custody while filing the suit. Later, in another suit filed by the above Bashir Malik in execution 1881 of 2002, I had entered as an objector. The above said will filed by me in OS so and so was later produced and the execution court's order dated 7/7/2005 in execution 1881 of 2002 and marked as exhibit 03A on my behalf. Now both OS 5557 and 93 and execution 1881 of 2002 have been finally disposed of. Sir, later while seeking return of the original will, it was kept in safe custody in OS 5557 of 93 and marked as exhibit 03A in execution 1881 of 2002. I have been informed that the said will could not be traced in the files of either 5557 of 93 or execution 1881 of 2002. Hence this complaint. Now upon this, next is annexure N2, page 121. That's only, now, no inquiry has been held by the City Civil Court with regard to this will. Only complaints are lodged. Now, unless some document with regard to this, last may turn to execution petition.
Now this application to summon the sub-registrar has been allowed.
Has
You are
been
aggrieved by that.
Yes, if it is any other document, certainly no will, especially will.
They have given explanation, sir,
No.
that the original was produced in the earlier suit.
It is taken.
And they have given a complaint to the registrar saying,
No,
so we are asking for return of the original will. It is not returned.
No.
Yes.
Last turn to page. What happened is, I had.
So what will happen now? If they summon the sub-registrar, He may produce the certified copy.
But your last
Yes.
page, your last page turn to page 237. They filed an application seeking to summon the original will. Page 237, 238 is the order. IA8 filed under section 151 CPC by the obstructor is hereby allowed. No order is to call. Office is directed to call for original will dated 3/9/81 produced in OS 555793 on the file of the additional section at Bangalore by way of issuing subpoena summons. Next, next sheet. Page 241. Original will dated 3/9/81 marked as exhibit P3A.
241.
Hardship. Original will dated 3/9/81 marked as exhibit O3A. D3A, I can't say.
It was marked.
Marked.
ಒಂದು ತಂದಿದ್ದಾರೆ. ಯಾವ್ದ್ರಲ್ಲಿ ಇದು?
Execution 1881.
Execution call for records from execution court.
That is marked.
Document is received, my lord.
Yes.
Then your last statement turn to exhibit page 245 in the same execution. Return of a document. Advocate for obstructor files application to return the documents exhibit 01 to 05 and so on so. Certified copies of the same is here present, placed for kind order. May be returned. Documents are taken back. Now
2006 they have taken it back.
2006. Now your last statement turn to N1 N2. Complaints lodged. At page
number 120.
26th April 2018 and 27/11/2019.
ತಪ್ಪಲ್ರಿ.
No, my lord, what happened is marked as A. I'm not received this original will, my lord. Because of this reason, my lord. See, original will already place it before declaration suit.
ಆಯ್ತು, now they have shown the order sheet.
Yes.
You have taken return of the document.
See, my lord, at the time of the return of document, I am given the original will to the court, same certified copy. I am not given certified copy also. I am not received A of the original will as a marked as a. But this document also I am not received.
Sir, ಇದೆ ಅಲ್ಲಿ order sheet ಅಲ್ಲಿ.
ಅಲ್ಲ ಅಲ್ಲಿ A ಅಂತ ನಾನು ತಗೊಂಡಿಲ್ಲ, my lord. This is the problem, my lord. See, because of this reason, lodge the complaint. This court is verifying the records till now is not traced. Even at the time of the return of document, my lord. See, I'll produce the certified copy of will. I am also not produced. Whatever certified copy I'll produce, same document has returned to me, but I am not received. I am also not produced, my lord. This is the problem, my lord. See, my lord, registered will, my
You
lord.
can't say that you have not received.
No, my lord, this the problem is, my lord, earlier, my lord, he also filed application for summon the sub-registrar. I have no objection. See, examine the sub-registrar also. My lord, I am not lodged the complaint on recently. I am lodged after filing of declaration to suit in the year of 2018, my lord. See, till now I am also going searching. Even office also is not.
Question of searching, sir, when it is recorded that it is handed over to you.
As per the order dated, my lord, is marked as annexure 3A, my lord. 3A I am not received. A. This is the actual problem, my lord. See,
ಯಾವ್ದು
but
page number ನೀವು ಓದಿದ್ದು?
241.
241.
245. 245 are taken back.
I'm also, I'll produce the original copy of will also before this court also, my lord. But I'm not there in original because I'm not suppressing the facts. I'll produce in the year of 93 also, my lord. See, but the execution court, my lord, very clearly marked as annexure 3A, my lord. So A I'm not received. 125 received, my lord, but I'm not returned the original will to the court, certified copy. But in the file is not there, my lord.
Still ಅದು ಎನ್ಕ್ವೈರಿನೂ ಮಾಡಲ್ಲ ಆಫೀಸ್ ಅಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ರೆ. This
I'll
is
give it
will,
two complaints.
ಮಟ್ಟಿಗೆ genuineness must be proved.
Received exhibits
1 to 5.
1 to 5, my lord.
and 7 and 8.
7 and 8, my lord. See, because of
Which is this document?
1 to 5. Include, will ಬರ್ತದಲ್ಲ, certified copy will ಬರ್ತದೆ, ಎಲ್ಲ ಬರ್ತದೆ.
No.
A ಇದೆ ಸ್ವಾಮಿ.
It was marked as which, what document?
Will as annexure
Will
three.
was
was
marked
marked
as
as what
03A, 03A. Page,
3A.
3A my lord.
Exhibit 3A.
ಅದು 01 to 05
1 to
ಇದೆ.
5 ಆಯ್ತಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ 1 to 5 A I am not received again and 7 is
Sir,
the
A
proper,
will
my
be the signature.
No.
Huh?
No, my lord. A I am not received.
Yes,
My lord,
answer.
see, I'm also personally go and verify the bill, my lord. I'm not produced the certified copy of original
They
bill.
would have given it to you, sir.
No, my lord, see, very clear, my lord.
Okay.
I'm also tracing this after commencing
What
of
is
a.
the use now? See, you have lost the case.
See,
Case that you had filed in
my
the year
lord,
nineteen
yes,
ninety-three
1990.
has attained finality.
No, it's not the finality. It's not dismissed on
The
merits, my
suit
lord.
filed by the plaintiff
But
against the
Filed by the
original
present-
tenants.
filed by these persons against me.
What is the use if you come and implead, and what is the relief that you're going to seek now?
See, my lord, see, he filed a suit for declaration against me, my lord.
Huh?
See, petitioner filed a suit against me, my lord, for suit for declaration, my lord. This is a declaration suit, my lord. See, my documents has been placed before the court, my lord. This will is already produced in the year of 1993, my lord. This suit is for declaration filed by the plaintiff.
What did you do with the will, sir?
See, my title, my lord.
What is the use of keeping the will with you?
See, my lord, see, will already,
What is the use of keeping the will with you?
see,
If any property is bequeathed to you under the
Yes,
will,
yes, man.
you should have taken steps to get the title in your favor.
Yes.
You have done nothing.
See,
You have filed a suit for declaration. That suit was dismissed.
no, again, I filed one more.
In his suit now, what is it that you are trying to do?
My lord, if I, and I'm filed one more declaration suit.
Yes, let us see.
Declaration suit also is
Circle.
pending, my lord. My lord, I have done, my lord, kind permission, I have done next week, my lord.
The
And I'll address
petitioner.
my arguments. Today I'll file entrance,
Plaintiff.
entering my appearance.
is aggrieved of the impugned order.
I have done Monday, Tuesday or
Passed
Wednesday.
on IA number 25. Which was filed by defendants number 6 and 7 under order 16 rule 1 and 6 of CPC for issuance of summons to the witness dash sub-registrar, Chamarajpete, to produce certified copy of a will dated 3/9/1981, executed by Srimati Bayamma and registered as document number 71/1981-82 in book 3, volume 36, page 234 to 237. Full stop. The application has been allowed by the trial court. Full stop. Learned counsel for the petitioner has taken this court through the order sheets maintained in execution case number 1881 of 2002. Arising out of OS number
HRC.
HRC.
2882 of 1989. Full stop. Learned counsel submits that earlier in a suit filed by defendants number
Defendant number. And recently, my lord, this document has been marked last hearing date, my lord. Examine the
number.
sub-registrar.
1, 2, 6 and 7.
And
1, 2, 6 and 7.
1, 2, 6 and 7 in OS number 555 7 of 1993.
Against the first defendant and his mother. against the petitioner and the mother.
comma, the original will is said to have been filed along with the plaint. Full stop. Nevertheless, it was contended that the defendants have not taken back the original will, and therefore they are constrained to seek production of certified copy of the will at the hands of the sub-registrar. Full stop. But learned counsel has pointed out to the order sheets in the execution case, wherein it is clearly stated that during the course of the execution case, the original was summoned by the court and marked as exhibit
O3A.
O3A.
O3.
Huh?
O3A malad.
O na?
Oh,
Adhe sir, because this problem.
because obstructor.
O3A malad.
O3A. Full stop. Nevertheless, thereafter, orders were pronounced by the learned second additional small causes judge Bengaluru in the said execution case on
18/4/2006.
13/4/2006.
Yes.
While allowing the application filed under order 21 rule 97 by the obstructors, and the EP was dismissed. Full stop. It is recorded in the order sheet that on 18/4/2006, after the execution case was closed, the learned counsel for the obstructors filed an application seeking return of the original documents in exhibits O1 to 5 and O7 and 8, while furnishing certified copies of the same. Full stop. It is recorded that on 22nd of April 2006, the originals of exhibits O1 to O5 and O7 and 8 are returned to the obstructor, who was identified by his advocate. Full stop. In that view of the matter, comma, it is submitted that the defendants number 6 and 7 could not have filed such an application to summon the sub-registrar and produce certified copy of the will, comma, when it is clear that the original of the will was taken back by the concerned. Full stop.
One more development. In the meantime, on the last date of hearing, the matter was set down. The original sub-registrar came with the will certified copy is marked subject to objection, because the matter was set down that day.
Next para, matter requires consideration. Full stop. Consequently, there shall be an interim order of stay of all further proceedings in OS number 8701 of 2011 till the next date of hearing. Yes.
Obliged.
Number 13. Shahbaz Hussain.
That's I appear for the petitioner. That's what I'm seeking here, is that a suit has been filed in by the annexure E methods on 2/9/2009. That's till date the stage of the suit is still in the notice. I am for the defendant number 11 in the original proceedings, the petitioner before my lords. Now, my lords, it's almost been more than 14 years, my lords, the stage is still in the notice. Now, the claim, it's a suit for partition, my lords. My lords may turn to Annexure A, my lords, which is at page number 18.
You are defendant number 11 in the suit.
Yes, my lords, I am the defendant number 11 in the suit.
What
who
is the
is-
prayer in the writ petition?
That's to dispose of or to set a time limit for disposal of this particular plaint, my lords. My lords, in the present matter, I am the only interested party. And all others have been placed ex parte. Now, my lords, the transaction is defendant number 1 sells it to defendant number 2 to 8. My lords, I'm referring to the defendants as it is in the original plaint. Defendant number 2 to 8 sells the property to me in the month of February 2005. Well, it's a third transaction which has been alleged here. The only line which goes on to say, though they acknowledge that, my lords, in the plaint, that sale has happened, my lords, I'm not on that point, but I'm only seeking, my lords, that the rest of the defendants have been placed ex parte. I am contesting. Defendant number 1, as of today, has passed away. Their legal heirs have been bought on record. Still, the suit continues to be in the stage of notice.
Partition and separate possession.
Yes, my lords, it's a suit for partition and separate possession. My only prayer is that, my lords, some time frame may be fixed, because, my lords, I need to have a litigation free land. I purchased back in the year 2005. And, my lords, till date, one or the other litigation has been ensuing upon me. And it's not like, my lords, pleadings are not complete. The pleadings are complete back in the year 2013 itself. My written statement, my lords would find it at page number 101, my lords, Annexure C. And I filed my written statement back on 21 August 2013. That's from since then, issues are not framed. That's no tangible proceedings have taken place.
No, all the other defendants are placed ex parte.
Yes, my lords, all the defendant, my lords, to be specific, my lords, defendant number 2, defendant number 3, 4, 5, 6, 7, 8.
No. Defendants number 2, 3 are represented.
I'm sorry, my lords,
5
defendant
is
number 1,
represented,
4.
9 is represented, 11 is represented.
Yes, my lords. Defendant number 1, 4, 6, 2, 8, and 10 have been placed ex parte. That's while order dated 22nd September 2017.
You are the 9th defendant.
I am the 11th defendant.
Defendant number 9 also has filed a written statement.
Yes, my lords. Defendant number 9
He is also a purchaser.
Yes, he's also purchased. She's also a purchaser. Back in the year 1995. But anyways, my lords, that's on the merits of the matter which we'll have to deal before the trial court. The trial has not even started. Issues have not been framed. Defendant number 1 passes away, my lords, and their legal heirs are brought on record. My lords, it's becoming like a continuous process.
Matter is coming up for Berkeley. Preliminary hearing. Full stop. Learned counsel for the petitioner submits that the petitioner is arrayed as defendant number 11 in the suit filed by respondents number
Respondent
One
number
to
1,
four
2,
here.
and 3.
for partition and separate possession. Full stop. Learned counsel submits that in the plaint, the plaintiffs have admitted
Paragraph number 6, page number 20 and 21. Where they go on to say that, yes, there's a sale transaction which has happened. Second line in the.
where have they stated?
Yes, my lords, page number 21, my lords.
Ah,
They were shocked to know that they executed sale deed in respect of scheduled property in favor of defendant number 2 to 8. And subsequently, defendant number 2 to 8 have executed sale deed in favor of 9th
they don't
defendant.
give the details of the
They don't,
sale deed.
they don't, my lords, because
Admitted that the suit schedule property has been sold in favor of defendants number 2 to 8
defendant number 1 sells it to 2 to 8, my lords. 2 to 8 subsequently
by
sells it
defendant
to,
number 1 in the year
my lords, in the year 1980.
1980.
Yes, my lords, 15,
1980,
yes, my lords, 15/10 to the 1980. Where
and thereafter defendants number 2 to 8 sold it in favor of
defendant number 9
defendant number 9
in 1995.
in the year 1995. Full stop. Defendant number 9 along with defendant number 10 sold the property in favor of
Defendant
the
number
petitioner herein in the year
24 to 2005.
in the year 2005.
That's the date becomes
Stop.
important for other purposes.
The learned counsel therefore submits that though the suit was filed
On 2/6,
on
2/6/2009, which my
2/6,
lords, would get
2009,
page number 23.
comma, the matter has been dragged on for several years only for the purpose of service of notice. Full stop. Full stop. Nevertheless, defendants number 1, 4, 6, 1, 4 and 6 to 8 have been placed ex parte. And defendants number 5, 9 and 11 have been contesting the suit.
Even 11, 10 has been placed ex parte. my lords.
Full stop. Learned counsel would therefore submit that appropriate directions may be given to the
First additional.
learned
senior-
first additional senior civil judge and JMFC, Devanalli to expedite the hearing of the suit and conclude the same within a time frame.
1 year.
Full stop. Next, sir. Having regard to the innocuous prayer made by the petitioner and having regard to the facts narrated herein above and taking note of the fact that the suit was filed in the year 2009 and issues have not been framed by the court, although statement of objections have been filed by respondent number 9,
Defendant number 9 on
defendant
11,
number 9
on 12/11/2010,
and defendant number 11 on
21/8/2018.
18,
Sorry, 13.
13.
13.
Full stop. Comma. Appropriate directions are necessary. Full stop. Next para. Consequently, the writ petition stands disposed of with a direction to the learned first additional senior
Civil judge.
civil judge and JMFC, Devanalli to endeavor to conclude the proceedings and pass judgment in the suit in OS number 297 of 2009 as expeditiously as possible and at any rate within a period of 1 year from the date of receipt of a copy of this order, ordered accordingly.
Grateful. That's
Number 14. Raghavendra V.
Suit for partition, my lord. Present petitioner before my lord is the defendant number 10 before the trial court. My lord.
Huh?
Suit for partition, my lord. Present petitioner is the defendant number 10 in the before the trial court. My lord. My
Yes.
lord, defendant number 1 to 13 are the family members, my lord, along with the plaintiff. 14 is the leasehold rights, my lord. Who has asserted the leasehold right, company, my lord, 14. Only the defendant number 3 and defendant number 8, 10 and 14 have filed the written statements. My lord. Subsequently, the plaintiff has filed a memo to withdraw the suit. The trial court, though ordered for withdrawal of the suit, has passed an order, my lord, annexure A, my lord, page 23, the impugn order. Page 24, my lord, para 5, my lord, married para 5, my lord. Page 24. This is an order passed on withdrawal memo, my lord. Para 5, my lord. Since the plaintiff is not interested to prosecute the suit and the defendant number 3, 8 and 10 are not interested to proceed with the counterclaim, they may be permitted to withdraw the suit and counterclaim. However, it is made clear that on the guise of the dismissal of the suit has not proceeded, the plaintiff and defendant number 1 to 13 shall not interfere with the lawful possession and enjoyment of the defendant number 14 with respect to item number 1 of the scheduled property. With this observation, I proceed to follow order. The memo filed by the plaintiff on 26/2024 is hereby taken on record. The suit of the plaintiff and counterclaim of the defendant number 3, 8 and 10 is hereby dismissed and not pressed. No, my lord, 8 and 10 have not filed any counterclaim, my lord. We have sought, I am the defendant number 10 before the trial court. I have filed a written statement denying the claim of the plaintiff and sought for dismissal of the suit. No, my lord, now the trial court has observed that, my lord, I should not interfere with the possession of the defendant number 14, who claims the leasehold rights. No, my lord, there was an interim order, my lord. Temporary injunction application allow Agithu Swami. The defendant number 14 has filed an application.
You are defendant number 10.
Yes, my lord.
You have also filed a memo.
No, I have not filed any memo. Plaintiff has filed a memo to withdraw the suit. Plaintiff has filed the suit memo to withdraw the suit. As saying that his matter is settled out of court.
But you did not seek to be transposed as a plaintiff.
No, my lord, I have sought for dismissal of the suit itself, saying that there is already a partition way back in the 1980. So the suit itself is not petable. Dismiss the suit. That was my written statement contention. I have not made any counterclaim.
You are a member of the family.
Yes, my lord.
Ah.
I have sought for dismissal of the suit. I have not sought for any counterclaim. But in the meanwhile, my lord, what happened during pendency of the suit? Plaintiff has filed an application for not to alienate the property that was allowed by the trial court. By a common order, my lord, the defendant number 14, who is the leaseholder, my lord, he filed an application against the plaintiff and other defendants, saying that they should not interfere with his possession. That was also allowed. Agreed by which, my lord, I have filed an MFA before this honorable court, my lord. That was pending. The plaintiff has also filed an MFA. That was also pending, my lord. During pendency of the MFA, plaintiff filed a memo for withdrawal of the suit itself. Observing that, my lord, this honorable court disposed of all the MFA, saying that it has become infructuous because the suit itself is disposed. Instead of dismissing the suit as not present, my lord, trial court has made all these observations, saying that I should not interfere with possession of defendant number. So only with regard to that observation, my lord, I have filed this petition. When the suit itself is disposed of, my lord, the direction given by trial court, my lord, it is not a permanent injunction has been given, my lord.
Who is defendant number 14 here?
My lord, he is the respondent number 14 before my lord, my lord. KLR Group Enterprises.
So your relief is in this petition is only against
14, my lord.
respondent number
14, but I am filing a memo, my lord, to dispense the notice to other respondents. ಕೆಲವರೆಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ರು ಅವ್ರಿಗೆ ಬಿಟ್ಟು ಮಿಕ್ತವ್ರಿಗೆ ನೋಟಿಸ್. Who have filed written statement, for them I am seeking notice.
Senate counsel for the petitioner. Today has filed a memo stating that no relief is sought against response number 2, 3, 5 to 8 and 10 to 14.
13 minutes.
13. Full stop. It is also stated that even before the trial court, they were placed ex parte. Full stop. Therefore, notice in respect of those defendants, respondents, is sought to be dispensed with. Full stop. At the risk of the petitioner, notice to response number 2, 3, 5 to 8 and 10 to 13 is dispensed with. Full stop. Next para. Issue notice to respond number 1 and 14.
1, 4, my lord, 4, 9 and 14.
1,
4,
4, 9 and 14.
my lord.
Yes.
Sought for interim the stay of the operation of the impugned order. The injunction ಇದೆ ಅಂತೇಳಿ ಅವರು ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ.
Yes.
My lord, I may be permitted to take hand summons to the trial court advocate. my lord.
ಎಲ್ಲಿ ಕ್ಲೋಸ್ ಆಗಿದೆಯಲ್ಲ ಎಲ್ಲಿ ಎಸ್
ಸುಬ್ರಹ್ಮಣ್ಯ ಸರ್ ಅವರು ಟೋಟಲ್ 18 ಅಲ್ಲಿ ಅರ್ಪಣೆ ಮಾಡ್ತಾರೆ. Serial number 15, my lord. Kindly be passed over.
ಪಾಸ್ ಓವರ್.
Great.
Serial number 16. Speaker of PK.
The petitioner is the plaintiff in the suit, my lord. The impugn order is an order passed under 38 Rule 5 of the CPC, my lord. The defendants have entered appearance, my lord, pursuant to which the interim order came to be passed. There was an ex parte order, my lord, wherein the ex parte order my lord, will be at page 190. The ex parte order says that there's a charge created as far as the property is scheduled property in the IA is concerned, my lord. Subsequent to this particular order, my lord, the respondent has sold the 3 sites and subsequently has entered appearance in the suit. Now, the impugned order, my lord, while the learned.
You are the plaintiff.
I am the plaintiff.
You filed the application.
Please, my lord.
Seeking attachment of.
Attachment before
schedule,
judgment.
Item number 1 to 4.
Please, my lord. Item number 1 is the entire property. 2 to 4 are the properties which were sold earlier to the filing of the suit. In the application, we said that in view of the fact that the defendant owes us money, admittedly by way of balance confirmation and communications admitting to that amount, they have now sold 2 to 4. In view of the fact that they have sold 2 to 4, the remaining portion of item number 1 are at threat. Kindly issue a conditional charge, my lord. In view of that, my lord, an ex parte order was passed. After that, my lord, service was served to the respondent, to the defendant via email through court. Subsequently, they were placed ex parte. On 28th of February, my lord, they have come and appeared. Now, during that time, my lord, they have sold few sites. In fact, in their objections, they admit that these sites have been sold. They say that these sites were sold because Canara Bank, there was a mortgage in the property. Otherly, there was a default, because of which I have taken NOC from Canara Bank and I have sold it. They have not produced any of these documents before this court. In fact, pursuant to their admissions, we procured the sale deeds. Sale deeds, my lord, they have in fact received money and also made payments to the vendor has made direct payments to Canara Bank. There is a total amount of close to 4 crores, my lord, which is received by them, by the defendant, while there's an admission of amount of close to 5 crores, my lord. While overseeing all of these, my lord, the impugned order came to be passed, dismissing my IA. So my only grievance today, my lord, let the charge continue as far as the properties which were sold subsequent to the interim order.
Why you had to file another application seeking order of attachment?
I didn't file, my lord. I didn't file, my lord. In fact, order rule 5 calculated, ex parte interim order was passed. They entered appearance, they filed objection, wherein they admitted that pursuant to filing of the suit and the interim order, they have sold few sites. The court holds that since all the properties are sold, this application is no longer maintainable. With
what application, sir?
The application which we have filed under order 38 rule 5. The same application, only one application.
You said order had already been passed on that application.
My lord, one is the ex parte order. The first order was the ex parte order, my lord. The impugned order is pursuant to the respondent coming on record and having heard both the parties, the order came to be passed.
Yes.
My grievance today is, my lord, let the charge be continued, because in fact, my lord, they have now filed a petition.
How can it continue if the property is already sold?
They have sold it pursuant to the interim order.
So?
That is my grievance, my lord. In fact, they have come today.
Understand the consequences of that kind of an order. What should happen to the purchasers?
My lord, in fact, we have informed the banks also, my lord. The fact is that, my lord, subsequent to the order, they have received
To
money.
notice to the respondents.
They have received money also, my lord. That is
The
my grievance.
petitioner is
They have
also
not,
permitted
they
to
have
serve
admitted to this amount which
Copy of the writ petition along with annexures on the learned counsel representing the respondent before the trial court.
they have admitted to that sale being done, my lord.
Yes.
Further alienation ಆಗ್ಬೋದು ಅಂತ ಸ್ವಾಮಿ.
Yes. Huh? Pass over.
Seal number 60 may be permitted to the trial court, lord.
Yes, I have
I am
said.
brief.
Number 18, right, come again.
The petitioner, my lord. The impugned order, my lord, is an order of arrest, warrant of arrest, my lord, in execution proceedings pursuant to a money decree. My lord, the order is at page 17, my lord. Application comes to be filed on the same date, my lord, 29/2022. No relief is sought, my lord, for arrest of the judgment debtors, but an order is passed, my lord, on the same day. Warrant of arrest has been issued against judgment number 2, my lord, page 17 of the order sheet, my lord. Page 17 of the petition, order dated 29/2022. My lord has it, my lord.
You are a partnership firm.
I was a partnership firm.
There is a decree.
There's a
money decree against
money
you.
decree against me.
Why are you not satisfying it?
My lord, my submission, my lord, I have no means, my lord. I have already filed the suit. for
Partnership firm.
Partnership firm, my lord. I've already filed for insolvency of the partnership firm, my lord. Now on 3 grounds, my lord, I am challenging this order, my lord.
Yes.
This, firstly, my lord, show cause notice ought to have been issued, my lord, to the judgment debtors before an order of arrest. Secondly, my lord, the order 21 rule 40 contemplates a mandatory inquiry before an order of arrest is issued. Thirdly, my lord, it is required, at least the court should be satisfied. I had means to pay the decree and have deliberately failed to pay the decree. All these 3 conditions have not been contemplated, my lord. Therefore, my lord, I am before the court seeking at least give me an opportunity, because application is filed on the same day application is allowed. At least give me an opportunity to show cause that I do not have any means and I'm not deliberately avoiding payment of this decree, my lord. The execution proceedings may go on, my lord. I'm only agreed with the order of this arrest, my lord, and I have sought for staying the operation of this order.
They have been trying to execute the warrant against you.
Please, my lord, that
from 2022.
22, my lord. My lord, what has happened, my lord? In 2023, pursuant to an order in a check bounce proceedings, my lord, I was in fact arrested. I had no means, my lord, to pay. I was arrested and I was.
Notice to the respondents. The petitioners are also permitted to serve copies of the petition along with annexures on the learned counsels representing the respondents before the executing court. Full stop. Release this matter on 23rd of September.
Lord, I've only asked for operation of the order, my lord. I have not asked for stay of the proceedings, my lord.
No, sir. Yes.
Great.
Number 3.
Lord, my date may be fixed, my lord, in this
23rd.
Grateful, my lord.
Question number 3, additional list, preliminary.
Here for the respondent.
Number 1.
Next week, my lord, there's some inconvenience.
Rama-
Senior is not well today. He's had a frozen shoulder since 2 days, my lord. Is some discomfort. Next week, my lord.
In 1.1, I have filed wakalat for after to 14 in a connected matter. Wakalat has been filed. 12 to respondent 12 to 14.
Yes. P. Anand.
No, Vijay Pramati Dasman. In the respondent
In
1.1.
WP number 23573.
That's I have filed.
For response number 1
In a connected matter, my lord, 23099. I have filed wakalat for 12 to 14.
12 to 14.
Yeah.
Then the last one?
Last one, I am not a party to the.
You are not a party. Okay. Learned counsel, Shri Vijaya
Paramati Das.
G.
Yes.
Submits that he has also filed wakalat for response number 12 to 14 in WP number 23099 of 2024.
Yes.
Full stop. Office to verify and show the name of the learned counsel in the cause list. Full stop. Next para. At the request of learned counsel for petitioners, release this matter on 18th of September.
Please.
Yes.
Issue number 1. For orders, till number 19. Sir, FEF.
Filing memo, dispensation of notice, respondent number 4 to 15. And also we withdraw or not press the IA number 1 of 2023. No relief sought against respondent number 4 to 15.
4 to 15.
Oh, sir. ಅದಕ್ಕೆ
Then
IA file
what about 1 and 3?
1 and 3 contesting parties. Reissue ಮಾಡಿ sir. Steps 2 already appear ಆಗಿದ್ದಾರೆ.
Learned counsel for the petitioner has filed a memo dated 11/9/2024 stating that respondents number 2 to 15 are formal parties. 4 to 15
yes,
are formal parties and no relief is sought against them in their petition. Full stop. Therefore, learned counsel seeks for dispensation of notice. Full stop. At the risk of the petitioner, notice to response number 4 to 15 is dispensed with. Full stop. Next para. The petitioner is granted a week's time to take fresh steps for service of notice on response number 1 and 3.
ಹಂಗೆ IA number 1 withdraw ಮಾಡ್ತೀವಿ ಸರ್.
ಏನದು?
ಅದು dispensation of notice ಗೆ IA file ಮಾಡ್ತೀವಿ ಸರ್. This objection raise ಆಗಿದೆ.
Next para. Learned counsel also submits that the petitioner does not press IA number 1 of 2023.
Yes, madam.
Full stop. Accordingly, IA 1 of 2023 stands disposed of.
Number 20. Adinaranappa, FEF. In respect of part 7.
Pass over. ಏನಕ್ಕೆ? Steps ತಗೊಳ್ಳೋದ್ರಿ. ಅದಕ್ಕೇನ್ pass over? Huh? You have to take steps for respond number 7.
Dispensation.
Learned counsel for petitioner has filed a memo dated 11/9/2024 stating that in view of the settlement made between the petitioners and respondent number 7 in respect of item number 1, respondent number 7 has been deleted from the suit claim. Full stop. Hence, dispensation of notice is sought insofar as respondent number 7 is concerned. Full stop. Next para. At the risk of the petitioners, notice to respondent number 7 is dispensed with. Yes.
Number 21. PD Surana.
I filed the memo for withdraw the writ petition.
The petitioners and learned counsel for petitioners have filed a memo dated 11/9/2024 seeking leave of this court to withdraw the writ petition. Full stop. The memo is taken on record subject to all such exceptions. Full stop. Accordingly, the writ petition stands dismissed as withdrawn.
22. Sunil Kane. Sunil Kane.
Learned counsel for petitioner has filed a memo dated 6/11/2023 stating that although respondent number 4, Shri K.T. Gopal is dead. Nevertheless, the legal representatives are already on record. Full stop. Next para. This court is of the opinion that there is no clarity in the memo. Full stop. There are several respondents in this writ petition, and the learned counsel has to be clear as to who are the legal representatives of deceased respondent number 4. Full stop. Next para. Better memo is required to be filed. Full stop. A week's time is granted to do the need.
23, KP Bhuvan. Reporting death of P1 and P2. P1.
2 weeks time is granted to take fresh steps for service of notice on respondent number 2.
24.
And
For R1.
for filing necessary application to bring the legal representatives of
P1.
P1 ಮಾತ್ರನಾ? Photo ಇಲ್ಲಿ.
R1, my lord.
For taking fresh steps for service of notice on respondent number 2.
24.
Advocate for R1 in this case, ma'am. Respondent number 1. Iವರು petitioner steps ತಗೊಳೋದಿದೆ. Petitioners steps ತಗೊಳೋದಿದೆ.
Steps
ತಗೊಳೋದಿದೆ.
ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿದ್ದೀನಲ್ಲ. ಆಯ್ತು. Yes.
24, Reena R, FEF 2 and 3.
A week's time is granted to the petitioner to take steps for service of notice on response number 2 and 3. Yes.
25, Varaprasad K, steps.
Insofar as R5, I have taken steps, your lordship. Insofar as deceased R2, I pray for 2 weeks' time to take steps to bring
Learned
LR.
counsel for the petitioner submits that steps have been taken for service of notice on respondent number 5.
Please.
Full stop. Office to verify and issue notice. Full stop. Next para. Insofar as
LRs of, deceased R2, your lordship.
filing necessary applications to bring the legal representatives of deceased respondent number 2 on record.
I pray for some time, your lordship, weeks' time, I kindly read.
2 weeks' time is granted to do the need.
Interim order may kindly be
Interim order
extended.
granted earlier stands extended till next date.
Grateful.
26,
Please, appear for R1, my
Ko
lord.
Chandrasekhar.
2 weeks time, I will serve a copy.
Number 2, madam.
For the petitioner, please.
I will serve a copy. I will serve a copy.
Statement of
It is not there.
Statement of objections.
Yes, my lord. Yes, sign.
Learned counsel for
Will make
respondent number 1 has served a copy of the statement of objections on learned counsel for the petitioner.
Please. Not if any rectification anta ide, I will check in the office.
Append for respondent number 2, my lord.
Affidavit has not been filed. Signature not forthcoming on each page.
Yes, I will comply, my lord.
Full stop. Nevertheless, a week's time is granted at the request of learned counsel for respondent number 1 for compliance of the office objections
Please.
raised on the statement of objections. Yes.
2 weeks, my lord. 2 weeks.
ಏನಕ್ಕೆ?
ಮಧ್ಯೆ ರಜೆ ಬರ್ತಾವ ಅದಕ್ಕೆ.
Yes.
There is an interim order with that.
Interim order granted earlier stands extended till the next date.
Great.
7, Ravishankar.
Respondent R3, it is, he has refused the notice, my lords, it is held sufficient. R3 is refused the notice,
Refused
refused, is held sufficient.
since notice sent to respond number 3 has returned with postal shera, inward commercial refused. Notice is taken as notice is held sufficiently served on respond number 3.
And I filed IA1 for production of documents.
Huh?
I have filed IA for production of document.
That will be considered along with the main matter.
Much, sir.
Yes.
28, Sachin BS, FEF, R2 and 3, second time.
Notice to R1 is served, my lords. R2 and R3, weeks time may be.
Interim order granted earlier stands extended till the next date.
Notice to R1 is served, my lords. R2 and R3, a week's time may be granted.
A week's time is granted at the request of learned counsel for petitioner
My lords,
to take fresh steps for service of notice on respond number 2 and 3.
3, my lords. Interim order may be extended. my
Interim order
lords.
stands extended.
Grateful, my lords.
29, Adinaranappa.
For R1A and M, my lord, A Shivrama. I've been told that Vakalat has not been filed.
Huh?
Vakalat has not been filed, my lord.
So,
and we have not received any Vakalat because in the lower court they have served us. my lord. So, and we have not received any Vakalat from the party. So only because we are in the lower court on the record, so they served us on the lower court. But afterwards the clients never come before to give the Vakalat to us.
what has happened to the matter before the trial court?
I am not aware of it.
Angala agadilla. We can't permit you to just go away like that. Either the party has to come or necessary instructions have to be obtained.
Maybe next week, I'll file
At the request of learned counsel for response number 1.
one A and M.
A and
M.
A and M.
Yes.
Weeks time is granted. 2 weeks time is granted to file wakalat. Yes.
Talwai Venkatesh.
Requesting for a pass over.
Hearing for respondents.
Huh?
Respondents counsel.
For the petitioner, your lord, my senior is busy in some court, requesting for a pass over.
The case where my lord, the suit is already disposed of. Your lordships recorded the things, my lord, in my lordship's order 31st July it appears.
August.
August, how this suit is maintainable is, since the suit itself is disposed of, determination and impounding process is now challenged second time before this honorable court. CRP is dismissed, it was rejected. Then, my lord, now they wanted to reopen the issue through this writ petition where impounding process is sought to be challenged. Taking shelter under the latest judgment of the Supreme Court.
Yes.
Despite the judgment have no application to the facts of the present case. Anyhow, my lord, the rejection of plaint is already attained finality by virtue of dismissal of the CRP. Plaint is rejected by the trial court for want of non-payment of court fee. That order was challenged. CRP was dismissed. That judgment.
So now if the party is prepared to pay the court fee, stamp duty.
It is not like that. They are not prepared to. Latest one judgment was rendered by the apex court. Section 39 of the Stamp Act. But that judgment I went through twice, my lord, yesterday. It is totally in a different set of facts. It is not a common or it would not be a judgment applicable to all the matters. It is exclusively dealing with the facts in that matter only that order have been passed. I went through the judgment.
Pass over the matter, let the senior come.
Yes.
Pass over ಗಿಂತ I think some other day it would be better.
ಅದೇ ಆಗುತ್ತೆ.
ಅಲ್ಲ ನನಗೆ ಸ್ವಲ್ಪ ತಾಪತ್ ಮಧ್ಯಾಹ್ನ ಯಾವ್ದೋ cooperative elections.
We will take it up now in another 15-20 minutes.
All right.
Pass over.
Number 31.
Appearing for the petitioner, my lord.
Yes.
Received a copy of the A.
My lords, I had filed a vacating, my lords. I'll file better affidavit, my lords.
Learned counsel for respond number 1.
Yes, my lords.
submits that he will file a better affidavit, having regard to the office objections raised on IA number 1 of 2023, ordered accordingly.
Interim order may be extended.
Interim order granted earlier stands extended till the next date of hearing.
Obliged.
32.
For the respondents 1 and 2 in this matter, my lords. Last time I have filed a memo to the effect that the petitioner before your lordship has withdrawn the suit before the court below. And this honorable court directed me to produce certified copy of the order sheet. I served the copy on the other side.
Learned counsel for the contesting respondent has filed a memo dated 23/8/2024 along with copy of memo dated 7/8/2024 filed by the plaintiff petitioner in OS number 239 of 2016. Full stop. Today, the learned counsel has also furnished the certified copy of the order sheet in OS number 239 of 2016 and points out that in view of the memo dated 7/8/2024, the suit is dismissed as not pressed. Full stop. The learned counsel would therefore submit that the prayer made in the writ petition has become infructuous. Full stop. Next paragraph. Consequently, the writ petition stands disposed of in view of the above.
Here for the petitioner. My lords, please. My lords, I am for respondent, my lords, in few of the matters and petition in other 2 matters. I'm not keeping well today. May I request my lords to kindly adjourn the matter, my lords. Fever is there.
My lord, they are all connected. It starts from this 33.1 only, my lord. If they are not ready, kindly have it on 19th, my lord, 19th, please.
At the request of learned counsel Sri Party Sumant Kumar,
Please, my lords.
release this matter on 19th of September.
Grateful.
Yes.
Interim orders will kindly be
Interim orders.
Interim order wherever granted
There are-
earlier stands extended till the next date of hearing.
grateful.
Page number 30, page number 8, serial number 34. I appeal for the respondent. File the appeal, my lords. I'll serve the copy on him, my lords. Appeal is filed immediately, my lords. And I checked up. Instead of pagination in Reading, it is done, my lord. That office objection and second it to be filed. I checked up today. And what has happened, my lord? 9 Rule 13 application. There are 2 orders which are being filed, my lord. As it means 9 Rule 13 revision appeal lies, my lord. But as the application of section 47 was filed, that has been dismissed, as against which there is no appeal, as against which the writ lies, my lord. Appeal is also filed, my lord. I'll comply with the office of eviction, I will move it by Monday.
Interim order has to be vacated.
Number is
Interim order is only to enable him to file appeal. Kindly see the interim order dated 21/3.
They have filed the appeal.
ಅದೇ, ಅದೇ, ಅದೇ.
That is on another application.
ಹೌದು.
This will be on another application.
47. ಇನ್ನೊಂದು ಅಪ್ಲಿಕೇಶನ್ ಇದೆ. ಅದು 2 years ಆದ್ಮೇಲೆ ಫೈಲ್ ಮಾಡಿದಾರೆ ಅದು ಅಪ್ಲಿಕೇಶನ್. They acknowledge, they have suppressed this one. Kindly see the date in that matter, my lord's application. Knowledge of that matter, your lordship may kindly see para 3 for a moment.
Para 3 of?
Interlocutory application section 47 at page 50, annexure E. Page 50. With para 3 ಅಲ್ಲಿ ಯಾವಾಗ knowledge ಬಂತು ಅಂತ, I further submit that I got to know about the judgment and decree dated 3/6/2022 only during January 2024. When the Honorable Court had directed for issuing warrant for execution of commercial so and so. Kindly note the date January 2024. Affidavit para 8 ಅಲ್ಲಿ they had knowledge on 28 September 2022 itself ಅಂತ ಹೇಳಿದ್ದಾರೆ. Para 8. Same this one affidavit. Knowledge of the proceedings. The first DHR approached us after he sent us the legal notice to vacate the premises, and we were informed that after the lease period is over, we will vacate the premises. This thus did not reply to the notice. However, on 28 September 2022, avate gotagide anta helidare. Now the affidavit contains 2 dates. Came up with their men also accompanied by local police and dispossessed us. Execution alle adagiddu. They are not challenged.
There are two parts of.
They were waiting for 2 years. Arrest warrant issue agatanga rent ge substantial rent was due. When arrest warrant was issued, they came before the commercial.
You have taken possession.
Houdu, possession ತಗೊಂಡೆ only for rent, arrears of rent.
Regarding possession, I am not questioning. They are demanding that the court has also decided I should pay damages without holding any inquiry. As against that, this is my lord, I have filed the documents for the executing court that he is holding my fixed at my advance security deposit of 11 lakh rupees. Plus, when he disposes me, my lord, there were my publishing and fittings were 30 lakh rupees, which he has retained. I have got the statement of accounts. The trial court has not, the executing court should go under section 47 into all the issues.
No.
That is the reason I had made the application, and only on the ground that I did not deposit the amount that application rejected, my lords. The application, that is the reason I said he is already holding my amount. He has not refunded my security deposit. So that could have been adjusted. That is the reason, my lord. After hearing the court looked at it, my lord, I got the statement of account, my lord. Don't you kindly see, I bought Yelahanka fixed details, my lord. Nearly 33 lakh rupees worth. I got the full accounts that my fittings are there in his shop, which are yet to be taken by me. Either he should compensate for it, or he should adjust it to the amount. That is the reason I am requesting the executive section 47, let it be gone into.
Bailiff report is very clear, my lords. On 28 September 2000, he removed all the items, then we took possession. It was a running.
It's not about possession now.
Alla rent. Rent alli the application is.
ಆಯ್ತು ಅಲ್ಲಿಗೆ from the date you have taken possession, no further rents are payable.
ಹೌದು.
Now the question is only regarding the rents
Arrears.
payable till September 2020.
That is set up by the court.
What is?
That is set up by the commercial court. Advance ಎಲ್ಲ set up ಮಾಡಿ order ಮಾಡಿರೋದು. That is under challenge. I'm sorry. That is under challenge in the miscellaneous proceedings. Still that miscellaneous is allowed. He can't question this.
Which is the other application?
Miscellaneous application. That he has challenged the decree.
Here in this writ petition, which is the order under challenge?
2 orders are under challenge. Page 57 is application ಮೇಲೆ. ಆಮೇಲೆ page.
Which is the impugned order here?
2 orders.
Adbidi innondu that will be considered in the appeal. So we are on which is the order which we are concerned about?
Page
petition.
Page 26.
26.
Page 25 of the David 17/2/2024. Same day, both orders were passed. Miscellaneous and this. E order na in this matter, in the light of miscellaneous petition being filed, they can't maintain this application, rent application. Adu 2 years admele. If there is any money of his, I am the last person to withhold that. All were set off. He didn't appear before the commercial court. Notice court to ella agi.
Application under
Section 47 of CPC.
Along with memo with one document. And what was the prayer?
That prayer is at page 50, my lords.
To recall order dated 12/12/2023.
And 16/1. Ade arrest warrant issue madiddu. And last alli, and recall the arrest warrant issued against the judge by determining a question of dues between the parties. That will not arise till the miscellaneous petition. He has to succeed in that miscellaneous petition. He rent application for 47 alli rent dues na determine madak barala. 47 has a limited scope. jurisdiction and other things. Trial court and he had knowledge of this order on 28th September 2022 itself. This application is filed on 17/2/2024, quoting a wrong date as date of knowledge, January 2024 in the paragraph 3 only.
And in fact, my lord, I had taken one more contention. The lease deed contained a arbitration clause, my lord. He suppresses that fact before the trial, before the court, in the civil suit. He takes a civil court decree.
Kindly
And I
see
can object to such decree, which is what jurisdiction even.
para 13 of the order of the trial court, commercial court, page 40. They have deducted whatever they are saying, deposit, then that is deducted by the court. Para 12 and 13. Consideration of the deposit of 11 lakhs. The only contention now is made is 11 lakh deposit. That is deducted by the trial court, commercial court. And admitted rents matra damages madidare. They have not excess ಏನು ಮಾಡಿಲ್ಲ 1 lakh.
Party order.
Ex parte, they did not contest the proceedings.
So their contention is there is an arbitration clause and therefore you could not have filed the suit.
Suit alla. The arbitration clause only for arrears of rent, not for the suit ಅಂತ ಅವರೇ ಹೇಳಿದ್ದಾರೆ. Application ಅಲ್ಲಿ arbitration clause, kindly see the paragraph number 5 of the application, my lords, page 52.
That is regarding
Arbitration clause not regarding ejectment, only for arrears of rent.
Where is the?
That is at page 53, my lords.
Allah, this lease deed, page number 65 is the document?
Yes, my lords, unregistered lease deed. They can't even look into that. Unregistered lease deed. To above 11 months. Even the arbitration clause, kindly see page 53, what they have contended. That arbitration clause is applicable only for arrears of rent anta. Page 53 of there.
Since the document itself is here.
Yes.
Let us see the document.
Please, my lords.
78.
Dispute resolution.
How the page 78, clause 24.
Yes.
Any dispute arising out of or in connection with this lease shall be resolved through arbitration in accordance to the provisions of the Arbitration Conciliation or any other enactment of the statutory modification thereof. The arbitration proceeding shall be in English language at seat of or shall be blank so and so. The parties shall each appoint one arbitrator and the two arbitrators so appointed shall thereupon appoint the third arbitrator. That the award passed by such arbitrator shall be final and binding on the parties. It is further agreed that so and so. Next sentence, it is agreed that
But it means all disputes.
Illa termination matra. Illi
cannot
page
be.
53 of the
Any dispute arising out of or in connection with this lease deed shall be resolved through arbitration. in accordance with the provisions
four
of-
lines from below. It is agreed that except in the event of termination, adu arbitration only rent gaste. Except in the event of termination of this lease deed. Arbitration is confined to only other than termination of lease.
Even for a moment.
ಅವರು accept ಮಾಡಿದ್ದಾರೆ affidavit ಅಲ್ಲಿ page 53 of the application. They have
shall
accept
continue to observe and perform their respective obligations
applications under the terms of
under the
this
terms of
despite the pendency of arbitration.
pendency of arbitration.
Renting ಮಾತ್ರ ಬರುತ್ತೆ ಅವರೇ contention ತಗೊಂಡು page 53 of the application filed before the trial court. Section 47 application ಅಲ್ಲಿ this would necessarily mean that the parties had to invoke the arbitration clause in case of any dispute regarding rents or mean profit. No doubt arbitration clause was not applicable in the event of termination of lease deed. That is their contention.
That is a wrong statement.
Allah,
The law is otherwise. The law laid down by the Supreme Court is even if there is termination of the contract, the arbitration clause will continue to hold to bind the parties. Any dispute that arises out of the contract has to be settled only by way of arbitration. So merely because there is a termination of the contract, it will not put an end to the arbitration
Absolutely.
clause.
I agree.
That is the judgment
I
of the
agree in
Supreme
that
Court.
matter. But section 40
Because they make one statement. ಆಗೋದಿಲ್ಲ.
Allah, section 47 application ತಾವು ದಯವಿಟ್ಟು ನೋಡಿ, not on jurisdiction.
Now, these are matters that are required to be considered. In the meanwhile, if everything is executed, and of course you have taken possession also. Now the question
I'm
is,
not seeking repossession also, only damages amount to.
I will leave to the honorable court. The rent, substantial rent is due. Arrears of rent, that trial court, commercial court was conscious of the fact. Kindly see The 4 lines from below in the arbitration clause, ಅದು applicable ಆಗದು other than termination.
ಏನು reissue arrest warrant, you are
ಹೌದು.
Only advance amount, ಆಮೇಲೆ they have retained my furniture and pictures worth 33 lakhs. I am telling, we'll sit, in fact, he came to us. for
which is the
settlement.
order you are aggrieved, sir, in this writ petition. In the other MFA, it is different. Now, in this writ petition, in this writ petition, which is the order you are aggrieved of?
Page 25, 17 to 2024.
In this writ petition,
In fact, I had questioned both my lords for one.
sir, you can't question both.
Yes, yes.
Because admittedly, now you have filed
ಅಲ್ಲ,
a
nine rule-
appeal.
ಅಲ್ಲ, 9 rule 13 appeal ಹಾಕಿದ್ದೇನೆ.
So therefore, let us consider only the prayer.
ಇಲ್ಲ, ಇದ್ರೊಳಗ
you have
arrest
raised
warrant
in
issue
this
ಮಾಡಿದ್ದು.
petition.
Arrest warrant issue ಮಾಡಿದ ಇದನ್ನ rate ಹಾಕಿ.
ಅಷ್ಟೇ, ಅದು ಒಂದೇ. We will set it aside. We will ask you to await the results of that miscellaneous first appeal that you have filed now.
Please.
Please.
And thereafter, if you succeed there, then the matter will go back. It will go back to the executing court.
ಹೌದು.
And then you will be permitted to reopen this question as to whether you
ಅಲ್ಲ,
are still due to pay or they have to pay.
Your lordship may tag this WP with the miscellaneous appeal, otherwise there will be confusion. This may.
ಈ arrest warrant ವಿಚಾರ
ಅಲ್ಲ, ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಲ್ಲ ಇವಾಗ.
ಹಾ.
ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಲ್ಲ, ಲಾಂಗ್ ಬ್ಯಾಕ್ 16/1 ಎಕ್ಸ್ಪೈರ್ ಆಗ್ಬಿಟ್ಟಿದೆ ಅದು ಅರೆಸ್ಟ್ ವಾರೆಂಟ್. Subsequently, arrest warrant is not there.
This is in respect of
Order
application
date in
filed under section 47.
page 25, my lords. Order is at page 25.
47,
ಹೌದು.
section 47.
47. This writ petition may be tagged along with the MFA, my lords.
Where is that application?
Application is at page 50, annexure E. Limited, our arbitration raise ಮಾಡಿಲ್ಲ ಅದರಲ್ಲಿ affidavit ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, but ಇದರಲ್ಲಿ by determining the question of dues between the parties, ಅದೇ ಕೋರ್ಟ್ ಮಾಡೋದಕ್ಕೆ ಕೇಳಿದ್ದಾರೆ, arbitration ಕೇಳ್ತಾ ಇಲ್ಲ ಅವರು. I will be satisfied if this is tagged with MFA, because both the matters are pertaining to the same subject matter.
All right, perfect. Having regard to the admitted fact that subsequently the petitioner has filed miscellaneous first appeal.
Commercial appeal.
Huh?
The commercial appeal, he has given me this.
ಕೊಡಿ.
ಇದೇನಾ?
Please give it.
Appeal 123 of
Commercial appeal.
2024.
Commercial appeal
Commercial appeal 123 of 2024.
123 of 2024 before this court.
Filed on 8th March 2020, 28th March 2024.
Calling in question
Order dated 17/2/2024.
order dated 17/2/2024.
This is against 9 rule 13.
In
notes of
commercial OS,
Page 4.
commercial
9 rule
miscellaneous
is rejected.
Commercial miscellaneous
8 of 2000.
2024. And having regard to the fact that the order impugned was also order impugned in this writ petition pertaining to section 47 is also
in the same subject.
Invariably connected with the order which is questioned before this court in commercial appeal number 123 of 2024, comma, and at the request of the learned counsels, this writ petition may be tagged along with the commercial appeal number 123 of 2024 for further orders.
Please.
Interim order may
Interim order granted earlier stands extended till the date.
Interim order only to file the appeal. Section 47.
Still number 35. Murali Babu M. Writing service.
Sir, before the trial court was served, my lord, 9 my lord, filed in the counter.
ಬಂದಿಲ್ವಲ್ಲ. Your notice is still awaited.
My lord, I filed in.
List this matter after service of notice on the respondent.
Before the trial court I served on
On the
second.
counsel.
House sir. Counter ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ ಅದು 9.
That cannot be taken as service of notice, sir.
Still number 36. Amaresh A. Angadi.
I appear for respondent. I undertake the Respondent.
Learned counsel Shri
Shauri HR.
Shauri HR undertakes to appear for the respondent.
Respondent.
Copy
Copies.
ಬಂದಿದೆಯಾ?
ಇಲ್ಲ.
Learned counsel for the petitioner is requested to serve a copy of the writ petition along with annexures and the learned counsel for the respondent. Full stop. In fact, a copy has been served today. Full stop. Release this matter for preliminary hearing,
Preliminary.
for preliminary hearing on 23rd of September. Interim order granted earlier stands extended till the next date again. 24.
37, Narayanan, MR. Awaiting.
The petitioner, my lords. I have served the copy on the other side as directed by this honorable court. My lords, this is the matter where,
The service of notice on the respondent.
my lords, this is the matter where it's a recovery out, coming out of a works contract act, which was, the entire contract was in Noida. The entire cause of action was in Noida. But the suit was filed in Bangalore.
Respondent is in Bangalore only, isn't it?
Respondent's company is in Bangalore, but they do have a branch office in this.
Not for that, sir. For service of notice, I am asking you.
Yes, my lords, I've even served it on the other side, advocate in the trial court as directed
Let
by
us
this.
Let us see. Yes.
My lords, and the interim order may be granted, my lords, since the trial court is,
No, no. Yes.
38. Conducted matter first time.
Appearing for petitioner lordship, kindly pray for 2 weeks of time to comply office objections. Lord.
2 weeks time are granted at the request of learned counsel for petitioner for complaints of office objections in WP number 22637 of 2024 and for taking steps for service of notice on response number 1 to 4 in the connected matter.
Yes, much obliged.
Still number 39. Arvinda Babu BS.
Yes,
Petition.
office objections.
Office of plaint and written statement ಅದ್ರದ್ದು ಅವಶ್ಯಕತೆ ಇಲ್ಲ ನಾಟ್ ಉಳಿದವೆಲ್ಲ ಕಂಪ್ಲೈ ಮಾಡಿದ್ದೇನೆ.
Petition copy of OS number 7507 of 2013 and return statement.
Dependent fellow plaintiff evidence on behalf of plaintiff they has evidence ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಅಬ್ಜೆಕ್ಟ್ ಮಾಡಿ ಥ್ರೂ GPA ಗೆ ಮತ್ತೆ ಎವಿಡೆನ್ಸ್ ಗೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ. ಅದ್ರ ಮೇಲೆ ಇದು
Want to appear for respondent.
Respondents.
Learned counsel
T. Sheshgiri Rao.
T. Sheshgiri Rao undertakes to appear for response number
Shrikant.
1 and 2 is it?
Yes.
1 and 2. Plaintiff, you are plaintiff.
Yes, ma'am.
A week's time is granted to the learned counsel to file power for response number 1 and 2. Full stop. Learned counsel for the copy idra kodi.
ಕೊಡ್ತೀನಿ
Please give a copy. You have a copy?
ಕಾಪಿ ಒಂದಿದೆ ಜೆರಾಕ್ಸ್ ಮಾಡಿ.
Learned counsel for petitioner is requested to serve a copy of the writ petition along with annexures on learned counsel for response number 1 and 2. Office is directed to show the name of the learned counsel in the cause list.
Kindly tag the matter on WP number 1304
1304
3
3
of 20
That is filed by me, my lord.
of 2024.
24.
List this matter along with WP number 13043 of 2024. Yes.
Date.
ಅದ್ರೊಳಗೆ ಆಗ್ಲೇ ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡಿರ್ತಾನೆ ಅವನು. Let us see. Yes.
40. Gangadarappa AV.
Petitioner, office objection is annexure F is not legible. I have stated that it is legible. And if the court,
Office objection is overruled.
now the question is very simple. Suit for declaration and injunction is filed by me. Annexure B is the written statement filed by respondent number 8. Defendant number 8, annexure B. that is who is respondent number one in the present writ petition. Annexure B is the return statement already filed. Then during the course of the proceedings, I noticed two typographical mistakes, which I requested the court to permit. Kindly go to annexure C at page 31. This is the only amendment I sought.
In para 18.
Para 18, delete the sentence so and so, and prayer A, the following prayer to be substituted, declaring.
The arose on 9/2/1958, when late Sri Lakshmaya purchased the
Suicidal property ಅನ್ನೋದನ್ನ delete ಮಾಡದಿತ್ತು, and prayer ನಲ್ಲಿ declaring the plaintiff as owner in possession and enjoyment of the suicidal property ಅಂತ ಸೇರಿಸೋದಕ್ಕೂ ಕೂಡ application was filed. That application was ultimately allowed by this honorable court in the writ petition. Then the defendant was required to file additional return statement, if any, so far as the amendment is concerned. He did not file, and subsequently he made an application requesting the court to permit him to file additional return statement. In the guise of additional return statement, he wants to substitute the entire return statement which has already been filed in the court. That was opposed, stating that no, it is not permissible. Additional return statement could be filed only insofar as the amended portion is concerned. You can't substitute the entire return statement, deleting some portion, adding some more portions and all that. The learned judges allowed the application and directed that additional return statement.
Where is their application?
IA number page 44. Page 44, annexure E. For the reasons stated in the annexed application. Page 44.
Page 44.
Yes, please. Annexure E. For the reasons stated in the annexed application affidavit, it is prayed that this honorable court may be pleased to recall and reopen the order dated 6/12/2023 and permit filing the return statement by the defendant to permit them to file the same in the interest of justice and equity. And in the affidavit, it is stated that he could not file the additional return statement on account of his ill health and all that. It's all right.
Return statement ಹಾಕಿರ್ಲಿಲ್ಲ ಮುಂಚೆ.
ಹಾಕಿದ್ರು ಅದನ್ನೇ annexure B ತಮಗೆ ತೋರಿಸಿದ್ದು. Annexure B may kindly be looked into. It is filed in the court and it bears the seal of the court also. Page 23.
They have not said additional return statement.
Yes.
And they have not said what is it that they want to bring on record.
Yes. And in the guise of that, they want to substitute the entire return statement.
Where is that? Where is that information?
That I will show to the court. Kindly go to page 47. Paragraph 1, 2, 3, 4, etc. Everything as it is. Then kindly go to paragraph 9. Paragraph 9. About 5 or 6 lines in paragraph 7. I'm sorry, 9. The plaintiff states in his averment in paragraph 4 of the plaint, defendant number 128, falsely claimed interest in the suicidal property on the etc. These are all new insertions without even seeking the permission. Then paragraph 8, last 3 lines. Now the plaintiff come up before this honorable court seeking relief under this false plea, etc. Then kindly go to next page, paragraph 12, 13. They were not there at all in the earlier return statement already filed. Paragraph 19, 20, 21, they were not, they have completely omitted. 19, 20, 21, which was already filed, they have been omitted in the present return statement.
ಯಾವ defendant to all the defendants?
No, only 8 defendants. That is respondent number 1 in the present petition.
Respondent number 1?
Yes.
Only respondent number 1.
Number 1.
Issue notice to respondent number 1. Insofar as the other respondents?
Dispensation I am seeking.
The petitioners are also permitted to serve a copy of the writ petition along with annexures on the learned counsels representing the respondent number 1 before the trial court. Next para, insofar as the other respondents are concerned, a memo is filed stating that no relief is sought against response number 2 to 8. And therefore, dispensation of notice is sought. Stop. At the risk of the petitioners, notice to response number 2 to 8 is dispensed with. Full stop. Next para. Learned counsel for the petitioner submits that
under the guise of filing additional written statement to the amended portion of the. plan.
although respondent number 1 being defendant number 8 in the suit had filed written statement on 1/12/2020.
Yes.
As could be seen at Annexure B, nevertheless, after amendment was permitted to the plaint, an application was filed at the hands of defendant number 8 seeking to
Permit additional written statement.
file additional written statement, although it is not happily worded in the application.
Please.
Full stop. Learned counsel submits that the additional written statement should be permitted only to the extent of the amendment brought to the plaint.
Yes.
And it cannot be taken as an occasion to reframe the entire written statement. Full stop. When this was pointed out, the trial court has rejected the application and proceeded to allow.
Allowed the application and
Rejected the objections and proceeded to allow the application permitting additional written statement
to be filed
at the hands of defendant number 8, which does not pertain to the amended plaint.
Please.
Full stop. Next para. Consequently, there shall be an ad interim order of stay of the impugned order dated
Fifteen 6/2024.
15/6/2024. Invoice number 656 of 2020. Till the next date of hearing.
Please.
Yes.
Seal number 41. Keshav M. Data. R3 first time.
All right, in your lordship's order, I taken out notice from the advocate appearing for the defendant number 2 petitioner before the trial court. The only issue at hand is insofar as an NOC wakalat is concerned. I have given the notice as mandated under law. In terms of Annexure B1 at page 15, he has received that tracking details also are produced. Therefore, the impugned order, let the trial court take my wakalat on record and terminate his wakalat. So I've given him notice and sufficient time. And despite giving him the service of the present petition pursuant to your lordship's order as well, don't think the advocate seems to be.
What information have you placed on record now?
My lord, kindly turn to page 15, my lords. Page 15 and.
No.
I have produced.
On the directions issued to you to serve the learned counsel.
My lords, I have produced a memo dated 4/9/24, my lords.
Yes.
The email is produced, my lords, at page number 2 of that memo.
The learned counsel's name is Mr. Krishna Vyas.
Please, my lords, he appeared before your lordships today itself in another matter.
Purple. Learned counsel for the petitioner has filed a memo dated 4/9/2024 along with copy of the email communication made to learned counsel Sri Krishna Vyas, having regard to the directions issued by this court on 29/8/2024. Full stop. Next para. Nevertheless, but his name is not shown here. Tagbadi. Office is directed to show the name of learned counsel Sri Krishna Vyas in the respondents column.
Please,
Huh?
please.
Release this matter
My lord, if it could be had on Tuesday, my lords, because.
on
the trial could-
17th,
On 17th.
on 17th of September.
Grateful.
Yes.
42. JCTB.
Rest time 1 week, man. Objection file.
Hmm?
1 week, my lord. Petitioner, my lord. 1 week.
A week time is granted at the request of learned counsel for petitioner for complaints of office objections.
43. Shreyas Jayasima.
This is a matter where temporary injunction had been granted in my favor, where my neighboring plot, the caveat has been served. We have served a copy for this of the petition.
My lord, we've, my lord,
what
last
happened
night, caveat copy has been received, my lord. I beg to appear for the counsel for the respondent.
I have
No,
to,
challenge
I
is-
have to commence, please. Allow me, learned senior counsel. I'm commencing, please. My
Matters come up for office objections, sir. It has come up for office objections.
all right, we will comply. We will comply with
Yes.
that immediately. But I only. There, been complied with. I'm instructed that those office objections have been complied with regarding the office objections.
When did you comply?
Yesterday.
They have asked for better copies of Annexure K at page number 97, 98, 116.
These are copies filed by the opposite party in the court below. We have produced the best available copies that are there. These are not material for adjudication of the case is what I would respectfully submit. If I may be permitted to address the honorable court.
Are you ready or you want the matter to be listed for preliminary hearing?
No, there is a urgency in this matter that the crane that is put on my learned friend's client's site, it is an admitted position that it strays into our property in the sky, above our property. Ours is a research facility where there are 4,000 people coming and going. In the ingress point itself, this is there. Brazenly, there is an attempt, there is an offer being made to say, I'll give you an indemnity, but they don't give us the indemnity. And then when we obtain the order, kindly see the order sheet from the honorable court below, that is at page 22 onwards. We had approached the honorable city civil court, obtained an injunction. There was no caveat that was on record as before the city civil court initially. We obtained the injunction. Thereafter, they sought to come before the court and then vacated the injunction on the ground that they had filed a caveat, but it was wrongly not put up by the civil court registry. This, my lord, can find at page number 25. And then the TI came to be vacated. My grievance is that on the date of vacation, my application for TI ought to have been heard itself. Not that the TI gets vacated and no hearing happens. Every date, we have been pressing for a hearing of the matter. For one reason or another, adjournment has been taken, and then there is now belatedly an application sought to be filed to say under 7 Rule 11, I'm not a person at all, which flies in the face of General Clauses Act to say that even an unincorporated entity can come before the honorable court. Now the case is set down for orders. The matter has been heard. My simple apprehension is this, that once more, the matter should not get dragged before the Honorable City Civil Court. It is now set down for orders as early as 17th itself. The immediate prayer
Petition is heard.
Yes, it has been heard. The main
Fully heard and reserved for orders, my lord.
It is reserved for orders. It is reserved for orders on the 17th. My apprehension has been, my experience has been that every time that we have been pressing for the early disposition of the matter, That has never happened. Now, if on the.
Not once as the court, my lord, it's the first time it's posted for orders coming up on 17th. My lord, matter has been, and my lord, kindly.
I'm making a reasonable submission. I'm not asking for of course, my client would like me to make sure that there is a request made for an interim order in this case right now. I acknowledge that the matter is listed on 17th. If this matter is even kept by and heard on the 18th itself, we will know what the orders is on the 17th. And if either side has to challenge that order, we may do so. But in the interim, I would request that at least an order of status quo is passed from today till the 17th, because the heavy rains are there. And this is the General Electric Company's research center, where they are working on military and aerospace related projects. And there is a grave concern for the safety of people. Now, employees don't feel safe to come into office.
Your only contention is that the crane
should not be passing over our property. That is all. They have a 2-acre plot.
Contention.
They have a
My
2-acre
lord,
plot.
if I may, my lord. My lord, firstly, all documents in the trial court are not placed before this court in this writ petition. My lord, I would want to place those materials. Secondly, my lord, that the tower crane goes over their property is not correct. My lord, the position is that the tower crane, my lord, goes over their gate and an electrical box unit of theirs, which is at along their compound wall. And my lord, it does not go, my lord, it's not that I am using the crane on top of their property. My lord, what happens, my lord, is when a tower crane is installed, my lord, because when it is not in operation, my lord, by law, I am required to let the tower crane loose because it has to flow along with the wind, because if it offers resistance to the wind, there's a risk. Therefore, my lord, the requirement, both technical and the requirement in law, is that the tower crane has to be left loose. Now, their grievance is, my lord, when the tower crane is left loose, sometimes, my lord, in the night there is a breeze, the tower crane will stand over their gate. My lord, they have a huge premises of 20-odd acres. This is at the fringe of it. It does not go over any of their research facility, office spaces, nothing. It goes over their gate and their electrical, my lord, some substation or something like that. And their grievance, my lord, is this. My lord, we had several rounds of discussions with them in respect of this. My lord, we put what is called limit switches. My lord, we had discussions, meetings. We had installed limit switches to make sure that at no point of time the operation can ever go anywhere near this place. So my lord, the operation of the lift, they were satisfied fully with that. And after all that is done, my learned friend sets up some indemnity. My lord, we are willing to offer. We have always been willing to offer, but they did not take that offer. Instead, my lord, they filed this suit. And now, my lord, this matter has been heard fully on the question of law, on the question of whether there's a property right, whether there's an easementary right, whether there's a nuisance. On all of these things, matter has been heard at length. All documents are not before this honorable court. And now, my lord, when the matter is set down for orders 7 days hence, the prayer is direct the trial court to pass an order in 1 week. My lord, even if that order is passed today.
No, anyway, the matter is listed for 17th.
17th.
Yes, I have said so. I only want to draw attention of the court to one document, which is contrary to the submission.
No, let us see what the trial court.
I agree. As counsel, I agree. That's why I have myself brought it to the notice of the court. But I'm only saying, please see page 100, because the submission that was made that it does not go over my property is not the position of his own client. Page number 100 shows document number 4.
Let us not go into those aspects now.
We will have this matter
date has been given.
Yes.
For orders.
Yes.
Let us await.
Yes.
The orders.
If my lord can kindly have this matter on the 18th, that will be, I'll be obliged.
Learned counsel for the petitioner as well as learned senior counsel appearing for the respondents submit that the interlocutory application filed by the petitioner plaintiff under order 39 rule 1 and 2 has been heard by the trial court, and the matter is listed on 17th of September for orders. Full stop. Next para. In that view of the matter, release this matter on 18th of September for preliminary hearing.
I am grateful.
Yes. And now the hearing is before but the learned in charge court has heard it also, my lord. I mean, we will be greatly discourteous to the learned judge who takes up a matter which is not on her board, hears the matter at length, and then is posted for orders for the first time.
Nothing has been said now.
Nothing has been said.
Grateful.
On matter of courtesy, the point is that the client itself says that it traverses over my property. That is a clear admission. The matter says the jib may stay over the premises of GE.
When it is left loose, my lord, that's exactly what I said. It
is over. I am grateful.
Pass over. Correct.
Number 30.
Just to refresh the facts, Manoj. Just to recapture the facts.
Your suit has been
Dismissed.
closed
Suit has been closed. I filed a suit for specific performance.
for non-payment of the stamp duty
Stamp duty and penalty.
and penalty.
The document was impounded on 11/1/2018
Ah.
at the instance of the respondent defendants.
Yes.
Thereafter, the court imposes 10 times penalty. Then, my lords, I do not pay the money in terms of the learned trial judge's court's order. Then, my lords, IA is filed by the defendant saying that there is a non-compliance of the order as directed against me. Therefore, my lord, the suit is dismissed.
Yes.
My lord, thereafter, I file a writ CRP before this honorable court. My lord, this honorable court finds no fault with the order of the learned trial judge, holding that since I have not questioned the order of stamp duty, he was within his power to dismiss my suit. Now, thereafter, realizing my mistake, my lords, I have questioned the order of imposition of stamp duty, mainly on two grounds. That, my lords, the 11/1/2018, the document is impounded under Section 33 of the Stamp Act. The recourse which was open to the respondent defendant is to file an application, get it referred for adjudication. That is not being done. Now, my lords, if your lordships, now the judgment of the Honorable Apex Court, which I passed on to your lordships on the other day, paragraph 21 would clearly indicate that, my lord, such a recourse is the only option for the learned judge. Paragraph 21.1, my lords, at page 22. The person who intends to rely on an insufficiently improperly stamped instrument had an option to submit to the scope of Section 34 to pay duty and penalty. The party who has an option directly move an application under Section 39 of the Act before district registrar and have the deficit stamp duty and penalty as imposed collected. In either of the cases, after deficit stamp duty and penalty are paid, impounding effected under 35 of the Act is released and the instrument available to the party for relying as evidence. In the event a party prefers to have a document sent to Deputy Commissioner for collecting deficit stamp duty and penalty, court and every person has no option except to send the document to the district registrar. The caveat to the above is that before court and every person exercises the jurisdiction under 34 of the Act, option must be exercised. Then, my lords, please come to paragraph 21.3. 21.4, I'm sorry. Section 37 of the Act. 21.4, my lords. Page 23. Section 37 of the Act is titled as Instruments Impounded, How to be dealt with. This section arises when a party pays a deficit duty and penalty. The court is to impound the instrument under Section 33 and has to forward the instrument to the Deputy Commissioner or District Registrar. Subsection 2 of Section 37 of the Act deals with the cases not falling under 34 and 36. Person impounding the instrument shall send it to the original to the Deputy Commissioner. This includes the exigencies set out in paragraph 21.1. Being a regulatory and remedial statute, party who follows the regulation and pays this duty and penalty as per 34 and 39 of the Act, legal objection emanating from 33 alone is effaced and document is admitted in evidence. In other words, objection under the Stamp Act is no more available to the contesting party. Section 39 of the Act is titled as Deputy Commissioner's power to stamp instruments impounded. This section provides that procedure to be followed by Deputy Commissioner or the DR while stamping the instrument are impounded under 33 of the Act. As per 39(1)(b) of the Act, penalty may be extended to 10 times the stamp payable. However, 10 times is of furthest limit, which is meant only for the extreme situations. Therefore, Deputy Commissioner or District Registrar has the discretion to levy the and collect the commensurate penalty. Then, my lords, please come to paragraph 21.8. The scheme does not prohibit a party to the document first invoke directly the jurisdiction of the DR and present the instrument before the court or every person complying with the requirement and duty and penalty. In such an event, available objection under 33 and 34 of the Act is erased beforehand. Quantum of penalty is primarily between the authority or the court, and the opposing party has little role to discharge. Relying on the above circumstances of the case, in the perspective of the steps summarized in the preceding paragraph, we notice that before stage of admission of instrument in evidence, respondent or the defendant in this case, respondent raised an objection on the deficit of the stamp duty. Therefore, it was the respondent who was the required suit agreement to be impounded, then sent to the district registrar. to be dealt with under section 39 of the Act. In this case, the respondent desired impounding of the suit agreement and collect a deficit stamp duty and penalty. Trial court is yet to exercise its jurisdiction under 34 of the Act. On the contrary, trial court filed a report from the DR. So for all the purposes, suit instrument is yet still one or the other steps summarized in para 21. Therefore, going by the request of the respondent, option is left to the decision of the district registrar. Contrary to these admitted circumstances, though suit instrument is insufficiently stamped, still penalty of 10 times under section 34 is imposed through the impugned orders. The imposition of the penalty of 10 times at this juncture in the facts of the case is illegal and contrary to law. So therefore, my lord, they direct the document to be sent to the DR for valuation. Now, in this case, 11/1/2018, my lords, documents get impounded. My lords, thereafter, by the impugned order, my lords, I volunteer to pay the stamp duty and get the stamp duty adjudicated. But the court would fix this stamp duty and imposes a penalty of 10 times. Now, the respondent would say that since suit is already dismissed and it is confirmed by this honorable court, which has become final, therefore, my petition under 227 is not maintained. Now, my lords, I relied upon a judgment of the Honorable Supreme Court at AR 2022 SC 422, which I passed on to your lordships on the last occasion. My lords, kindly come to page 5, paragraph 6.
Okay, sir. ಸೀತಾರಾಮ್ ಶೆಟ್ಟಿ ಮುಂದೆ ಕೊಟ್ಟಿರೋದು ಒಂದೇ ಕೊಟ್ಟಿರೋದು ಇಲ್ಲ ಕಾಪಿ ಕೇಳ್ತಿದ್ದೇವೆ ಒಂದೇ ಕೊಟ್ಟಿದ್ದಾರೆ ಸೀತಾರಾಮ್ ಶೆಟ್ಟಿ ಒಂದೇ
ಕೊಟ್ಟಿಲ್ಲ.
The scope and ambit of exercise of powers and jurisdiction by the High Court under Article 227 of the Indian Constitution is examined and explained in number of decisions of this court. Exercise of powers under this article involves a duty on the High Court to keep the inferior court and tribunals within the bounds of their authority and to see that their duty is expected or required to them in a legal manner. High Court is not vested with any unlimited prerogative to correct all kinds of hardship or wrong decisions made within the limits of jurisdiction of the subordinate courts or tribunals. Excess of this power and interfering with the orders of the court or tribunal is restricted to cases of serious derivation of duty or flagrant violation of fundamental principles of law and justice, where if High Court does not interfere, a grave injustice remains uncorrected. It is also well settled that, so therefore, my lords, I am relying upon these last parameters. That, my lords, if the order is illegal and I do not challenge it, for any reason, my lords, I am not advised properly. Now I come back before your lordship, say that I am willing to pay the stamp duty, please get it adjudicated. My lords, after adjudication, I have an option of either going back to the learned trial judge to say that, look, I have complied with the requirement of law, therefore, please restore the suit. So therefore, in these circumstances, my lord, the present petition is filed. Therefore, my lords, the respondents opposing my petition towards penalty and duty, my lords, Honorable Supreme Court says they have no role to play. It is between me and the state how much penalty I am going to pay. They can oppose me on merits of the case when, if at all, the suit is restored in subsequent in a vacant application. Therefore, my humble submission is that dismissal of the suit will not come in the way of your lordship's lords to exercising the powers, because this order, which is illegal, will continue to affect my rights. Therefore, the wording used is.
The matter is not heard on merits.
No.
So you are saying, if an opportunity is not given to me to pay the stamp duty and penalties, even if it is 10 times, that issue is different.
It is for the DR to decide how much penalty he wants to
Therefore, in
impose.
terms of the judgments of the Supreme Court, I think even our division bench had held.
Yes, yes.
In one
This
such
is
matter.
Dastigiri. That was also confirmed.
That it is always the prerogative of the deputy commissioner.
Yes. How much?
Having regard to the provision. So therefore, a party can always say, please refer the matter to the deputy commissioner. I have a better option with him.
Yes. Good.
I think there is a
On
judgment.
11/1/2018, at the instance of respondent, defendant, the document gets impounded. So, my lords, it was for them to file an application and refer it to the DR for adjudication. My lord, if I don't pay, then consequences in law will follow against me. That document will not be admitted or my suit may fail. Merely because suit is dismissed, my lords, that does not preclude me from approaching your lordships, because that order still exists against me and I am liable to pay nearly 4 crores 8 lakhs.
And once the stamp duty and penalty is collected,
I am entitled for seek for restoration.
Matter is required to be heard on merits.
Because this honorable court at paragraph 7 at page 71 would make a note of it that I have not challenged the order. So therefore, my lords, I am before you.
Yes, sir.
But in fact, may kindly see, my lord, order 7, rule 13 may kindly be seen. That machinery have been provided. he is not going to lose anything at all. He can file a fresh suit and this res judicata have no application in such matters. It's a scheme itself in the CPC itself. Order 11, Rule 13, my lord.
Yes.
The rejection of the plaint on any grounds herein before mentioned shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action. The suit, it is saved by the CPC itself. Whether he is ready, he can pay the entire court fee which is determined, file a fresh suit, he can prosecute. Res judicata would not applicable.
Yes.
That's a scheme under the law itself. That is the reason, my lord, while framing the rules, all cautions have been taken by the government, parliament. Here is a case, my lord, may kindly see this. Suppose, my lord, your lordships allow this writ petition passes an order. A coordinate bench dismiss the writ petition.
No.
Could it not amount to review the one minute, my lord? That is
pointing out.
Correct.
It was dismissed only on the ground.
It may be.
That you did not question that order.
No, he questioned that order. Plaint came to, first of all, impounding process have been completed. Then penalty and for stamp duty was determined. He was given occasion to make good of that. He doesn't avail that. Then, my lord, that plaint was rejected. After rejection of the plaint, he filed a CRP before this honorable court. By that time, there were 4 years of delay. On that ground, the CRP came to be dismissed. By virtue of rejection of the CRP, now trial court order is merges with the order of this honorable court by virtue of rendering judgment on CRP. Now, my lord, after that, now he refers to the later judgment of the Supreme Court. I can take your lordship. That judgment has not come to his rescue for this reason. I read it, my lord. Facts in that case was a process of impounding was raised in that suit. What happened was trial court taken note of that, cognizance of that and proceeded. While it intending to determine the stamp duty and penalty, it's find difficult saying that in which village it comes for the purpose of determining the value of the property. Therefore, a trial court that rejected the memo, then they come to this honorable court. High Court said, you refer the matter to the district registrar. Matter was referred to the district registrar to determine the stamp duty regarding in which village this property is located. Then that order, the district registrar in that matter send it back to the trial court, saying that in view of the property fallen in which village cannot be identified and not forthcoming, I could not be able to determine. When that was the process, ultimately plaint came to be rejected. Thereafter, my lord, in that case, the stamp duty and penalty was not finally determined by the court. Matter was referred to the district registrar. Therefore, the Supreme Court said, under section 39(2), when the stamp duty and penalty was not determined by the civil court, it is before the district registrar. Therefore, rejection is not correct. That was the view taken by the Supreme Court. That was the fact of the case. Under the scheme of the Act, once, my lord, the impounding process is commenced by the court. Your lordship, I read the judgments in entirety. What is meant by impound is a property, a stamp duty and penalty issue. It would be the asset of the court concerned along with the instrument. It is an asset. A logical end has to be given by the court so far as that impounded proceedings are concerned. After the impounding process is completed, what my learned friend section refers to 39. 39, my lord, it is not available in a regular course. After he make the payment of the stamp duty and penalty, a machinery is provided for a person. He can approach the deputy commissioner to show the relaxation. If he made out a reason, the court, the deputy commissioner given power to relax certain extent of penalty and not stamp duty. This process 39 could be invoked Only the payment is deposited and made to the civil court and impounding process after seeing the logical end, not prior to that. My lord, your lordships, under the scheme of the Stamp Act, it is like that. Today a client came to me. I examined the papers. I noticed if I file a suit, you would be made accountable for stamp duty and penalty. Therefore, it is an impounding process would commence. I can advise him. You take this paper, place it before the deputy commissioner, district registrar or stamp act, deputy commissioner stamp act. He can, at that process, even before instituting the suit, he can collect the stamp duty and penalty, or if necessary. That is one process. Second process is the determination and penalty of stamp duty by the court is the second stage. Third process is, after adjudicating all this, still it is, my lord, a sympathetic procedure or mechanism provided under the law. Suppose in his case, penalty is imposed about 4 crores and add it is the stamp duty and others. He can make out a case before the deputy commissioner after making the payment. That payment which is made before the court, it will not made before the court. It will be deposited for district registrar. Registrar received the money. He make an endorsement to the instrument. Impounding penalty and stamp duty have been collected. Thereafter, the document will go back to the civil court. Then all other proceedings would commence. That on completion of that process, this is another mechanism. It is independent of the plaintiff or the party and the deputy commissioner. If the deputy commissioner exercises arbitrarily, it is for the state to challenge. Therefore, section 39(2) does not empower the deputy commissioner to redetermine the things which ought to have been determined by civil court. It says 3 mechanisms under the Stamp Act it is provided. In that particular matter, what happened was, since stamp duty and penalty was not determined by the civil court, when it was went to the district registrar, in that process, some developments have taken place rejecting the plaint. In that view of the matter, Supreme Court said, there are about 10 to 12 times, but the Supreme Court said, in this case, it is confined to the matter before the Supreme Court, but not as a precedent. Not as a precedent. I can take your lordships, if your lordship is very inclined to hear that matter, absolutely no issue. That was the law.
I pointed out that is a division bench judgment.
Yes.
I think Digambar Varti.
Digambar judgment was also referred to.
And there's one more also.
Is also noted.
In Digambar judgment, your lordships earlier to that, there was one order by Honorable Justice Sridhar Rao, where I have appeared. It is Govinda Gowda's case. The learned single judge in that matter have taken the view, this very provision itself is discriminative in nature, because deputy commissioner given discretion so far as 10 times of penalty is concerned, he can impose 5%, 2%, 3%, maximum is 10%, 10 times. Even 5 times it is permissible for the DC. But civil courts are concerned, it is no such discretion at all. It's a statutory compulsion.
Correct.
Therefore, the learned single judge have taken the view in Govinda Gowda's case, where I appeared and argued, it is a discriminative. Therefore, he said it has to be determined by the deputy commissioner. However, in later judgment, division bench have taken the view, law holds by learned single judge never be the good law, it is not accepted. A different view was taken by Lordship Justice Kumar and Honorable Justice Venugopal Gowda, it appears. They holds that no, 10%, no discretion so far as adjudicating process before the civil court is concerned. Imposition of penalty is 10 times. The court even cannot impose a penalty exercising dispersion 9.5 times or 9.9 times. It is 10 times, 10 times. But that is the reason when the law is so strict, 39(2) is provided. You go to the DC, address your grievance. If he made out a case, you will some penalty and could be reduced. You have given that power. That is subsequent to payment is made. This is the scheme, my lord. Now, Digambar's case, all other matter, it doesn't say so far as discretion of the court is concerned.
Yes, ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ ಅದು? Or the one that you mentioned earlier?
Digambar's case.
Digambarana, you also mentioned the same.
Yes, lordships indicated.
Even Digambar case was considered in the judgment by the apex court. In the present judgment where my learned friend cited, Supreme Court said it is correct. Supreme Court said the judgment is correct so far as that matter is
Digambar's
concerned.
case was taken in SLP and it is confirmed. And Supreme Court would refer to that judgment.
It is referred to that. Even Govind's case also
I
referred.
think before going to these judgments, now that question regarding mentality of the petition is raised.
Yes.
I rely upon
First answer that one.
20 to 22, my lords. It says that if lordships decline to interfere.
Now the learned senior counsel has pointed out a provision.
Yes.
Yes. Subsequently, you can file a suit again.
My lords, accepted.
Can I refer to one more
If I,
constitutional issue?
can I just,
without that document?
Yes.
How will he file a suit? Without that document.
That is the reason now he has to pay the stamp duty before the district. He can seek permission.
but unless
He
this
can
order is.
deposit.
My lords,
He
whether
can
I,
deposit before the. In fact, my lord, suppose I would like to put it in where it is in inaction on the part of the state under the Stamp Act. Then once this process is adjudicated, if he committed a default, government can recover it as a land revenue. That is the mechanism provided under the law. He will not live free. Even if he is, suppose, my lord, it would happen in such a way. I am not going to prosecute the suit. My suit was dismissed for default. By that time, adjudication is already there. If that was informed to the revenue department or a state is required to collect and recover as a land revenue arrears.
this is a precise reason.
It's one thing.
My lords, I think.
Even my lord, your lordships, one constitutional issue I would like to refer to. Surya Devi Roy's case that was decided by 2 judges, in which my lord, the Supreme Court have taken the view 226 and 227 both are amenable for the adjudication so far as civil court matters are concerned. When that issue given rise to the controversy, then my lord, in Rajesh Sham's case decided by the 3 judges, matter was referred to the 3 judges, where it was said 227 is only remedy available to the pending proceeding before the civil courts are concerned. Question of invoking 226 jurisdiction does not arise where an issue is related to be adjudicated by the civil court. That is 2015 Supreme Court. Now Surya Devi Roy's case is clarified to that extent. Now, my lord, it might up, there would be no apprehension. He can go to the bank, pay the challan, he paid the money. After counterfile, he can enclose and file a fresh suit. It is not. Therefore, adjudicator, want of cause of action, those things does not arise.
Lords, I am grateful for.
Those things does not arise.
Can I just clarify subject to? My lords, whether I go for a restoration or a file a suit, separate suit with the document, without document, this order of imposition of 10 times is staring at me. If that is set aside, I will go back to the DR, adjudicate myself, or I can even abandon the cause of action. I may not go for a suit. But if I have to go for a fresh suit or restoration, this 10 times penalty will be staring at. So therefore, my lords, paragraph 21.2 and 22, they say moment a document is impounded, it is the defendant who has to make an application to refer it to DR. My lords, therefore, that option is kept open, my lord, this order has to go. Whether I exercise subsequent the right to go back to the learned civil judge, or I go for a fresh suit in terms of what is now being advised by learned senior counsel, it is an option left to the petitioner. So, my lords, this 10 times penalty has to be removed. I will adjudicate myself before the learned, district registrar, and whatever penalty will impose, if finance permit me, I will go back, my lords, otherwise I will abandon it and close the matter. To say that, my lords, my petition is not maintainable in the face of this illegal order may not be correct, is my humble.
It's actually an illegal order. It's a legal.
For everything.
Yes.
Now the document is necessary.
That's all right, madam. My submission is.
So long as the document is lying with the civil court.
Correct. Document he can take back.
How?
He has to pay the money to the, he remitted it.
10 times I have to.
Is that the only course open is the question.
But your lordship, my lord.
Is that the only question?
Yes.
Is that the only course of action?
My lord,
Is the question that is
it is
required
the
to be
compulsion under the law. He could have been thought over that issue before instituting the suit. That's what I said. Even before instituting the suit, a remedy available for him to go to the deputy commissioner, get correction of the document, paying the appropriate stamp duty.
Please sit
Then
back.
all those things would not arise. When property instrument become the asset of the court, where adjudication have taken place, there would be no concession at all. Then only he can pay it. Then he can address all of grievances before the deputy commissioner. He can pass an order of
Shall we
refund.
continue in the afternoon or?
No, afternoon, my lord, there are other problems are there.
Release this matter. We will have it on 13th, Friday.
ಆಗ್ಬೋದು. Come on, I'm ready.
ಹೇಳಿ, ತಾವ್ ಹೇಳಿ.
I think, my lord, it is
13th, Friday.
13th beda. 18th or 18th, my lord.
Want it on
18th or 20th, any day.
18th at
Ve-
2:30 PM.
Very good.
Great.
Please come, you please come with all the judgments. I have also passed an order when I was sitting in Dharwad,
Yes, I'll just check.
based on 2-3 judgments.
Yes,
You please look into that and
yes,
bring it.
I would do that. Great.
Lords, one submission, please, in serial number 28, my lords, in causes number 2, withdrawing the petition.
Court officer, sir. Court officer, sir.
ಹೇಳಿ ಸರ್.
ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ 52 ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಲ್ಲ ಕರೆದಿಲ್ಲ ಸರ್. ಓಕೆ ಸರ್, ಓಕೆ ಸರ್. ಇದು ತಗೊಂಡಿಲ್ಲ, ಅಡ್ಜರ್ಮೆಂಟ್ ತಗೊಂಡಿಲ್ಲ ಅಲ್ಲ ಸರ್?
ಯಾವ್ದು ತಗೊಂಡಿಲ್ಲ ಸರ್ ಅಡ್ಜರ್ಮೆಂಟ್.
ಓಕೆ ಸರ್, ಪ್ಲೀಸ್ ಸರ್, ಪ್ಲೀಸ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
ಅದರ್ ಸೈಡ್ ಇದ್ರೆ ಟೋಟಲ್ ಅಡ್ಜರ್ಮೆಂಟ್ಸ್ ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
Sir,
ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ ಕೇಳ್ಬಿಟ್ಟ ನೋಡೋಣ.
ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ ಸರ್?
ಮಧ್ಯಾಹ್ನ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಂತೀರಾ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಸರ್?
ಸರ್ ಇದು ಬಂಚಲ್ಲಿ ಇದೆಯಲ್ಲ ನಮ್ದು 252ನೇದು ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ, ಅದು ಎಜುಕೇಶನ್ ಅದು ಇದ್ರ ಜೊತೆಲ್ಲ ಅಟ್ಯಾಚ್ ಆಗಿದೆ, ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಸೂರಜ್ ಗೋವಿಂದರಾಜ್ ಮುಂದೆ ಡಿಸ್ಪೋಸ್. ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್ ಗ್ರೌಂಡ್ ರೇಟ್ ಮಾತ್ರ ನಂಬರ್ ಬರ್ಕೊಡಿ, ಪರ್ಟಿಕ್ಯುಲರ್ ಕೇಸ್ ನಂಬರು ಮತ್ತೆ ಇದಾಕ್ಬಿಟ್ಟು ಏನಕ್ಕೆ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಅಂತ ಏನಾಗಿದೆ ಅದನ್ನ ಬರ್ಕೊಡಿ. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಎಲ್ಲ ಚೆಕ್ ಮಾಡ್ತೀನಿ. ಅದೆಲ್ಲಿ ಫೈಲ್ ತರಲಿ 5368 ಹಾಕೊಂಡು ಸೀರಿಯಲ್ ಅದು 252 1.2 ಸರ್.
ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ ಮೆಮೋಸ್ ಎಲ್ಲ ಹೋಗಿದೆಯಾ ಸರ್?
ಯಾರು ಬರ್ತಾ ಕೇಳಿ ಪ್ರಕಾರ ಹೇಳ್ತಾರೆ. ಏನು ತಗೊಳ್ತೀರಾ? ತಗೊಂತಾರೆ ಸರ್, ಡೈಲಿ ತಗೊಂತಾರೆ. ಇರ್ಬೇಕು ನಾನು ನಿಮಗೆ ಸಬ್ಮಿಷನ್ ಬಿಟ್ಟು ಇದ್ರೆ ಒಳ್ಳೇದು ಸರ್. ನಂಬರ್ 1 ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ಸೀನಿಯರ್ಗೆ ಹೇಳ್ಬೇಕು?
ಸರ್ ಮೆಮೋ ಬುಕ್ ಆದ್ರೂ ಇಲ್ಲಿ
ಬರ್ತಾರೆ ಕೇಳಿ ಸರ್, ಮೆಮೊ ಬುಕ್ ಇಡಲ್ಲ.
ಸರ್ ಬೆಳಿಗ್ಗೆ ಒಂದು ಮೆಮೋ ಮೂವ್ ಮಾಡಿ, ಬೆಳಿಗ್ಗೆ ಒಂದು ಮೆಮೋ ಮೂವ್ ಮಾಡಿದೆ, ಅದಲ್ಲಿ ಅಲ್ಲಿ ಸ್ಕ್ರೂಟಿನ್ ಬೆಂಚ್ಗೆ ಹೋದ್ರೆ ಮೆಮೋನೇ ಇಲ್ಲ ಸರ್. WP 23227. ಹೌದು ಸರ್, 227.
ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಬಂದು ಹೇಳಿ ಯಾರು
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ನೋಟಿಫೈಡ್ ಇದೆ ಅಲ್ಲಿ ಹಾಕೋದು ಅಲ್ಲಿ ಹಾಕಿ ಹೋಗಲ್ಲ. ನಮ್ಗೆ ಗೊತ್ತಿರಲ್ಲ ಕೈಲಿ ಏನಿದೆ ಅಂತ ಹೇಳಿ ಕಳ್ಕೊಡ್ತೀವಿ. ನೀವು ಹಾಕೊಳ್ಳಿ, ನೀವು ಮಾಡಿ ಆಮೇಲೆ ಡೇಟ್ ಕೊಡ್ತೀವಿ, ಬರ್ತದೆ. ಏನ್ ಪೇಜ್ ಇದ್ರು ಅದೇ ಪೇಜ್ ಬರುತ್ತೆ. ಇಲ್ಲ ಬೀಗಕ್ಕೆ ಹೋಗಿದ್ರೆ IX ಜಂಪ್ ಆಗುತ್ತೆ. ನೋಟಿಸ್ ಆದ್ರೆ ನಾನು ಯಾವ ಮೆಮೊನು ಕಳಿಸಲ್ಲ, ಡೇಟು ಹಾಕಲ್ಲ.
230 matters, B group. Both are easy, B group matters.
If one continue ಆಗುತ್ತಾ for two ನ ಇವಾಗ? ಹೌದಾ?
ಸ್ಟಾರ್ ಇಲ್ಲ ಅಂತ ಕೈಕೂಟಲ್ಲಿ ಯಾರು ತಗೊಂಡು ಸ್ಟಾರ್ ಅಲ್ಲ ಯಾರು ಹೇಳ್ಬಿಟ್ಟು ಹೇಳಿ
ಸರ್ 232nd ಲಿಸ್ಟ್ ಅಂತಾರ?
ಹೌದು ಸರ್
ನಮ್ದು ಒಂದು 7 ಅರ್ಜೆಂಟ್ ಇದೆಯೋ ನೋಡಿ.
7 ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಇಲ್ಲ ಆಗಿಲ್ಲ ತಗೊಂತಾರೆ
ಅದೇ ಲಿಸ್ಟ್
ನಿಮಿಷ ಅಷ್ಟೇ ಇಲ್ಲ Infructuous matters
ಅಲ್ಲ 10
ಇದ್ರೆ ತಗೊಂಡ್ಬಿಡಿ ಹೇಳ್ಬಿಡಿ ಅಷ್ಟೇ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ ಇದು ಚೇಂಜ್ ಮಾಡ್ಬಿಡಿ
ಇವೇನ್ Infructuous matter ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
ಇದೆ ಸರ್ ಇವಾಗ ಕರೀತಾರೆ
ಇದಾಗಿರ್ಬೇಕು
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅದು Infructuous matter
ಎಲ್ಲ Infructuous
ಇಲ್ಲೇ ಇದ್ರು ಆಗುತ್ತೆ
ಅದು ಮಾಡ್ತಾರೆ
ಮೆನ್ಷನ್ ಮಾಡ್ಬಿಡಿ ಅಷ್ಟೇ ನೀವು
ನನಗೂ ಗೊತ್ತಿಲ್ಲ Infructuous ಚೆಕ್ ಮಾಡಿಲ್ಲ
ಡೇಟ್ ಕೇಳ್ತಾರೆ
ಇದೆ
ಬಂದು
Which number two?
10,
Number one?
list number 2, serial number 10, Infructuous.
Correct.
ಆಯ್ತು.
Call out all.
Krishnamurti, yeah?
OS 1177 of 2015. Was dismissed as withdrawn on 3/12/2022.
Serial number two? Then Ramakrishna?
Bring for petitioner, my lordship. Kindly fresh time, my lordship. Senior inconvenience, my lordship.
OS number 91 of 2020 was dismissed on 3/8/2024. Prayer has become infructuous, disposed of.
Three, Lakshmikant K. Serial number 3, Lakshmikant K.
Case 2959 of 2020. It was dismissed as not maintainable on 3/11/2023.
Serial number 4, HP
Sir,
Devaraju.
that I appear for the petitioner. I filed a memo that the suit dismissed as settled out of court on 14/6/2024.
Learned counsel for petitioner has filed a memo.
Petitioner files.
All right. OS 1967 of 2007 was settled out of court and accordingly decreed on 14/6/2024.
Mature.
Serial number 5,
For the petitioner,
this-
my lord, the second respondent, it has come as unclaimed. It may be held sufficient. Notice to second respondent has come back as not claimed. That may kindly be held sufficient. And
The suit 4271 of 2012 was dismissed as withdrawn on 5/6/2024.
oh, I'm sorry, I was not.
Yes.
Well,
serial number 6. N Suresha.
OS 61 of 2017 was decreed on 3/1/2024.
Serial number 7, Manohar.
Appearing for respondent number 1 and 2, man.
OS 79 of 2018 was dismissed as withdrawn on 4/3/2024. Disposed of.
8, Vinod Prasad.
decreed on 16th November.
OS 3109 of 2019 was decreed on 16/9/2023. Submission of learned counsel for petitioner.
Yes, petition.
9, Gurudat BS.
OS 4130 of 2001 was decreed partly and preliminary decree was drawn on 19/6/2024. Disposed of.
10, PN Harish.
Learned counsel for petitioner. OS 35 of 2022 was settled before the Lok Adalat on 8/7/2023.
11, sufficient.
For the respondents. Suit has become infructuous. Prayer has become infructuous. The suit has been.
The plaint in OS number 4515 of 2015 was rejected on 28/3/2024. Disposed of.
12, BK Manjunath.
Respondent. OS 192 of 2017 was dismissed on 24/8/2024. Disposed of.
13, Harish Kumar MS.
For the respondent.
OS 387 of 2012 was dismissed on 30/3/2024. Disposed of.
14,
14, I think.
Vijay Kumar R.
Lordship may fix a date so that we can argue. What has happened is, my lord, the preliminary decree was drawn by the trial court. Then, my lord, the matter was carried up to this honorable court where preliminary decree was confirmed. And the final decree proceedings and application is filed. And the learned judge has passed an order. After the order is passed, when the writ petition is pending, they did not appear, FDP is dismissed now. But the shares have been redefined now by the order, impugned order. That is under challenge. The shares have been altered by the impugned order by the trial court. But after that order, when the writ petition was pending, they did not appear and the FDP is dismissed now. They may revive the FDP in that event. This order, again, my lord, will have to be reviewed. Again, it has to be reconsidered. The question is whether the shares could have been redefined now by the FDP court, one the preliminary decree had attained penalty. That question, therefore, the lordship said, we will hear this matter. That is how notice was ordered. The lordship may keep it pending, and we will address arguments on the impugned order. Because anytime they can file FDP, another FDP.
I'm appearing to the respondent number 2. We haven't filed the wakalat yet. See.
17/8/2022.
Yes, my lord. But the difficulty is once the FDP, they file a FDP based on the revised decree, there will be difficulty because res judicata will operate against me then. If my lord said to say, dispose of this writ petition saying that if the FDP is revived, I can revive this, there are no difficulty. Instead of keeping it pending, I can make an application for revival of this very writ petition. Or else your lordship may keep it, hear the matter and we can.
The information received by this court is that the final decree proceedings from out of which the present writ petition arises, namely FDP 126 of 2018 was dismissed on 26/10/2023 after this writ petition was filed.
And entertained by this honorable court.
Full stop. In view of the dismissal of the final decree proceedings itself, the question is whether the prayer made in the writ petition has become infructuous or not. Full stop. Next para. Learned counsel for the petitioner submits that the petitioner, being respondent number 32 in the final decree proceedings, is aggrieved of the impugned order dated 17/8/2022.
By which, my lord, application for amendment of the preliminary decree was allowed.
Oh, that was done in view of the ruling of
That's right, but.
Vinita Sharma.
But anyhow, my lord, no, anyhow, my lord, we will distinguish that Vinita Sharma in the light of the fact situation in the present case. There are other judgments. Your lordship may post it for hearing on any day, my lord. I will address argument. It will take some time. But it needs to be addressed. What I would request is your lordship may simply adjourn it by 2 weeks. Then I will, if my lords feel that this can be considered on merits, it can be considered. Or the lordship may give the liberty for me to revive this petition at a later point of time, whatever it is.
Revive when?
When they get the FDP renewed. Because this order should not come in the way of my.
They get it renewed.
Pardon, my lord?
Why would they get it renewed?
The final decree is not drawn today, my lord. Final decree is not drawn.
The preliminary decree and the shares that were declared in terms of the preliminary decree has been modified by this impugned order.
It can be modified is our question.
Having regard to the judgment passed in Vinita Sharma, isn't it? You have questioned that one here.
Yes.
Now, the final decree proceedings have been closed.
This is not drawn. Final decree is not drawn.
Dismissed why?
Because they did not appear to take further steps in the matter.
Who is the
They are
petitioner?
the petitioners before the final decree proceeding.
Who is the petitioner?
Petitioners are the dependents in whose favor there is a decree confirmed by this honorable court.
You are the plaintiff, is it?
No, we were the defendant.
You are
in
also
the suit.
dependent.
Yes, yes.
No, you. Who is the plaintiff?
Our plaintiff.
I am for second petitioner, my lord.
Who is the party who filed the final decree proceedings? Who is the party who filed the final?
The plaintiff, my lord, in whose favor, sorry.
With reference to the party, sir.
Yes, my lord.
Yaro?
The plaintiffs, my lord.
Huh?
The plaintiffs in the suit.
The respond number 2, my lord, respond number 2.
ಏನು ಬರ್ದಿಲ್ಲ. You are required to write ಯಾರು who is the plaintiff ಏನು ಗೊತ್ತಿಲ್ಲ.
Respond number 2 and 3 are the plaintiffs, my lord. Respond number 2 and 3 were the plaintiffs, my lord.
Response number 2 and 3.
2 and 3, my lord. Yes.
You had filed the final decree
Yes, my lord.
proceedings.
Along with my sister, I filed the suit.
Now the FDP proceedings have been dismissed
Yes.
on 26/10/2023.
I don't know. I need to take instructions,
my
my
lord.
lord. I need to take instructions in that regard.
To take instructions, this is the information
Yes, my lord.
from the
that is-
website of the city civil court.
That's a fact, my lord.
I'll inquire, my lord. I'll inquire, my lord. I don't have a.
Now what to do about this matter is the question.
Well, let it be, have it in next week, my lord. In the meantime, I will ascertain, my lord, and also I will make necessary application.
Certain unless
No, my lord,
that is a fact which I have, which is here.
my lord, even
He also knows the final decree proceeding have been dismissed in October 2023,
Please, man.
and you have not done anything after that.
I don't have any knowledge, my lord, in that regard. Even otherwise, my lord, this case is covered by the judgment part Vinita Sharma, my lord, where, yes.
Now, after all that, your final
I do
decree
agree, my lord.
proceedings have been dismissed,
Yes, if it dismissed, my lord,
and you have not taken any steps.
yes. I will ascertain and submit, my lord.
Next para, at this juncture, learned counsel for response number 2 and 3.
No, I'm for respond number 1, my lord.
I for the response 2, my lord. We haven't filed the wakalat.
I appear for respond number 1, my lord.
Neeva,
Respond number 1.
2 and 3 are the plaintiffs.
Plaintiffs.
They filed the petition,
Yes, man.
They filed the
final
petition.
decree proceedings.
Yes,
Huh?
yes. Being a plaintiff, they filed
Learned
it.
counsel for respond number 1. Who is appearing for 2 and 3?
I'm for two, man.
Huh?
Respond number 3. I'm for respond number 2, man. We haven't filed the Wakala case. Need to find time to find the Wakala. Respond number
Learned counsel for response number 2 and 3. Comma, the original plaintiffs and the parties who filed the final decree proceedings seek for a short accommodation to secure instructions and make submissions. Next para, release this matter on 19th of September.
Great.
Serial number 15. Tarun, Purana.
Respondent.
The execution case 171 of 2013. Was closed. On satisfaction of the decretal amount, comma, on 24/8/2024. Disposed of.
Number 1, passed over matter. Serial number 15. V.V. Kulkarni.
Sir. The matter being brought, sir. The respondent number 1 has filed the suit seeking declaration. And Lord's mandatory injunction also. Lord's pursuant to which Lord's there was an order passed on 12/6/2024, Lord's directing Lord's the defendants from Lord's alienating, restraining them Lord's from alienating or encumbering the Lord's the suit schedule properties. Then Lord's that was as in Lord's while considering Lord's of pending consideration of IA number 1 and 2 Lord's, that order came to be passed till the next date of hearing. Lord's, your lordships will get it Lord's at page number 20. The page 21 Lords is the order.
Ex parte temporary injunction.
The ex parte temporary injunction Lords, which will be enforced till the next date of hearing Lords, is the observation made. Lords, subsequently, that is on 23/8/2024 Lords, in the very same page. Lords, when we filed written statement Lords and the objections, Lords, the trial court Lords passes an order extending Lords still further orders, the orders, Lords, without considering Lords those applications. Meanwhile, Lords, I had also made an application, Lords, seeking rejection of plaint, Lords, wide Lords, application dated
Order 7 Rule 11D.
Order 7 Rule 11.
A and D.
Yes, Lords, at page number 24. Lords, that application Lords, I filed it Lords on the same day. Lords, when the matter came up on 23/8/2024. Lords, now the trial court Lords post the matter Lords to 22/11/2024. After 3 months Lords, without considering the application. I am only seeking Lords the mandamus Lords that my application Lords for the rejection of plaint Lords would be considered within a time frame Lords by the trial court.
Date ಕೊಟ್ಟಿದಾರಲ್ಲ ಈಗ.
ಅಲ್ಲ, you want to list the matter Lords after 3 months. Lords, kindly see 23/8/2024 Lords is the date on which the matter came. Posted Lords after 3 months. Without considering the application Lords which is filed. And ad interim Lords injunction that was granted Lords till the next date of hearing, even that was also Lords extended till further orders. In fact, Lords, if my Lords were to see, kindly see Lords why Lords the Lords in the plaint itself, Lords. The plaint itself, Lords, 1 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 Lords, 1
That is at page number 28.
Learned
Kindly see.
counsel for the petitioners submits that the petitioners are dependents in the suit filed at the hands of the respondent herein, who has sought for declaration and
What's injunction?
mandatory injunction.
Declaration, my lords, and injunction. What's if prayer,
Permanent injunction.
permanent injunction.
Full stop. Along with the plaint, application in IA number 1 under order 39 rule 1 and 2 was also filed, and an ad interim ex parte temporary injunction was also sought. Full stop. Learned counsel submits that an order was passed on 12/6/2024 restraining the defendants from alienating or encumbering the suit schedule property as prayed for in IA number 1 till the next date of hearing. Full stop. On the next date of hearing, the petitioners herein appeared, filed objections to the application seeking temporary injunction, and along with the objections, the petitioners also filed
IA number 5.
IA number 5 under order 7 rule 11 bracket A and D of CPC for rejection of the plaint, as there is no cause of action against defendants number 1 and 2, and that the suit is barred by law. Full stop. However, the trial court has not only extended the ad interim temporary injunction that was granted on 12/6/2024, but also directed and adjourned the matter to
22/11/2024.
22/11. Full stop. The learned counsel would therefore submit that it would suffice if appropriate directions are given to the learned senior civil judge and JMFC, Hoskote to consider IA number 5 filed by the petitioners and dispose of the same within a time frame. Full stop. Next para. Having regard to the submissions made by the learned counsel for petitioners, this court is of the considered opinion that there is no need to issue notice to the respondents, and the writ petition may be disposed of accordingly. Full stop. Next para. Consequently, the writ petition stands disposed of with the direction to the learned so-and-so judge to hear and dispose of IA number 5 filed by the petitioners herein as expeditiously as possible and at any rate within a period of 2 months from the date of receipt of a copy of this order. full stop. For that purpose, the learned senior civil judge may also advance the matter. Inform the learned counsels for the petitioner, plaintiff, and take up the application for consideration as directed by this court. Ordered accordingly. Great.
Number 17.
Petition. Plaintiff writ petition. You last may kindly see the prayer, page number 19. The election to the pastorate committee of the respondent for the period 2024 to 27. A list of members have been published, fixing the election as 30th June 2024. 30th June 2024 is the date fixed for election. Publishing the voter list. I filed an objection to the voter list, bringing to the notice that non-Christians are also included in the voter list. Kindly restrain them from participating in the voting and delete their names in the voter list is concerned. That has not been done. Then I approached the civil court. An application for injunction was sought for. Page 21, you will not may kindly see page 21. I sought for an order of injunction. The emergent notice has been ordered by the trial court.
Restraining the defendants.
Not to conduct the election illegally with regard to the alleged voter list 448 members. Then the emergent notice has been ordered. Election date was on 30th June 2024. The written statement was filed before the trial court. Your Lordship may kindly take page 48. I brought to the notice of the court, these are the 20 ineligible voters have been included in the voter list. They should be restrained from casting their vote. Considering my application, there was an interim order by the Honorable Court. Kindly take page 54. Operative portion, page 55. So far as these 20 persons are concerned, the voters, if any, cast by the person mentioned in the voter list number so and so, list
We kept in a separate sealed box.
Not to be
and
announced.
result shall not be announced without
further
orders from the court.
ಇವ್ರದನ್ನ separate ಆಗಿ ಇಡಿ ಅನೌನ್ಸ್ ಮಾಡಬೇಡಿ ಅಂತ ರಿಸಲ್ಟ್ ಕೊಟ್ಟರು. ಇದಾದ ನಂತರ an application was moved by the defendants before the trial court. Annexure H, page 68. Directing the returning officer of the election to pastorate committee to open the sealed 2 ballot boxes pertaining to the election so and so. ಇಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು ಅವ್ರದ್ದು ಸಪರೇಟ್ ಆಗಿ ಅನೌನ್ಸ್ ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದ್ರು. ಇಲ್ಲಿ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು. ಇದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ದೆ ನಾನು. Now the application has been allowed, directing the election officer to announce the result. Page 58, 88. ಅವ್ರನ್ನ ಬಿಟ್ಟು ಅನೌನ್ಸ್ ಮಾಡಬೇಕು. Page 88. Consequently, the returning officer of the elections of pastorate committee is directed to open the sealed 2 ballot boxes pertaining to the election so and so, announce the result. My suit become infructuous. Nothing remains in the suit.
ಅಲ್ಲ ಏನಿದು ಓನ್ಲಿ 2 ಬ್ಯಾಲೆಟ್ ಬಾಕ್ಸಸ್ ಅಂದ್ರೆ ಏನದ ಅರ್ಥ?
ಅಲ್ಲಿ 2 ನಮ್ಮದನ್ನ 20 persons ಸಪರೇಟ್ ಆಗಿಡಿ ಅಂತ ಹೇಳಿದ್ರು.
ಹೌದು.
ಇನ್ನೊಂದನ್ನ ಒಂದು ಬ್ಯಾಲೆಟ್ ಬಾಕ್ಸ್. ಈಗ ನಾವು ಏನು ನಾನು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದ್ನಲ್ಲ 20 ಜನ ನಾಟ್ ಎಲಿಜಿಬಲ್ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಸಪರೇಟ್ ಬಾಕ್ಸ್ ಅಲ್ಲಿ ಇತ್ತಲ್ಲ ಅದನ್ನು ಓಪನ್ ಮಾಡಿ ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಎಲಿಜಿಬಲ್ ಕ್ಯಾಂಡಿಡೇಟ್ಸ್ ಒಂದು.
There must be some reasoning for that.
Kindly see the reasoning. ಅಷ್ಟೇ ಹೇಳ್ತಾರೆ, ಏನು ಹೇಳೋದಿಲ್ಲ.
Reasoning page 79. ಎಲೆಕ್ಷನ್ ಆಗೋಗಿದೆ, ಹಾಗಾಗಿ ನಾವು ಡಿಕ್ಲೇರ್ ಮಾಡ್ತೀವಿ ಅಂತ ಅಷ್ಟೇ, ಬೇರೆ ಏನು ಹೇಳೋದಿಲ್ಲ.
ಆಯ್ತು, ರೀಸನಿಂಗ್ಸ್ ಲೆಟರ್ಸ್
Kindly see the reasoning page 79.
ಅಲ್ಲ 83.
Reasoning
Yes.
page 83
83.
full stop. It must be noted that I need not repeat the entire contention of the parties here also, since I have already narrated the same in the inception of this order. It must be noted that the plaintiff has filed the suit against the defendant for the relief of declaration to clear the voter list furnished by the defendant number 1 as null and void, and to announce the new voter list by deleting the persons who are not or proposing Christianity, and to direct the defendant number 1 to conduct the election to the St. Matthew Church, Wilson Bank, Coromandel, KGF for the year 2024 to 2027, and to announce the calendar of event to fix the date of election of the said church in accordance with the bylaws of the Constitution of the Church of South India, Karnataka Central Dicos, and also for the relief of permanent injunction restraining the defendant, their men, age servants, and others acting on behalf of the defendant from acting as an election presiding officer, St. Matthew Church, and not to hold the election illegally with the alleged voter list of 448 members on 30th June 2024. This was the prayer made in the application. In the case on hand, the defendants have filed this application and to praise to direct the returning officer of the election of pastorate committee open the sealed 2 ballot boxes. Earlier ಇವ್ರನ್ನ ಸಪರೇಟ್ ಆಗಿ ಇಡಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸಪರೇಟ್ ಆಗಿ ಇಟ್ಟಿದ್ರೆ ನನ್ನ ತಕರಾರು ಇರಲಿಲ್ಲ. Pertaining to the elections of the pastorate committees of St. Matthew Church held on 30th June 2024. Further, it is relevant to note as per para 23 of the plaint, the plaintiff has contended that plaintiff and other congregation members have absolutely no objection to hold the election by deleting the non-Christians of 20 members mentioned in the memo by the plaintiff. Further, as per the order of the court, the voters, if any, cast by person mentioned in the voter serial number so and so, to be kept in separate sealed box, and results shall not be announced without the further order from this court. As per the averments of the affidavit annexed to the application, 13 members have cast their vote out of 20 disputed members. Further, it is relevant to note as per the bylaw of the Karnataka Central Dicos of Church of South India, a voters pastorate committee shall be qualified who has been member of the unbroken period prior to the election for the sake of convenience so and so. ಇದನ್ನೆಲ್ಲ extract ಮಾಡಿ next page 86 ಅಲ್ಲಿ. It must be noted that in the case on hand, the plaintiff have not produced any document to substantiate or contention that only the 13 disputed voters who were cast their votes are not at all the congregation members and they are not nothing to do with the church activity. Further, it is to be noted that as per the bylaw, any dispute arises with respect to the election of pastorate committee, initially pastorate shall hand over the settle the dispute, then refer to the board of conciliation. If fails to settle the matter, board of conciliation, then refer to the bishop of the Dicos. Further, it is to be noted that the chapter 5 of the Constitution bylaw so and so, ಅದನ್ನೆಲ್ಲ extract ಮಾಡಿ page 87. In the case on hand, there is no materials available on record to show that the plaintiff has complied with the condition mentioned in chapter 5 of the Constitution of bylaws of the Karnataka Central Dicos of the Church of South India. Further, in the case on hand, there is no material on record to show that whether bishop has taken any effort to settle the matter or not. Even though the plaintiff has a remedy available in the Constitution and the bylaws of the Central Dicos Church of South India to settle the dispute, the plaintiff has filed a suit. Further, on perusal of the pleadings and the documents available on record, it is just necessary to direct the defendant return the officer to elections to pastorate committee to open the sealed 2 ballot boxes pertain to the elections for the pastorate so and so ಅಷ್ಟೇ. There was no reasons at all. ಇದನ್ನು ಯಾಕೆ ಓಪನ್ ಮಾಡ್ತೀವಿ ಅಂತ ಏನು ಹೇಳಲ್ಲ. ಒಂದು ಬ್ಯಾಲೆಟ್ ಬಾಕ್ಸ್ ಓಪನ್ ಮಾಡಿ ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮಾಡಿದ್ರೆ ನನ್ನ ತಕರಾರೇ ಇಲ್ಲ. So far as the disputed are concerned, I given the list of members, 20 are ineligible. Out of it, 13 have casted their vote. They have been kept in a separate ballot box. ಅದನ್ನು ಓಪನ್ ಮಾಡಿ ಅನೌನ್ಸ್ ಮಾಡಿ ಅಂತ ರಿಸಲ್ಟ್ ಕೊಡ್ತಾರೆ.
ಏನಾಯ್ತು, ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗೋಗಿದೆಯಾ?
ಇಲ್ಲ, ಆಗಿಲ್ಲ, ಇನ್ನೂ ಆಗಿಲ್ಲ.
ಹಿಂಗೆ
ಇದು ಬರೀ ಇದು ಚರ್ಚ್ ಇದು 3 yearsಗೆ ಕಮಿಟಿ ಮೆಂಬರ್ಸ್ ಇರೋದು
ಅಲ್ಲ. ದಿಸ್ ಆರ್ಡರ್ ವಾಸ್ ಪಾಸ್ಡ್
30th
August 2024.
10 days ಆಗಿದೆ ಅಷ್ಟೇ. 10 days ಆಗಿದೆ ಅಷ್ಟೇ. 30th August.
3rd of August.
ಅನೌನ್ಸ್ ಆಗಿಲ್ಲ ಅಂತ ನನ್ನ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಅನೌನ್ಸ್ ಮಾಡ್ಬೇಡಿ ಅಂತ ಕೊಡಿ ಅಷ್ಟೇ. ಆಗಿದ್ರೆ ಏನು ಮಾಡಕ್ ಬರಲ್ಲ.
ಬರ್ಕೊಳ್ಳಿ. Issue notice to the respondents. The petitioner is also permitted to serve copies of the petition along with annexures on the learned counsels representing the respondents before the trial court. Stop. Next para. Learned counsel for the petitioner plaintiff submits that having regard to the averments made in the plaint and the affidavit accompanying the application filed along with IA number 1 under Order 39 Rule 1 and 2 of CPC, the trial court passed an order
on
29/6/2024 that votes, if any, cast by persons mentioned in the voters list at
in the
serial numbers
in the memo dated 28/6/24.
ಇದರಲ್ಲಿ page number 55 ಅಲ್ಲಿ ಇದೆ. Have to be kept in a separate sealed box and result shall not be announced without further orders of the court. Full stop. Nevertheless, after the defendants entered appearance,
No, it is after hearing only the order has been passed. Thereafter an application was moved.
and they filed another application in IA number 3 of 2024 to direct the returning officer to announce the results by opening both the sealed both the ballot boxes, including the sealed box as was directed by the court earlier, the trial court has proceeded to pass the impugned order allowing the application and directing the returning officer to open the sealed two ballot boxes pertaining to the elections held on 30/6/2024 and directed that the votes shall be counted and results be announced. Full stop. Next para. Learned counsel submits that there is absolutely no reasons forthcoming from the impugned order, other than pointing out to the provisions of the bylaws of the church, which require disputes to be resolved, initially at the hands of the pastor and thereafter at the hands of the bishop. Full stop. Learned counsel submits that by passing the impugned order, the trial court has clearly come to the conclusion that there is no merit in the suit And the defendants have been given a free hand to go ahead and conduct the elections. Although it was pointed out earlier that non-Christians were also enlisted as members contrary to the bylaws, and they should not be permitted to participate in the elections. Full stop. Next para. Nevertheless, having regard to the fact that the impugned order was passed on 3rd of August 2024, there shall be an ad interim direction to the returning officer of pastorate committee of the respondent, St. Matthew's Church, not to announce the results, if not already announced. Yes, please.
Hearing interlocutory application, serial number 44. M. Venkatappa.
Pray for some time.
Huh?
2 days time.
Allama 2019 I'll file ಮಾಡಿದ writ petition.
2 days
Stay
time.
order ಇಲ್ಲ ಏನು ಇಲ್ಲ.
He's held up in portal 23. He's held up in portal 23.
No, does it survive for consideration?
Pass over.
No order of stay has been passed.
The stay is there, the stay is.
No, it has come up again for IA 1 of 2022 for stay. At the request of learned counsel for petitioner, release this matter on 24th of September.
Serial number 45.
This matter, I appear for the applicant, my lord, to implead me as a party. I am a defendant.
They've not served me a copy of the impleading application.
You don't
No,
have a copy.
impleading application was served by my. No, I am sorry. I will give one more because I appeared subsequently. My previous advocate, I think he must have served. Otherwise, he would have been noted.
He has not
Anyway, I have no objection for that. I will give one more. I entered appearance now.
I'll
My
file my objections to the application.
Learned counsel, Shri Y.K. Narayana Sharma is requested to serve a copy of IA number 1 of 2020 on learned counsel for the petitioner. Full stop. The petitioner is also granted a week's time after receipt of the copy of the application to file objections to the said application.
Interim order may be extended.
Interim order granted earlier stands extended till the next date of hearing.
Obligations.
46. Prasanna Kumar, yes. Answer.
If it is serial number 46, my lord,
No.
I am appearing for respondents, my lord, in this case.
Ah.
My lord, you will may kindly see what is challenged is annexure A.
For number 2, my lord.
In fact, we have sought for vacation of the interim order for this reason. 2 counter suits are filed. One by my lord, the petitioner before your lordship, my lord, another by Karnataka Road Development Corporation, for whom I am appearing for recovery of money. And my lord,
there is no one for the petitioner.
ಅಲ್ಲ ಹಿಂಗೆ ಆಗ್ತಾ ಇದೆ ಅದು ಬರೋದಿಲ್ಲ ಸ್ವಾಮಿ. In fact, my lord, 2 hearings we waited, they did not come, and the matter is this: 2008, my lord, suits are filed, money recovery suits, my lords.
ಬಂದ್ರು ಒಂದ್ ನಿಮಿಷ ಬಂದಿದ್ದಾರೆ. Yes.
Let's, we have engaged the senior counsel Where is been out of station, my lords. Kindly have it next week, my lords. It would be a,
At the request of learned counsel for petitioner, release this matter on 18th of September.
and kindly extend the interim order. my lords.
Interim order granted earlier stands extended to the next date of hearing.
Gratefully honored.
My lords, can I make one submission, my lords? Lords
Ah.
make additional further proceedings in the suit have been, my lord, held up on account of the interim order.
I'm listing it next week itself. We will
ಅಲ್ಲ,
consider.
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಅವ್ರದ್ದು IA for recalling the witness
We
was
can
filed. It
consider
was
and
not
dispose of the writ petition itself.
ಅಲ್ಲ,
No question of considering your interim application.
ಅಲ್ಲ
for-
ಕನ್ಸಿಡರಿಂಗ್ ಅಲ್ಲ ಸ್ವಾಮಿ, ಅದನ್ನ ಈಗ ಮ್ಯಾಟ್ರನ್ನೇ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡ್ಬಿಡ್ಬೋದಂತ.
Huh?
ಮ್ಯಾಟ್ರನ್ನೇ ಡಿಸ್ಪೋಸ್ ಆಫ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ವೆರಿ
ಅದನ್ನೇ
ಶಾರ್ಟ್
ಅದೇ
ಕ್ವಶನ್.
ಹೇಳ್ತಾ ಇರೋದು. I will dispose of the matter itself next week. Yes.
47. Rajaras.
Petitions in this case, my lord.
Yes.
This is an appeal, sorry, the petition filed by me, having aggrieved by the order passed by the court below, dated 24th January 2024, my lord. On my application filed under section 45 of the Indian Evidence Act to refer the disputed signature on the alleged fabricated will of late Beki Sujata, my lord. So I have filed this application, but the court below was dismissed my application by assigning no reason at all. Earlier, at the time of evidence, I have made an application under 11 Rule 14 for production of the original will. But that application was dismissed, saying that this is not the time to consider that application since already evidence is over. That is, on that ground, the application was dismissed. After conclusion of the entire evidence, my lord, I have made an application under section 45 because of the simple reason, my lord, the suit of the respondent for possession entirely revolves around that alleged fabricated will.
Let us see the reasoning.
Beg your pardon?
Let us see the reasoning.
Yes, my lord.
Page number 12. It's only a one paragraph.
Yes, one paragraph, my lord.
Yes.
Non-speaking order, point number 1, reasons. On perusal of the record, the suit is for eviction of the defendant from the property by directing them to quit and deliver the vacant possession. This court already rejected IA under order 11 Rule 14 of CPC. Again, the defendant number 2 to 4 filing the application under section 45 of the Evidence Act and states that the original will is with plaintiff to produce the same to lend it to the expert opinion, which has been dismissed from this court. With all these observations, IA filed by the defendant number 2 to 4 is dismissed. Hence, I answer point number 1 in the
The suit
negative.
for eviction.
Suit for
Question of
eviction.
considering title will not arise.
Yes, my lord. And possession also. Because and possession, suit for eviction
All
and
that the
possession
court is
filed by the
required to
opposition.
consider is whether there is a relationship of landlord and tenant.
No, not
Other than that,
not
it's a
landlord.
suit for eviction.
Eviction of the original owner, my lord.
ಹೌದ್ರಿ. The plaintiff has filed the suit
Yes,
seeking eviction of the dependents from the suitable property.
yes, my lord.
In a suit for eviction, what is required to consider is whether there is a relationship of landlord and tenant between the parties. Aste, no question of.
No, my
getting into
humble
the title.
submission, my humble submission to your honor is the relationship between the parties is brothers and sister.
Huh?
My brothers and sister, my lord. And my late father, one by name Krishnaraja Aras, executed a will on 1/9/2004, bequeathing this particular property in favor of the daughter, namely BK Sujata.
Yes, you are appearing for the plaintiff.
Yes, my lord.
How is it that you have filed a suit for eviction against your
The
sister?
fact, my lord, earlier, he filed the suit for bare injunction, all brothers.
Huh?
All brothers have filed the suit for bare injunction. That was dismissed
same-
against me only, my lord. It was dismissed.
ಹಾಕಿದ್ರಾ?
ಹೌದು.
Awesome.
ಯಾರು ಅವರು ಅಂದ್ರೆ?
These particular petitioners, my lord. That is all, I produced that suit, my lord, along with the-
Plaintiff.
ಹೌದು.
ಶ್ರೀಮತಿ BK Shanti Nagaraju.
ಹೌದು.
Only one person.
Yes, my lord.
He is seeking eviction of all the other
Yes,
sibling-
that, not
brothers.
brothers, that is wrong, incorrect submission. He filed the
submission
suit,
only.
all these
You are
particular,
the plaintiff.
yes, my lord.
You are the plaintiff.
Yes, my lord.
You are seeking eviction of all the other defendants.
Defendants, they are not related to the suit schedule property. Their properties are different, my lord.
They will not be related to the property. They are related to you.
Of course, my lord, they are related to me, but the fact, my lord, on OS number 6326/2015, these particular petitioners have filed the suit for bare injunction. And on the basis of the will, my lord, all these particular, their suit was dismissed. My will was probated, my lord. That is also produced before this honorable court. No, sorry, in the suit for possession. On basis of that particular probate, I filed the suit for the possession of the property. And my lord, in that particular things, I have approached after death of BK Sujata, I have approached the corporation authorities for change of kata, all those things, objections does not considered, and they have not proceeded about it. After this one, my kata, tax paid, everything is standing in my name, my lord.
Please come to Annexure B is your plaint. Annexure B is your
Yes,
plaint.
yes, my lord. Yes, my lord.
Please read paragraph number 4.
It is submitted that the plaintiff is only the absolute owner and entitled to get lawful possession of the suit schedule property bearing number 2, old number, and new number 109, ground floor built up area 198.44 square meter, residential house situated at 10th Main, 3rd block, Jayanagar, Bangalore, PID number 59-18.
Boundaries ಎಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಆಮೇಲೆ
And bounded on these particular things, man. Herein after as future, as
It is
well as
submitted.
revenue
Next para.
records are also standing in the name of the plaintiff in respect of the suit schedule property.
Please read the next paragraph.
It is submitted that the first defendant is Little Lily Guest Suits Private Limited, represented by its director Melville Rose, and second and third and fourth defendants are threatening and making unlawful claim that the defendants are directors of the first defendant, Messrs. Little Lily Guest Suits Private Limited. However, the defendants are in lawful possession of unlawful possession of the suit schedule property after the death of BK Sujata, and the defendants are the trespassers. The said BK Sujata had conveyed the right title and possession of the suit schedule property through the will dated 9/4/2014, and property was bequeathed to the plaintiff after demise of Srimati BK Sujata, and said BK Sujata died on 10/3/2014. The copy of the death certificate BK Sujata is produced at Annexure A. The copy of the will dated 9/2/2014 executed by the said BK Sujata in favor of the plaintiff is produced at Annexure B. Subsequently, the Honorable Court was also granted probate in favor of the plaintiff, and revenue records are also standing in the name of the plaintiff in respect of the suit schedule property. The copy of the probate is produced at Annexure C. The copy of the encumbrance certificate in respect of the suit schedule property is produced at Annexure D. The copy of the kata certificate is produced at Annexure E. The kata extract in respect of the suit schedule property is produced at Annexure F. The copy of the tax paid receipts towards the suit property is produced at Annexure G. The said facts are also well known to all the defendants, since the defendant number 2 to 4 are relatives of the plaintiff. After death of Srimati BK Sujata, the defendant number 2 to 4 have colluded with the director of first defendant company and planned to knock away the suit schedule property and trespassed into the suit schedule property. Originally, the suit schedule property was let out to the first defendant company by B.K. Sujata. And B.K. Sujata used to collect rent and all other benefits income from said first defendant company. The said Welvin Rose had 49% share in the first defendant company, and B.K. Sujata is having 51% of the share in the first defendant company till her death. And said B.K. Sujata also bequeathed the entire 51% share of the defendant company in favor of the plaintiff in accordance with law. The plaintiff is only having lawful rights over the 51% of the shares holder in the defendant company, and defendants have no shares lawfully acquired from the first defendant company. The said Melvin Rose has committed several unlawful and criminal acts and even misappropriated huge amount of the defendant company. There is also a complaint by the plaintiff, and copy of the same is produced at annex.
Please come to paragraph 7.
It is submitted that the second defendant, defendant number 2 to 4 have suppressed the true fact and filed OS number 6326/2015 before the City Civil Court, Bangalore, for permanent injunction by making false allegations against the plaintiff and also made false claim in the suit schedule property. After service of the notice, plaintiff is also filed the written statement and contesting the said suit. All other unlawful and illegal acts of the defendants are reserved and same will be disclosed in appropriate proceeding. Defendants are not having any right.
What happened to that suit?
That suit was dismissed, filed by them.
That suit was dismissed
1
only
minute,
because of
sir.
there is a dispute.
I will
with
make the
title.
submission.
Not in regard to position. That was dismissed on the ground that the title of the property is in dispute. Not regarding position. Position is they themselves admitted.
So you had filed only a suit for permanent injunction.
Yes, ma'am.
Yes, ma'am.
So therefore it was dismissed.
Therefore, it was dismissed
Yes.
on the ground that.
Then what did you do?
Nothing.
No, nothing. Because since the comprehensive suit is pending.
And
No question of
since comprehensive
no
suit.
question of sending the document for consideration of the expert in this suit.
My humble submission, my lord. Humble submission, my
humble
lord.
submission to your honor is the entire suit revolves for possession, revolves around the alleged will dated 9/2/2014, allegedly executed by B.K. Sujata.
Rejection against the company.
Rejection and possession.
That is,
Please
they are the
understand,
share
said
of that.
Suit for rejection against the company.
No, against us, the company is no more in existence.
If you have any right, go seek a declaration. There you can ask all this,
My lord,
not in a suit for rejection.
no, my lord, my submission to your honor
My
is,
humble
company is
submission, my
not in
lord.
existence now. We are in the property.
So
We have
after
let out,
dismissal of the suit for bare injunction, you have not taken any steps to get a declaration in your favor.
because it was
That question cannot be considered in a suit for rejection. Not possible.
no, my respectful
Moreover,
submission to your
my
honor
lord, there
is.
is a
Because one submission ಕೇಳ್ಬಿಡ್ತಾವ ಆರ್ಡರ್ ಮಾಡಿ ಸ್ವಾಮಿ.
ಹೇಳಿ.
My respectful, because during the pendency of this particular suit, 154 of 2018, I have obtained a handwriting expert's opinion from the handwriting expert. I have produced the document wherein he has categorically stated that the signature of late B.K. Sujata is not tallying.
This civil court cannot go into all these aspects. There is a probate obtained by this person already.
Yes, my lord.
Probate,
Yes,
I have challenged the probate.
They have challenged
It is in
it, get
dispute.
an order of stay. All this cannot be considered in this suit for rejection. Not possible. But
ಸ್ವಾಮಿ ನನಗೆ handwriting expert opinion
take
ಬಂದಿದೆ.
steps in accordance with law, not in this suit.
ಅಲ್ಲ ಸ್ವಾಮಿ ಅವರಿಗೆ ಫ್ಯಾಬ್ರಿಕೇಟೆಡ್ ಫೋರ್ಜ್ಡ್ ವಿಲ್ ಅದು.
I am sorry, my lord.
Opinion ಬಂದಿದೆ
You have
ಸ್ವಾಮಿ.
said
Yes, it is a
you
fabricated
have
will
questioned
ಅಂತ.
you have questioned the probate.
Yes, sir.
Not yet,
Go and
not
get
yet.
all that information from there in that suit, not in this suit for rejection. No.
ಅಲ್ಲ questioning the probate before the Honorable High Court of Karnataka, not before the trial court.
ಎಲ್ಲಾದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ, you get an order of stay there.
So that is right.
All
Because
further proceedings,
since
get
it is
it
a suit
stayed.
for possession.
In this case, no question of sending the document for expert's opinion, not possible. ಬರ್ಕೊಳ್ಳಿ. the petitioners or defendants in OS number 154 of 2018 filed at the hands of respond number 1 herein. Full stop. The suit is filed seeking directions to the defendants to quit and deliver vacant possession of suitable property to the plaintiff and for permanent perpetual injunction restraining the defendants from interfering in the peaceful possession and enjoyment of the plaintiff in the of the suitable property. Full stop. Damages at the rate of rupees 1 lakh per month from the date of the suit, along with future interest at the rate of 18% per annum, is also sought by the plaintiff. Full stop. In the said suit, an application is filed by the petitioner defendants invoking section 45 of the Indian Evidence Act. To refer and compare the signatures of deceased B.K. Sujata in the alleged will dated 9/2/2014 to be compared with the signature of Srimati B.K. Sujata found in the original partition deed dated 26/2003 for expert's opinion, regarding the genuineness of the alleged signature of Srimati B.K. Sujata. Full stop. The trial court held that an application earlier filed by the defendants under Order 11 Rule 14 of CPC was dismissed by the trial court, and therefore such an application cannot be once again entertained at the hands of the defendants. Full stop. Next para. Learned counsel for the first respondent plaintiff further submits that earlier the petitioners herein had filed a suit in OS number 6326 of 2015 before the City Civil Court at Bengaluru, seeking permanent injunction in respect of the suit schedule property, against the
all
respondent
petitioners.
here.
All petitioners.
Full stop. However, the said suit was dismissed.
Yes.
On
27 June 2019.
On the ground that the respondent herein raised question of title and contended that she is the true and absolute owner of the suit schedule property, and therefore such a suit for permanent injunction cannot be maintained against the true owner of the property. Full stop. Learned counsel would therefore submit that even after dismissal of the said suit, no action was taken by the petitioners herein to seek declaration, more so in the light of the claim of the first respondent under the will said to have been left behind by Srimati B.K. Sujata. Full stop. Moreover, it is stated in the plaint that a probate has been obtained by the first respondent plaintiff in respect of the bill left behind by Srimati B.K. Sujata. Full stop. That being the position, it is contended that in a suit for ejectment filed by the plaintiff, such an application seeking expert's opinion in respect of the signatures of Srimati B.K. Sujata is not permissible, since in a suit for ejectment, what is required to be considered is whether there is relationship of landlord and tenant between the parties. Full stop. Question of title cannot be gone into in a suit for ejectment. Full stop. Next para. For contra, learned counsel for the petitioners submits that they have obtained an expert's opinion and it is found that the alleged will does not contain the signature of Srimati B.K. Sujata.
Yes.
Full stop. Next para. If that is the contention of the petitioners, they had to take steps consequent to the dismissal of the earlier suit for questioning the alleged probate obtained by the first respondent in respect of the will said to have been left behind by Srimati B.K. Sujata. Full stop. This court is also of the opinion that the law is well settled that in a suit for ejectment, the court is only required to consider whether there is relationship of landlord and tenant between the parties. Question of title cannot be gone into in a suit for ejectment. Full stop. The petitioners will have to approach the competent court or forum to redress their grievance insofar as the alleged will said to have been left behind by Srimati B.K. Sujata.
And
submission, may make a submission.
In that view of the matter, this court is of the considered opinion that the application filed by the petitioners under section 45 of the Indian Evidence Act to refer the documents and verify the signature, comparing the same in two documents to expert's opinion, is not permissible in a suit for ejectment. Full stop. Next para. Consequently, the writ petition stands dismissed.
One submission by that. So far as the expert opinions report is concerned, he has made an observation in the report that the opinion of the handwriting expert, the person who wrote blue enclosed signatures marked A1 to A20 did not write the red enclosed signatures marked Q1 to Q5. As a ಮೇಲ್ಗಡೆ note ಅಂತ ಮಾಡಿ, since only
all that cannot be gone into in this suit, you will have to file a separate suit for that or challenge that probate that he has obtained.
If law permits, my lord, already long back it has taken place.
Now the matter is shut down for
2014, my lord.
So if it takes a judgment and decree, how can I file all these things for me?
Sir, you will have to file a separate suit.
Also, separate suit filed ಮಾಡ್ತೀನಿ.
Yeah.
ಈಗ now this suit
The
for
main ground is for ejection of the company that is admitted the lessee in the suit.
Swami,
schedule from premises.
company is no more in existence. Only petition number 2 to 4 are in position.
There is a
That is
detailed
by
cross-examination on that aspect.
Suppose if they succeeded the suit voice 154 of 2018.
Sir, in the meanwhile, you have to already take steps. If the suit was dismissed in the year 2019, what are you doing till date?
No, because it is a settled principles of law. When there is a number of citations are there, both at the Honorable High Court and Supreme Court, saying that when title is in dispute, no injunction can be granted. Appeal ಹೋಗಿ ಸ್ವಾಮಿ
ಹಂಗೇಳಿ dismiss ಮಾಡಿದ್ದಾರೆ.
ಹೌದು ಸ್ವಾಮಿ.
But you have not taken any
ಸ್ವಾಮಿ
step.
appeal ಹೋಗಿ ಏನ್ ಪ್ರಯೋಜನ? Because settled principles
Appeal
of law ಇದೆ.
ಅಲ್ಲ. You will have to file a suit for declaration.
ಅಲ್ಲ ಅದು ಸರಿ ಸ್ವಾಮಿ.
Only you can raise all this issue.
ಅಲ್ಲ
In a
ಈಗ
suit
ನಾನು
for declaration, you should raise all this issue. Not in a suit for ejectment, not permissible. Yes.
This number 4. Further reading, serial number 1. Locational.
Make one section. Respect to serial number 51, your lordship, that continuously it is coming every week, but it is not reaching your lordship, because I have paid the money into, I'm a third party auction purchaser, your lordship. I paid the money in 2021, your lordship. Any date which, because of humble submission, your lordship, continuously ಬರ್ತಾ ಇದೆ ತಮ್ಮಂದೇನೆ reach ಆಗ್ತಿಲ್ಲ.
2024 matters.
ಅದೇ ಅಲ್ಲ, I have
ನೋಡಿ ಇನ್ನೊಂದು ವಾರ ಹೋಗ್ಲಿ ಮುಗಿಲಿ, otherwise it's not.
I have paid the money in
I can't
2021.
give date in any of these matters.
Lordship, kindly appreciate your lordship. Auction purchaser.
ಎಲ್ಲರಿಗೂ urgency ಇದೆ, but please understand, ನಾನು ನಿಮ್ ಒಬ್ರು ಕೊಟ್ರೆ ಎಲ್ಲರೂ ಕೇಳ್ತಾರೆ. Not possible. Yes.
May I make one submission, my lords? My lord, serial number 45 or 48, 48.1, my lords, it's been mistakenly connected to the matter. 48.1.
Huh?
48.1. It's been mistakenly connected, my lords. It may kindly be de-linked, my lords.
Anyone appearing for the parties?
8.5. Education matters.
ಅದೇ this 48.1 WP number 8241 of 2024
Please, ma'am.
has got nothing to do with the other petitions. Correct?
Can it be delinked?
Can be deleted. 48 ಅಲ್ಲಿ delete WP number 8241 of 2024 from the other matters, since it is submitted that the said writ petition has got nothing to do with the other connected writ petitions. Yes.
Much obliged.
It is number 52. Number 52.
No dates.
The entry matter.
No. There is no need to extend now, sir. If the matter reaches, if any order is passed.
What happens, last time it was not reached, but in the website it is not, only least next week, my lord, entry matter was not written. That is why I mentioned.
ನಾವು ಆತರ ಎಲ್ಲೂ ಬರೆಯೋದಿಲ್ಲ ಸರ್. ದಯವಿಟ್ಟು ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ.
I'm sorry, madam.
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೆಂಗಿರುತ್ತೋ ಹಂಗೆ ಇರುತ್ತೆ.
ಇಲ್ಲ ವೆಬ್ಸೈಟ್ ಅಲ್ಲಿ ತೋರಿಸ್ತಾ ಇದೆ.
You will not do that.
Daily orders ಅಲ್ಲಿ.
Point number
Yes.
1. Challenge the ex parte order, my lord.
No. Please start with the other matters.
Please.
Yes.
Please.
This number 4. The reading.
That's now. I'll just address, my lords, the main argument with
Yes.
regard to local self-government units.
Yes.
Let's kindly see the BBMP Act for a minute. Lords, definition section 211.
Chief Commissioner.
Chief Commissioner means the Chief Commissioner appointed under section 63 and includes a person appointed to act as the Chief Commissioner under section 71. Then, my lords, 218, Corporation Administrator means an officer appointed by the state government to exercise the powers and perform the functions and discharge duties conferred or imposed on the corporation by or under this act. Now, my lords, kindly see section 3, my lords, Corporation Authorities. The following shall be the authorities of the corporation.
who shall carry out the provisions of the act. Namely, Brihad Bengaluru Mahanagar Palike, that's the corporation, the mayor, the chief commissioner, the zonal commissioner, the zonal committees, the standing committees, the ward committees, area sabhas. So the chief commissioner is also corporation authority. Now, my lords, the main charging section is section 142.
ಯಾವ್ದು?
142.
Ah.
142 minutes. Notes, this has been amended. I'll just read this notes. Kindly see, subject to general and special orders of the government, the corporation may impose the following taxes at rates not exceeding those specified in the act. Now it is the corporation, my lords, which is entitled to impose the taxes. The provisions, my lords, with regard to demand and collection and realization, my lords, is a different aspect of the matter. It is a corporation which is entitled to. Now, my lords, this has been 142 has been amended
to impose.
Please, my lords. To impose, may impose, my lords, may impose. Now, 142, my lords, we have amended, my lords, in the latest amendment.
Powers are vested with the corporation.
Powers are vested
to
with
impose.
Please, my lords, I'm coming to that. Powers are actually vested with the corporation under the provisions of this act because 142 is a charging section.
Correct.
Now, my lords, in 142, we have in the heading, my lords, there in chapter 3, instead of taxes, my lords, now we have said taxes, comma, levy, fee, levy, charge and demand by whatever name it may be called. That has been substituted.
Yaudu?
Chapter above 142, there is chapter 13, my lords.
Correct.
Heading.
Yes.
Other taxes anta ide.
Yes.
That has been substituted as taxes, after taxes, comma, fee, levy, charge and demand.
Yes.
By whatever name called.
Yes.
And then, my lords, in subsection 1, after the word taxes at following taxes at rates anta idella. After that, my lords, we have stated
amended notification. ಎಲ್ಲಿ ಅದು 2022 ತಾನೆ?
No, minutes. 24 amendment.
24.
Let's get it, minutes. Second page. In section 142.
Yes, yes.
In the heading, after the word taxes, the words and punctuations fee, levy, charge and demand, or by whatever name it may be called, has been inserted. And my lords, in subsection 1, after the words taxes at rates, which comes that follow impose the following taxes at rates. Taxes, comma, fee, levy, charge, demand, or by whatever name it may be called at such rates shall be substituted. And then, my lords, we have added D Roman I, Roman 1, any small Roman 1, my lords, any fee or levy or demand or charge for permitting building constructions. So, my lords, in the charging section, it is a corporation, my lords, itself. Corporation means the body here, that is the elected body.
Yes.
That is entitled, my lords, to impose the taxes.
Correct.
Now, my lords, insofar as the chapter under which, my lords, 240 comes, 240, my lords, is a separate chapter. This is the main charging section. This is the main section, my lords, which empowers. Kindly now, my lords, see to chapter 16.
Regulation of
Building, including town planning.
Correct.
So we have inserted that it is under the any fee or levy or demand or charge for permitting building construction has been inserted in 142 DI, and my lords, that is by the corporation. subject to the general and special orders. Now, in this chapter with regard to regulation of building, including buildings, including town planning, 240A has been inserted, which provides, my lords, for and read with the amendment, 240A, read with the amendment, where, my lords, earlier it was, I'll just read 240, my lords, if it is in the book there.
Earlier was chapter 13.
Earlier was chapter 13.
13.
13 minutes. This is chapter 16.
Yes.
Notes here, that book contains 240A, my lords.
Yes.
Please, my lords. I'll just read. This is unamended. 240.
240?
Yeah. The chief commissioner may grant such permission.
Yes.
So he is only the person granting the permission to execute the works together with the site plan of the land, ground plan, elevations and sections of the building, subject to such restrictions and conditions as may be specified in the bylaws, or he may refuse to grant such license subject to the conditions specified in section 244. Now kindly see 2, my lords. The chief commissioner, while fixing the rates for levy of the fee or penalty, shall consider all the costs related to the issue and execution of the approval as he may deem fit. Now, my lords, yesterday, why I am pointing out this out is, I have made a submission that if there is a broad correlation with regard to the fee that is being collected across the entire Bangalore metropolitan region or Bangalore Municipal Corporation region, and, my lords, the service that we are rendering, subject to what the BBMP has to say. Now, kindly see 3, my lords. The chief commissioner may, for approving or sanctioning the plan or grant of commencement certificate or a completion certificate, charge and levy the following fee at such rate based on the guidance value fixed by the Department of Stamps and Registration under the provisions of the Karnataka Stamp Act, namely. And now, my lords, A, B, C, D, E, F has been substituted with a new thing. Now we have given the limits. Now, my lords, the authority under the act for the chief commissioner is like the chief executive officer. He is the executive head. But the corporation is the elected body in terms of the provisions of the constitution.
Chapter 13.
Please, my lords.
Power is vested with the corporation.
With the corporation. I'm coming to that, my lords.
They are releasing.
Please, my lords.
The charging section.
Please.
Empowers the corporation.
Please, my lords.
To do all that.
All that. Please.
To fix a rate, impose, and all that.
Please.
But contrary to that, the power of not only charging and imposing, both are given to the chief commissioner under this chapter.
Fixing and imposing.
Correct.
Please.
That is the allegation.
Please, that is the allegation. How it has to be read, because both the provisions have to be read harmoniously in tune, my lords, with the chapter on municipalities, my lords, in the constitution, where it provides for local self-government. Now, my lords, this similar provision also, my lords, was there in the Bombay Municipal Corporations Act. It has been adopted. It has been interpreted. I'll just read the judgment. My lords, insofar as A to now, earlier, one of the arguments was with regard to excess of delegation.
No, if this issue has been raised and answered by the Supreme Court, we'll go
not the Supreme, Bombay High Court.
Bombay High Court.
Please. But they have referred to one Supreme Court judgment also, which has relevance.
All right.
But that is in the context of 243 W and X.
Let us see.
Please, my lords.
Yes.
So, my lords, one submission here that the commissioner here is entitled to, my lords, collect taxes only which are approved by the corporation.
Charge and collect.
He can.
You read the provision
Please,
again.
my lords. He can. In fact, it says the provision says he can. If I will. 240. Notes it also uses that may for approving the so and so charge and levy.
Correct.
Charge and levy the following fee at such ready. So, my lords, he is the person, my lords, who will be charging and levying. But the rate at which it is going to be charged has to be, my lords, by the approved by the corporation. Without that approval, my lords, it cannot be done. Now, my lords, when the body is not there, then, my lords, it is the administrator who exercises the powers of the 8 committees, my lords, under the provisions of the Act.
No, not that.
Please, my lords.
Not that.
But without this judgment says everything has to be read harmoniously. It is whatever the municipal commissioner actually levies, it has to pass through the muster of the corporation itself, the elected body. I'll just take my notes to the panel.
Yes.
Milords, para 36.
Such contention was raised in this writ petition?
Please, in
One that
Bombay,
you are
please, please,
reading.
Milords.
Yes. Yes.
It was in a slightly different context, but it was in the, it was in the context of a tax, not of a fee, Milords. In Bombay tax under the, but provisions are similar.
All.
Milords, para 36, Milords. Similar contention was raised and the court, I'm not reading, Milords, the contentions.
Yes.
I'll straight away take, Milords, to the
Yes.
reasoning portion. Para 36. For properly appreciating the rival contentions, we would first make reference to the position and status of the municipalities under the Constitution of India. Part 9A of the Constitution of India contains the provision regarding the municipalities. Article 243 contains the definition, and insofar as a term municipality, Article 243 PE defines the term to mean an institution of self-government constituted under Article 243Q of the Constitution of India. Article 243Q deals with Constitution of Municipalities, whereas Article 243R deals with its composition. The constitution and composition of ward committees, etc. is dealt with by Article 243S and 243T provides for reservation of seats. Article 243U provides for duration of municipalities. 243V deals with disqualification of members. Then comes 243W, on which strong reliance is placed by Ms. Karnik, which reads as under. Let's, we have read that 243.
Yes.
Now, para 37. Upon a bare perusal of the same, it is evident that subject to the provisions of the Constitution, it is the legislature of a state and which may by law endow the municipalities with such powers and authority as may be necessary to function necessary to enable them to function as institutions of self-government. That law may contain provisions for the devolution of powers and responsibilities upon the municipalities, and that is how various aspects of planning, economic development, social justice, and functions and duties in relations thereto have to be performed by the municipalities. They have been entrusted to them. There is force in the contentions of Ms. Karnik that the provisions of every law and by which the powers, authorities, and responsibilities have been endowed on the municipalities must be construed in such a way so as to make existence of the municipalities meaningful and purposeful. That it is an institution of self-governance is therefore abundantly clear. That such institution must have certain freedom, autonomy, and independence is also apparent. However, her arguments overlook the fact that it is the state which has to make the necessary law. Even in terms of this constitutional scheme, the law-making power of the state is untouched. The power to impose tax by and funds of the municipalities is granted under 243X that reads as under. I'll skip that, my lords. Para 38. Therefore, what we have held above gets further reinforced and supported by Article 243X of the Constitution of India. It is the legislature of a state and which makes the law by which municipalities are authorized to levy, assess, collect, and appropriate such taxes, dues, tolls, and fees in accordance with such procedure and subject to such limits. There can be assignment of duties to the municipalities. The state government may assign to a municipality such taxes, dues, tolls, and fees levied and collected by the state government for such purpose and subject to such conditions and limits. Therefore, when the legislature of the state has to endow the municipalities and by law with power and authority so as to enable them to function as institutions of self-government effectively, then that position is in no way affected merely because the law authorizes the state to impose the taxes. Merely because the state has such power in terms of the law of legislature does not mean that by itself such law or any provision therein would fall foul of the constitutional mandate. But enactment of section 127 of the said act alone, the independence of the municipalities is in no way affected. Chapter 9 of the said act deals with municipal taxation. The law itself states that the corporation shall impose a tax, namely property tax, tax on vehicles, boats, and animals. Pertinently, subsection 1 of section 127 of the said act is not in any way challenged, and on the ground that the provisions therein encroach on any power of the municipality or taxation. Eventually, the municipality derives its power and authority to impose a tax from the law made by the legislature. That such law obliges the corporation to impose a property tax and tax on vehicles, boats, and animals, therefore cannot be said to be encroaching on its independence and autonomy. Now, let's the rest of the para I'll skip notes. Now, let's make kindly see para 42 minutes. In that page itself, last 2 lines, that under the framework of the Indian Constitution. That under the framework of the Indian Constitution, only 2 principal bodies which have been vested with the plenary power to make laws, they are the Parliament for the Union and state legislatures for the state. In New Delhi Municipal Committee versus State of Punjab reported in so and so, the Honorable Supreme Court held as under. We have great difficulty in accepting this assertion. Article 265 of the Constitution emphatically mandates that no tax shall be levied or collected except by authority of law. Under the framework of the Constitution, there are two principal bodies which have been vested with plenary powers to make laws, those being the Union Legislature described by Article 79 as Parliament for the Union, and state legislatures which are described by Article 168 in the singular as legislature of a state. While certain other bodies have been vested with legislative power, including the power of levying taxes by the Constitution for specific purpose, as in the case of district committees and regional council constituted under the aegis of the 6th schedule of the Constitution, the plenary power to legislate, especially in matters relating to revenue, still vests with the Union and the states. Even if the submissions that municipalities now possess under Part 9A of the Constitution, a higher jurisdictional status is correct. The extension of that logic to the proposition that they have plenary powers to levy taxes is not and is clear from a perusal of relevant part of Article 243X of the Constitution. Article 243ZB provides that this provision will be applicable to union territories, and the reference to the legislature of a state would apply in relation to union's territory having a legislative assembly to that legislative assembly. It is therefore clear that even under the new scheme, municipalities do not have an independent power to levy taxes. Although they can now be granted more substantial powers than ever before, they continue to be dependent upon their parent legislatures for the bestowal of such privilege. In the case of municipalities within state, they have to be specifically delegated the power to tax by the concerned state legislature. In union territories which do not have legislative assemblies of their own, such a power would have to be delegated by parliament. Of the rest of those who have legislative assemblies of their own, would have to be specifically empower municipalities within them with the power to levy tax. We have already held that despite the fact that certain union territories have legislative assemblies of their own, they are very much under the supervision of the union government and cannot be said to have an independent status. Under our constitutional scheme, all taxation must fall within either of the two categories, state taxation or union taxation. Since it is axiomatic that taxes levied by the authorities within a state would amount to state taxation, it would appear that the words or by any authority within the state have been added into Article 285(1) by way of abundant caution. It could also be that these words owe their presence in the provision to the historical reasons. It may be noted that Section 154 of 135 Act was similarly worded. The fact that Article 289(1), which in its phraseology is different from 155 of 1935, having been drafted by the drafting committee to make specific, does not contain similar words, will not in any way further the case of the appellant, because the phrase union taxation will encompass municipal taxes levied by the municipalities in union territories. Now, my lords, kindly see para 48. This is where they made it workable, where, my lords, even if it is a commissioner or the state government which imposes certain things on the corporation, they have said as a...
Ultimately, it becomes a farce.
Please, my lords.
It becomes a farce that there is a provision in the Constitution.
Please,
saying that the power should be vested with the municipality.
Please.
But in reality, it is vested only with the government. Ultimately, it is the state legislature which takes the decision.
Please.
And usage of the word municipality or chief commissioner will have no effect.
Please.
That is what it is.
Please.
All right.
But then in 48 and 49, what they have said is that suppose the state government, there is an obligation on the corporation to levy taxes.
Even if they use the words municipality, corporation.
Please.
In section 142.
Please.
It's of no consequence because ultimately the law should be made by the legislature
itself. Please.
Therefore, even if they have used the word corporation there,
please,
it does not signify anything. But because ultimately it is the state government legislature which is levying all this, making the law
with regard to levy. Because under the Constitution, either the union or the state legislature.
That is why I said it's a farce then.
Farce.
Having such a provision in the Constitution and not giving effect to it.
Please.
There is a meaning.
What they have done here is,
by progressively such amendments are being brought to the Constitution. By emphasis being laid for decentralization, for local self-government.
Please.
Andre, the meaning is that you should leave it to the people themselves to decide what should be, how it should be.
How it should be done.
Therefore, if they are saying local self-government should be given more power, to decide all these things. Then in the council of the corporation,
Please.
when these things are discussed, it should fall out of that discussion. If they want to bring about any amendment, some change to the structure of the taxation, rates, other things, have to actually be discussed there in the house.
It has to be discussed. And
Maadi, our recommendation kalisbeko. See, that is the meaning.
please,
Otherwise, there is no meaning at all to these words employed in the constitutional provisions. By reading this judgment,
Please.
what we can understand is, irrespective of what is
the power to
stating,
levy is only in the legislature.
ultimately it's the state legislature only which takes the decision.
Please.
Because law can be made only by the state legislature.
Pay the taxes.
Yes.
Please, Millards, that is only insofar as the taxes portion is concerned, because taxes is governed under the article of the constitution which says it's only by except by way of authority of law.
Correct.
Authority of law has been interpreted to mean either by law made by the parliament or by the state legislatures. Now, Millards, 48 and 49, they try to harmoniously construct. Here, what happens is in the present case, just Millards, by virtue of this amendment, we have said it shall be based on the guidance value not exceeding 0.30%. Now, not exceeding 0.30%, it could be a small portion of that. It could be 0.29% also. It could be 0.15. That is where, Millards, the role of the municipal corporation comes. They have to decide, subject to the limitation that has been given, not exceeding 0.30% is the ground rent, and 0.25%, Millards, is with regard to the other levies. So the maximum percentage is provided by the legislature. Even they can decide to do it 0.1% also. It is left to the discretion. That is where, Millards, in 48 and 49, there is some discussion, Millards, how it has to be harmoniously. We do not find any basis. There was an apprehension that was raised, Millards, in that case, by the petitioner council, that this is the state of affairs that they, as my lords pointed out, that the entire concept of self-government is taken away by virtue of this 48, Millards. We do not find any basis for this apprehension. These submissions overlook the provisions of the said act. The said act firstly sets out the definition of corporation. The corporation is defined in the constitution itself. It is an entity which comes into being in a larger urban area. The constitution of the corporation is set out in section 3 of the said act. The municipal authorities and charged with execution of the said act are those set out in section 4. One such municipal authority is a municipal commissioner. However, the corporation by itself is understood as a body corporate having perpetual succession and a common seal, and by such name may sue and be sued. It consists of elected councillors, and its composition is in terms of section 5. The powers of the municipal corporation and that of the commissioner have to be exhaustively referred. In that regard, one cannot lose sight of the fact that the management of the local affairs is with the corporation. It is in the general body of the corporation that such power vests. The commissioner, being one of the authorities specified by the said act, thus cannot be held to be a parallel authority and by himself. What the said act envisages is, it shall be incumbent on the corporation to make reasonable and adequate provision by any means or measures by which it is lawfully competent to use or take for the matter specified in section 63, and for the matter specified in section 66, it may use all its discretion and provide from time to time either wholly or partly for all of any of the matters therein. The performance and of the functions and duties imposed or assigned to the corporation under the said act or any other law for the time being enforced by the state government and any other authority can be discharged either by the corporation by itself or subject to such directions as may be issued, and in terms of the conditions as may be determined by the state government, cause it is to be discharged or performed or implemented by any agency. It is in this circumstance that one must note section 67 of the said act, by subsection 1 thereof, respective functions of several municipal authorities shall be such as are essentially specifically prescribed by or under the said act. Except as otherwise expressly provided in the said act, the municipal government of the city vests in the corporation. There is therefore no force in the complaint that the commissioner will override the corporation or ignore it or brush aside its decisions, leave alone the views. When the general body expresses itself and by means known to law, then the general body proposals, views and suggestions have to be communicated by the commissioner, and that would constitute the proposals of the commissioner. If the commissioner does not independently hold any view on the local body tax or on any aspect thereof, then he must forward the views, suggestions and communicate the decisions of the general body to the state government by incorporating them in his proposal. In other words, the proposals of the commissioner would contain the decisions taken by the general body at its meetings, views and suggestions incorporated in the resolutions of the general body passed from time to time, and equally those of the authorities who are put in charge of the matters and which are specified by the said act. Once this is the scheme of the municipal law and it is understood in this matter, so also in this perspective, then there is no warrant or basis for the apprehension expressed by so and so. Para 50 minutes. Eventually, if the municipal governance vests in the corporation and it is taken to be a representative body of the people residing within its limits, then it is a voice of the people themselves. They speak through the representatives. Ignoring the municipal corporation would mean ignoring the residents themselves. By no stretch of imaginations, any of the provisions and which are attacked by the petitioners can be so read as taking away this position and status of the municipal corporation. It's a body corporate representing the people. It is a government at the municipal level. Once it is charged with the municipal governance and it vests in it, then it is performing a public duty and therefore it is expected to act in public interest and for public good. So this is how, my lords, now 53, my lords, last two paragraphs, 53.
Yes.
Therefore, we are of the view that whenever the state calls upon the municipal corporation to levy the local body tax, it's not imposing it on the municipal corporation, but reminding it to levy, assess and collect a tax which is more friendly and serving all people, including traders. That the local body tax has to be then levied, assessed and collected by the municipal corporation does not mean that the state takes a unilateral decision in all matters connected with the levy. Though the state takes a decision, the municipal corporation is not overlooked and as understood above. Therefore, the determination of the rate of levy, selection of articles and goods, manner of levy, assessment and recovery though controlled by the state, but the municipal corporation has a definite role to play in the same. Its role is by no means diluted, diminished. It is eventually the local body tax and to be levied, assessed and recovered by the local body. Therefore, the state government being empowered by the various provisions noted above to direct, levy, to regulate and control its assessment and recovery does not mean that the autonomy and independence of the or status and position of the municipal corporation is in any manner threatened, leave alone, defeated or frustrated. If all these provisions are read together and harmoniously and understood in the above perspective, then there is no hesitation in rejecting the submissions of the petitioners to the contrary. We are in agreement with so and so that the constitutional scheme is in no affected by the amendments made to the said act. So, my lords, finally, it was so the amendments were upheld. It was similar in nature. So my respectful submission, my lord, says that if the provisions, my lords, it is the corporation itself which is entitled, my lords, only the limit has been prescribed in the amendment. Earlier, my lords, the argument was with regard to the excessive delegation. Excessive delegation, my lords, was they said it is vested, the powers are vested in the commissioner itself. As the unamended 240 stood, my lords, 240A stood. When it is read, my lords, without reference to the amendment, a prima facie case could be, it would look, on a prima facie reading, my lords, it would look that there was a case of excessive delegation. Therefore, my lords, amendments have been brought about, which specifically provide, my lords, that there shall be limit that with regard to delegation, so that it is a controlled delegation with regard to guidance on how, my lords. So, the limits that we have levied, in that has been specified by the legislature is a maximum limit. Within that limit, what the municipal corporation decides to levy in terms of, my lords, the charging section itself under 142, it is a decision of the municipal corporation. Now, my lords, for the last few years, there is no elected body there. What administrator has been, my lords, functioning? That is a different aspect of the
different aspect. See, instead of using the word chief commissioner,
please, my lords,
if the word corporation was used,
please, my lords,
it would be in consonance with section 142.
If my lords are referring
that
to
is the argument.
Lords, if my lords are referring to 240A or 3, my lords, 240A, we have section subsection 2 and 3. Subsection 2 says the chief commissioner while fixing the rates. So
correct.
It is only
in all those provisions.
Please, my lords.
Instead of empowering the chief commissioner,
please, my lords,
if the word corporation was used,
please,
it would be in consonance with one section, section 142.
Please.
There would be no difficulty to say that ultimately the council would discuss all these aspects on the floor,
please,
of the council, and then a decision would be taken, recommendations would be made to the government.
Please.
Accordingly, provisions could be amended and rates could be fixed.
Please.
Now, instead of doing that, you have given the power to the chief commissioner, and you still want to say, no, ultimately, whatever the recommendation, it is ultimately the state government which will take a decision.
No, I'm not saying that. What I'm saying, my lords, is state government, my lords, has power to make law. entitling, my lords, the corporation
Correct.
to take tax in accordance with that law. When the law has been made, 142 says it's the corporation, my lords, which is entitled to impose the taxes.
Correct.
142 is covered under chapter 13, which talks about taxes, fees and duties. Now, my lords, insofar as chapter 16 is concerned, it concerns only with regard to building, regulation of buildings. And there, my lords, this fee comes into play. Because in other chapters, my lords, the other fees will come into play. Now, here, insofar as 240 is concerned, my respectful submission is, if it is read in a literal sense that it is the chief commissioner, without reference, my lords, to 142, and therefore, my lords, if it is, if the court comes to a conclusion that it has to be struck down only for that reason, my respectful submission is in that the Bombay High Court has interpreted the similar provisions, and my lords has read it harmoniously, 142, 240, and said that it is the power of the chief commissioner is subject to what the municipal corporation says.
Illa, barodilla hange.
Lords, that is how it is. That is the last paragraph. Please.
See, as you said, this chapter 16.
Please.
Is regarding regulation of buildings.
Regulation of buildings. Part of the regulation of buildings is giving a plan.
Correct.
And in that process, my lord, there is some fee that comes into play. Now, but the main chapter 13 is now titled taxes, fees, levy, charge and demand. That apart from taxes. Now that is actually the charging section.
Correct.
So 142, my lords, 240A has to be interpreted, my lords, with reference to 142. 142, my lords, is a main provision. The provision which empowers the levy of taxes. This is, if my lords may see the short title also, we use the word, my lords, levy of imposed restrictions and conditions.
Actually, see in subsection 1 of 240A.
Please, my lord.
There is nothing.
Please. It's only he grants permission because he is the executive.
For the plan.
He is entitled to do.
Suddenly in subsection 2.
Please, my lords.
The word used is chief commissioner while fixing the rates.
Please, we use the word while fixing the rates, my lords. This fixing of the rates, I'm told insofar as practically is concerned, without, I understand, my lords, we use the word the chief commissioner while fixing the rates. It's the statutory language. Then, my lords, in 142, it is.
If this is not the charging section.
Please, my lords.
If this is not the charging section.
Please, my lords.
Insofar as fee.
Please.
Payable on an application for.
240 is the charging. 240 is the charging section.
There.
Lords, the 3, my lords. 3. The chief commissioner may, while approving or sanctioning the plan or grant of commencement certificate or completion certificate, charge and levy the following fees. So the chief commissioner, when he says charge and levy, he's only charging in terms of the rates that is fixed by the corporation under 142. So 240A subsection 2, my lords, has to be read harmoniously instead of striking it down, or it may be read down is the submission that we are making.
One 142 ಏನೋ amendment ತಂದಿರಲ್ಲ ಈಗ.
Please,
142 also.
142 also.
Our charging section.
Earlier it was only taxes, my lords. Now we have made it taxes. Chapter itself has been renamed. ಆಮೇಲೆ 140 subsection 1 ನಲ್ಲಿ we have used the words after taxes at rates.
The words taxes at rates, taxes P, so and so. B.
Minutes, kindly see, taxes at rates, it says taxes, fees, levy, charge, demand, or by whatever name it may be called at such rates. So the rates, minutes, are by the corporation at such rates. Now, insofar as the further power, my lords, in 240A3, we have now given the limits. With regard to, so maximum shall be so much of the guidance value, but it is the power to decide the rate below that maximum limit is vested in the corporation. So 243A subsection 2 lords, in the scheme of things, actually 243(1), and then we have to go to 3. Maybe 2, my lords, might be an offending section.
Yes.
So instead of striking it down,
Yes.
so it says the chief commissioner while fixing the rates antare. So the rates for levy of fee or penalty shall consider all the costs related to the issue and execution of the approval of the plans. So the data he has to collect with regard to everything, and then while fixing the rates, but the fixing, my lords, has to be read harmoniously with regard to the municipal corporation under 142 itself. The only way, my lords, is he puts it to the corporation, all this information. It is not he who fixes the rates. 240A2 has to be my lords, declared that it has to be read in harmoniously with 142, and that it is the corporation who fixes the tax. Maybe the chief commissioner, my lords, shall take into consideration the cost related to the issue and execution of the approval, and then place it before the.
All the data, information that would be required
Please,
to take a decision.
Please.
Can be given by the chief commissioner, placed before the council.
And additionally, we have said, instead of leaving it to the corporation in 240A3, the limits, earlier there was no limit. We had stated charge and levy the following fee at such rates based on the guidance value. ಈಗ we have that A is there, but what we have said is, for each of the fees, earlier it was only fee for issuance of license. We left it unguided. Now we have, my lords, given guidance that fee for issuance of license at such rate not exceeding 0.30% of the guidance value. So again, my lords, it is vested in the corporation. Power is vested in the municipal corporation. So it has to be read in that manner. And based on that, my lords, the demand and levy has to go ahead.
Let us see.
So therefore, my lords, if interpreted in this manner, and this is how, my lords, it is going to be workable. Otherwise, my lords, the chief commissioner, my lords, cannot decide on the rates technically.
Because that is why they are arguing.
Please.
It should be the corporation, not the chief commissioner.
My lords, it is always the corporation, because in the earlier, I just verified, when the earlier circulars were issued, it is the commissioner who issued the circulars. But then when the body was not there, it is with the approval of the administrator. If the body was there, it was with the approval of the body. Without that, he is the chief executive, my lords, who places everything, who runs the entire show with regard to how the.
Or when you are making a law.
Please, my lords.
You should have taken into consideration that all powers of taking such decisions is vested with the corporation.
Please.
And not on an executive. So instead of using the word chief commissioner, you could have used the word corporation.
In 2 itself, my lords, we could have used 240A2 itself, it could have been used. But even, my lords, now I had to
They
just.
could not have raised any objection.
No, my lords, I have to defend it as it is.
See, what they are saying is, as we have discussed earlier,
Please.
and what you read out now from the judgment of the Bombay, the entire development of the constitution, especially in respect of the local self-governments, is this. And now it has extended to cooperative societies. So many things like that.
Please.
So as far as possible, decentralize the powers so that it can be exercisable by the people themselves. Let them decide what they want to have. So if you had said, all right, the corporation will take such a decision, then they also could not have any grievance, because ultimately they would have at least been satisfied. All right, let us take care of it when it comes to discussion before on the floor of the council. But now it doesn't look like that.
Insofar as the levies that were already being made, now that it has been given retrospective effect, now, my lords, from the time when these circulars were issued, it was the administrator, my lords, who was.
And even if you are saying,
please,
the limits are fixed.
Please.
It is still a discretion of the chief commissioner to actually fix the rate between so and so 2 points. He is going to decide what it should be.
No, no, my lords, it is a corporation because he is, my lords, a section, a law pertaining to taxation, my lords, has the rates is one aspect of the matter. My lords, the mechanism, my lords, of how the charging section will operate and how, my lords, it is to be levied and collected is the second. So if 240A3 is seen, it is the word that is used is levy. So he is only levying what is already there, but the limit is provided therein. Maybe the limit could have also been stated, my lords, in 142 itself.
That is what it is.
But since it was a separate chapter,
It's come in a separate chapter
please, my lords.
and powers are vested with the chief commissioner
Sir, the what,
to even fix the rate.
let's if
Charging, it says charge and levy.
let's I get it, lords. 240 let's charging insofar as charge and levy the following fee at such rates based on the guidance value. Lords, the rates, my lords, will again have to be, that's what, my lords, if you read it independently of 142, that is the impression, my lords, that it will give. But if it is read in conjunction with 142 and the context of the scheme of the act and the chapter on municipalities in the constitution, my lords, and how the Bombay High Court has interpreted, that would be the harmonious construction is my respectful submission. And so therefore, their apprehension, my lords, is allied is my. No, my lords, I'll just conclude.
Which was the other aspect?
My lords, the other aspect that they raised was with regard to, my lords, double taxation. My lords, there is one judgment of the Supreme Court. Mohit Minerals. That's Mohit Minerals case, 2019 to SEC. That's para 61. This was a case where there was already a GST and additional, my lords, cess was introduced on that. Para 61 minutes. Issue number 4 minutes. Whether the levy of compensation to state cess and GST on the same taxing event is permissible in law. The petitioner elaborating his contention submits that as per Section 8 of the imputed legislation, there should be levied a cess on intrastate supply of goods and services as provided in Section 9 of the CGST Act, whereas CGST Act has been enacted to levy tax as provided under Article 246A of the Constitution. This is also true in respect of the cesses imposed on interstate supplies of goods and services covered by Section 5 of the IGST Act. Therefore, on the very same transaction, there cannot be two levies, one under the CGST Act and another under impugned legislation, as it would amount to double taxation, as levy is on the same taxable event and the same subject. Thus, there is an overlapping on law, which is not permissible. The petitioner contends that goods and services tax being already imposed by 3 enactments of 2017 as noticed above, imposition of states compensation cess is levied on the same taxing event and has overlapping effect. The principle is well settled. The two taxes imposed, which are separate and distinct imposed, and on two different aspects of a transaction are permissible, as in law there is no overlapping. A constitution bench of this court in Federation of Hotel and Restaurant Association of India versus Union of India has held that a law with respect to a subject might incidentally affect another subject in some way, but that is not the same thing. There might be overlapping, but the overlapping must be in law. The fact that there is an overlapping does not detract from the distinctiveness of the aspects. Therefore, if the taxes are separate and distinct imposed and levied on different aspects, then there is no overlapping in law. Then, my lords, I'll skip that extracted portion. Then para 66 minutes. It's para 64. Krishna here so and so laid down that it is if on the same subject matter the legislature chooses to levy tax twice there is no inherent invalidity in the physical adventure unless there is some other prohibitions. In the above case, the government of Punjab had issued a notification under Section 94 of the Punjab Municipal Corporation Act 1976 imposing tax at the rate of ₹1 per bottle on Indian made foreign liquor within the Municipal Corporation of Ludhiana. One of the contentions raised was tax imposed is on sale, hence beyond the government power. In para 4, following was laid down. A feeble plea that the tax is bad because of the wise of double taxation and is unreasonable because there are heavy prior levies was also voiced. Some of this contention hardly made consideration, but have been mentioned out of courtesy to counsel. The last one, for instance, deserves the least attention. There is nothing in Article 265 of the Constitution from which one can spin out of the constitutional wise called double taxation. Bad economics may be good law and vice versa. Dealing with somewhat similar argument, the Bombay High Court gave short so-and-so to it in Western Indian theatres. Some undeserving contentions die hard, rather survive after death. The only so-and-so we may inscribe is rest in peace and don't be reborn. If on the same subject matter the legislature chooses to levy tax twice over, there is no inherent invalidity in the fiscal adventure, save where other prohibitions exist. Goods and services tax imposed under the 2017 Acts as noticed above, and levy of such on such intrastate supply of goods and services or both as provided under Section 9 of the CGST Act, and such supply of goods and services or both as part of Section 5 of the IGST Act is thus two distinct imposed in law and are not prohibited by any law so as to declare it invalid. We thus do not find any substance in the submission that levy of compensation to state cess on the same taxable event is not permissible. Let's, insofar as taxing laws is concerned, I'll just give an example, notes. Suppose we buy a car. When we buy a car, lots, the ex-showroom price will also include the GST. The ex-showroom price of the car will also include the GST on that, and other lots, there is one other compensation tax also that is levied on that. On the entire component, lots, again there is a stamp duty that is levied. On the entire component, a registration, on the entire component, road tax is levied. The ex-showroom price consists of not only the price that goes to the manufacturer, it also includes the taxes. So there is tax on another tax, road tax. Here in this case, what happens is when the transaction is with regard to building license, 5 different stages: scrutiny fee, license fee, and then occupancy certificate, commencement certificate, occupancy certificate. So it is at different stages. So therefore, it seems to be well settled principle that with regard to levies is concerned, as long as the legislature, there is a proper charging section and there is a proper section which provides for a levy, then double taxation principle cannot be adopted. Here it is not a case of double taxation. It's at different stages and for different components because it is a fee and it is related to a service technically. The other argument yesterday, after I pitched in the argument with regard to legislation by reference, insofar as the Stamp Act was concerned, I think Shamit pointed out that the concept of primary legislation and secondary legislation. With regard to primary and secondary legislation, we have the Municipal Corporations Act, it refers to that. They are both legislations, as long as there is legislative competence, there is no question of primary and secondary legislation. I don't know how they develop that argument. Maybe in the reply they will develop it. But I don't see any basis for that argument. That a secondary legislation cannot be referred to in a primary legislation. That seems to be the argument.
Yes.
But with all due respect, it is like this. There is the Stamp Act is there. It is a distinct act, and it is under the separate enabling provision, under the concurrent list, we do that.
Cited some judgment on that. You note ಮಾಡ್ಕೊಂಡಿಲ್ಲಮ್ಮ?
No, my colleague has noted. Shamit arguments there.
No, it was not in this context.
Please, Manoj.
240A, 3AC, nodi.
Not in the context of the Stamp Act.
It is in the context of zoning regulation. ಈಗ ಹೊಸ ಪ್ರಾವಿಷನ್ ಅಲ್ಲಿ
I think it refers to security deposit minutes. 240A, 3C minutes.
3C.
Please minutes, that is security deposit.
Security deposit as specified in the zonal regulation.
For ensuring that the construction.
For ensuring that the construction is in accordance with the plan sanctioned.
Please. Lords, zonal regulations have been framed, Lords, it is part of the master plan itself. It is part of the master plan, it is done under the KTCP Act. There it provides, Lords, it is refundable itself. Here it is not provided, but since we have used, referred to zoning regulation itself, zoning regulation itself provides that it shall be refundable.
Allah,
So-
refundable Allah.
Please.
The argument was, you are taking shelter under a secondary legislation, that is zoning regulation.
Please, Lords,
Is not a statute by itself.
please.
Is not a law by itself.
It is a master plan, it is part of the master plan, which is under the KTCP Act.
ಹೌದು. So, in a primary legislation like this,
Please, Lords,
section 240A,
please.
you are basing it on a secondary legislation. That is the argument.
No, Lords, what happens is under the, insofar as this argument is concerned, if it is refundable in any which way because it's a security deposit, since they were, insofar as refundability, my lords, we have stated in the statement of objections also, zoning regulations, BBMP will point out, my lords, that even in the zoning regulations, it specifically says it's a refundable security deposit for the purpose of ensuring that the construction is in accordance with the plan. The moment you do it in accordance with the plan, it goes back. So therefore, my lords, it might not have much bearing, my lords, the argument on this insofar as, because it's refundable any which way. And once it is refundable, I don't think they will have any grievance, my lords, with regard to that.
All right.
Lords, I had not read a few judgments. I can just pass on with the paragraph numbers with regard to fees. I'll just, idu kodu, Agriculture Market Committee and State of UP.
ನಿಮ್ದು ನಿಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಗಳನ್ನೆಲ್ಲ ಒಂದು ಕಂಪೈಲೇಷನ್ ಮಾಡಿ
Please, my lords. With
ಬ್ರೀಫ್ ಹೆಡ್ಡಿಂಗ್
brief heading, please.
ಆನ್ ವಾಟ್ ಕಾಂಟೆಕ್ಸ್ಟ್
And the paragraph numbers.
ಅದನ್ನ ಮಾಡ್ಕೊಟ್ಬಿಟ್ರೆ ಅನುಕೂಲ ಆಗುತ್ತೆ.
Please, my lords, I'll do that.
Otherwise I'll have to keep searching
Please, my lords.
everywhere.
Ours we have spiral binded marks.
Lords, insofar as the other copies will supply, my lords. There is one judgment, that 9-judge bench judgment, my lords, which I had not read. I had in fact passed it on. I'll make it part of the compilation, my lords, and refer to it. Since it's bulky judgment, can we take it back? The rest of the judgments, my lord, have marked it, my lords.
You
It
can
can
take
be
it
there.
back.
I'll take it.
You can take it back and
And give it in a compilation. Maybe tomorrow itself I'll pass it on.
in what context it was.
Lords, there it says, what is impost andre, it includes a tax, fee, duty, everything. And just the general theory, basically the precedents on the basis of Shirurmat and McDowell's, which are, my lords have, I think, read and reread it now,
Yes.
have just been culled out. That was in the context, my lords, whether states have the power to levy tax, my lords, on mineral development. When it is a central legislation, MMDR Act is covered by that. So finally, my lords, by a majority of 8-1, my lords, Supreme Court has held that the states have the power.
That recent judgment.
That recent judgment of the 9-judge bench. But in that, my lords, I'm only relying not in the context of this, but in the context of what is the basic jurisprudence with regard to a few paragraphs with regard to what is a tax, what is a levy, what is a impost. And impost will cover a fee as well as a duty, as well as a cess and all these things. Only for that paragraph, please. My lords, one submission, just one submission with regard to ground rent. I am informed, the BBMP will bring it to my lord's notice. Insofar as there are central government guidelines with regard to, my lords, collection of construction and demolition waste. So on that basis, my lords, I'm informed that if it is a smaller site, the construction, the disposal, my lords, of construction and demolition waste has to be done in a particular manner. And for that, services are being provided by the BBMP itself, where, my lords, they will collect and take it there, and then, my lords, it has to be disposed in a particular manner in terms of the central.
That's why they are saying,
Please, my lords.
If that is the case, there is no difficulty.
That is the case.
If they are saying, no, if they are saying, we are going to prescribe a fee for collection of the building debris for its disposal in accordance with law, we have no difficulty.
Please.
That is not the purpose for which the ground rent is being collected.
Now in the expanded
Ground
definition,
rent is collected for usage of the
Infrastructure.
property belonging to the BBMP.
that is the payments on footpaths that is.
There.
How
That
that
the,
is-
this is done. Now
Clarify-
we have given an expanded definition.
Yeah.
Now the BBMP will clarify and
infrastructure.
also my lords how the levy, the service is translated into that. I just mentioning to my lords, they will bring it to my lords notice. There is a separate, there is a central guidelines itself. And there is a construction and demolition waste management rules of 2016, which provide my lords how it has to be done in the, and especially in cities like Bangalore. We are told that insofar as the smaller sites is concerned, because they cannot dump, they have to dump it, they can't dump it inside the construction area because they don't have a place. Because as a matter of practicality, I think all of us know, because we have seen how constructions are going on, lots. They dump it lots on the footpath, but it is the municipality corporation itself which actually transports it to 4 designated locations. But in respect of heavier, larger constructions are concerned, since they have place to store that, they will store it for some time, and once and for all it is collected and it is deposited at that place, and there it is used for the purpose of disposal. It has to be properly disposed. That services is being provided by the BBMP. Is what I'm-
correct ಆಗಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ರೆ,
Please,
if there was clarity
in the
that it is being levied
please,
for this purpose, which means they are ready to pay, because anyway you are going to collect it and dispose it off, and one headache is gone for them.
Please.
But if it is not made clear, chances are that again charges will be collected. That is what they are saying.
No, no, what is happening?
If you had made it very clear, yes, we are collecting it for this purpose.
Please.
For disposal of the building debris, no difficulty. By not clarifying that one, chances are that here in the form of collection of fees for
New market.
ಇದು sanction plan, you are collecting it.
And then
But ultimately, when they go and bring their debris for dumping it in a
designated place.
designated area,
Please.
if again the charges are collected,
Plus, I'm informed that there is a law in this. Guidelines are also there. They are in the process of implementing it. So that is the status. Maybe their argument is based on a previous experience of how they have been going on the construction.
yes.
So if this mechanism is provided,
Ah.
maybe my lords may take that into consideration. Please.
All right. Tomorrow. Yes.
Submission.
Let's tomorrow 2:30.
That serial number 50, my lords, there is a.
Grateful.
It has to 25 lakhs TD I'm carrying from past 3 months now.
Huh?
Kindly, tomorrow, my lords, because I'm unable to, because 50 lakhs, it was, the matter was stayed, my lord, subject to condition paying 50 lakhs, my lord. 25 lakhs, the party, petitioner is ready with paying 25 lakhs, but I'm unable to, it is not reaching.
Paying to whom?
No, to before the lower court for the JDR, my lord.
Then you should have gone and deposited there.
But my, there is a condition for me to pay 50 lakhs, my lord. The lower court is not accepting because it is only 25 lakhs. I need another one for extension of time. I filed an IA, my lord. From past 3 months, I'm waiting, my lord. This is the 4th time it is coming with your lordship, my lord. It is not.
Do, sir.
At least kindly have it tomorrow, my lord, please. Otherwise, it really gets expired, my lord. It is a waste of 16,000 rupees.
I do not, serial number 50.
50, my lord.
Day after tomorrow for orders.
Much of. The serial number 50. The serial number 50. Day after tomorrow.
Orders.
For orders.
Orders ಅಲ್ಲಿ ಬರುತ್ತೆ ಅದು. ರಿಮೈಂಡ್ ಮಾಡಿ ಅವಾಗ ಬಂದಾಗ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಸರ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್.
Interim order from it.
Interim order holds good as it is.
Continue.
We'll continue.
Sir, next week, is it?
Next week.
Serial number 48 reach ಆಗಿಲ್ಲ ಅಲ್ಲ? Serial number 48.
ಆಯ್ತು, ರೀಚ್ ಆಯ್ತಲ್ಲ. ಡಿಲಿಂಕ್ ಮಾಡಕ್ ಹೇಳಿದ್ರಲ್ಲ. ಡಿಲಿಂಕ್ ಆಗಿದೆ ಅದು.
ಸಾರಿ ಸರ್,
ಆಯ್ತಮ್ಮ, ಅರ್ಜುನ್ ಆಗಿದೆ.
ಯಾವಾಗ ಚೆನ್ನಾಗಿದೆ? ಡೇಟ್ ಏನಾದ್ರು ಗೊತ್ತಿಲ್ಲ.
ಆಗತ್ತೆ. ಆಗಲ್ವಾ?
ಸರ್. ಸರ್.
ಹಾ.
ಇದು ಇದ್ರನ್ನ.
ಹೇಳಿ ಸರ್, ಹೇಳಿದ್ರೆ ತಾನೇ ಗೊತ್ತಾಗಲ್ಲ.
ಬಟ್ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಇರುತ್ತಾ? ಓ ಹೌದಾ ಸರ್?
ಸರ್, ಆನ್ಲೈನ್ ಅಲ್ಲಿ ಇದೆಲ್ಲ ನೋಡ್ಬೇಕು. ಇದು ಡೇ ಟು ಡೇ ಆರ್ಡರ್ ಏನಿದೆ ಅದು ನೋಡ್ಬೇಕು. ಇದು ಓನ್ಲಿ ಫಾರ್ ರೆಫರೆನ್ಸ್ ಅಷ್ಟೇ. ಈಗ ಏನಾಗಿದೆ ಕೋರ್ಟ್ಗೆ ಅಂತ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಏನಿದೆ ದಟ್ ಹೋಲ್ಡ್ಸ್ ಗುಡ್. ಸಾಹೇಬ್ ಡಿಕ್ಟೇಷನ್ ವೆನ್ ಒನ್ ಕೋರ್ಟ್ ಹಿಯರ್ಸ್ ಓನ್ಲಿ ದೆನ್ ಟು ಸಿ ದಟ್ ಡೇ ಟು ಡೇ ಇದೆಲ್ಲ ನೋಡ್ಬೇಕು.
ಟಿಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಅಂತ ಇರುತ್ತೆ.
ಅದೇ ಸರ್ ಬರ್ತಾ ಇದೆ ಈ ಇಯರ್ದಲ್ಲ ಸರ್, ಅದು ಡೇ ಟು ಡೇ ಆರ್ಡರ್ ಬರ್ತಲ್ಲ, ನೀವು ಓಪನ್ ಮಾಡ್ತಿರಲ್ಲ ಅದೆಲ್ಲ ಇರುತ್ತೆ. ನೀವು ಇದು ನೋಡ್ಬಾರ್ದು, ಡೈಲಿ ಆರ್ಡರ್ಸ್.
ಡೈಲಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರಲ್ಲ ಅಂತ.
ಅದು ಬರುತ್ತೆ ನೋಡಿ ಸರ್, ಅದಲ್ಲ ಡೇ ಟು ಡೇ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರುತ್ತಲ್ವನ್ರಿ ಇದು?
ಬರ್ತಾ ಇಲ್ಲ, ಡೈಲಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಬರ್ತಾ ಇಲ್ಲ.
ಹಾ, ಅದು ತಗೊಳಂಗಿಲ್ಲ ಸರ್ ನೀವು. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಏನಿದೆ ಅದನ್ನೇ ತಗೊಂಡು ಇಯರ್ ಮಾಡಿದ್ ಮಾತ್ರ ತಗೊಂಡ್ ಅಷ್ಟೇ. ಅದು ನಾವು ಅದನ್ನೇ ಹೇಳ್ತಾರೆ ಸಾಹೇಬ್ರು. ಅದ್ ಕನ್ಸಿಡ್ 2 ಬರ್ತಾ ಇದೆ, ನಿಮ್ಗೆ ಗೊತ್ತಾಗ್ತಾ ಇದೆ ನಮ್ಗೆ. ಒಂದು ಕೋರ್ಟಲ್ಲಿ ಏನಾಗ್ತಿದೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಡೇಟ್ ಕೊಡ್ತಾ ಇರೋದು ಅದು ಬರ್ತಾ ಇರುತ್ತೆ. ಹಾ, ಡೈಲಿ. ಬಟ್ ಡೇ ಟು ಡೇ ಆರ್ಡರ್ಸ್ ಅಂತ ಏನಿದೆ, ಆರ್ಡರ್ ಡಿಕ್ಟೇಷನ್ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ ಅದು ಬಂದಿರುತ್ತಲ್ಲ. ಈಗ ಲೋಯರ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಂಗೆ ಆರ್ಡರ್ಸ್ ಬಂದಿರುತ್ತೆ ಅದೇ ತರ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಇದೆಯಲ್ಲ, ಅದನ್ನ ತೆಗೆದು ನೋಡ್ಬೇಕು ನೀವು. ಅದರಲ್ಲೇ ಅದು ದಟ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಲ್ಲಿ ಕೊಡೋದು. ನೀವು ಡೇ ಟು ಡೇ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ಬರೀ ಅಡ್ಜರ್ನ್ಡ್ ಡೇಟ್ ಅಷ್ಟೇ ಸಿಗುತ್ತೆ. ಇಂಟ್ರಿ ಆರ್ಡರ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಎಲ್ಲೂ ಸಿಗಲ್ವಲ್ಲ ಅದರಲ್ಲಿ.
ಯೂಶುವಲಿ ಸಿಗುತ್ತೆ ಸರ್, ಒಂದೇ ಇರೋದು.
ಹಾ, ಅದ್ ಕೊಡೋದಿಲ್ಲ.
ಒಂದೇ ವೆಬ್ಸೈಟ್ ಡೈಲಿ ಆರ್ಡರ್ಸ್ ಅಂತ ಇದೆ, ಸ್ಟೇಟಸ್ ಕೂಡಲೇ.
ಅದೇ ಸರ್, ಅದನ್ನು ನೋಡಂಗಿಲ್ಲ ಸರ್. ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್ ಏನಿದೆ ಅದು